My lords, with your lordship.
Yes, yes. ಆಯ್ತು ಕೊಡಿ.
My lords,
ಹೌದು ಕೊಡಿ ಮೇಡಮ್.
with your
ಒಂದು ನಿಮಿಷ,
lordship.
ಅದೇನು 11 o'clock ಮೀಟಿಂಗ್ ಅಂತ ವೆಯ್ಟ್. ಮೆಮೊಗಳೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. 2:30 ಇರೋದು ಮಾತ್ರ ವೆಯ್ಟ್ ಮಾಡಿ, ಬೇರೆದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಫೈಲ್ ಇದೆ. ದ ಪೆಟಿಷನರ್. Now you tell me this Suraj Govindraj ಅವ್ರ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, ಅದರಲ್ಲಿ ರಿಸಲ್ಟ್ ಇಲ್ಲ ಇದೆ. All right, now what is the problem again? There is no vacancy. I am the director. The petitioner number 1 is a member of the union and he is the director and he is representing the president now. There is no vacancy, madam. Now they have issued a notice. How do you demonstrate that there is no vacancy? In the page number 24, it is referred that 24. 24 into that. There is an interim order by this honorable court. In earlier occasion also, they have issued a notice. Which interim order, madam? There is page number 36, annexure. Annexure 3, madam. Earlier to this also, madam, they have issued a notice to elect for the election of the president, and this honorable court granted an interim order. Then, madam, the respondent number 3 sought for clarification regarding this to the JRCS, madam. Respondent number 4. JRCS has made a communication on annexure 3. Directed the respondent number 3 stating that, madam, page number 49, annexure B. ಸಂಬಂಧಿಸಿದಂತೆ ಗೌರವಾನ್ವಿತ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಾಪಾಡಿನಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಘೋಷಿಸಲು ಸಂಬಂಧಿಸಿದಂತೆ ಆಕ್ಷೇಪಣಾ ಬೇಡಿಕೆ ಸಲ್ಲಿಸಿ ತಡೆಯಾಜ್ಞೆಯನ್ನು ತೆರವುಗೊಳಿಸಲು ಅವಶ್ಯ ಕ್ರಮವಿಟ್ಟು ತಡೆಯಾಜ್ಞೆ ತೆರವುಗೊಂಡ ನಂತರ ಧಾರವಾಡ, ಗದಗ ಮತ್ತು ಉತ್ತರ ಕನ್ನಡ ಜಿಲ್ಲಾ ಸಹಕಾರ ಹಾಲು ಉತ್ಪಾದಕ ಸಂಘಗಳ ಒಕ್ಕೂಟ ನಿಯಮಿತ ಧಾರವಾಡ ಜಿಲ್ಲೆಯ ಧಾರವಾಡ ಅಳ್ನಾವರ ನವಲಗುಂದ ಮತ್ತು ಅಣ್ಣಿಗೇರಿ ಮತಕ್ಷೇತ್ರದ ನಿರ್ದೇಶಕರ ಸ್ಥಾನದ ಮತ್ತು ಒಕ್ಕೂಟದ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆಗೆ ಕ್ರಮವಿಡಲು ತಿಳಿಸಲಾಗಿದೆ. Even in the interim order also, my lord, this honorable court has given a direction, given a liberty to move for vacating interim order. Till date, they have not filed any objection. That petition is pending. Yes, madam. Still it is pending. Interim order is pending.
Please, we'll make submission. Let the second petitioner.
Urgency ಏನು?
ಇಲ್ಲ ಒಂದು ನಿಮಿಷ. Second petitioner is a representative and delegate of the first petitioner society to the third respondent society. The election to the first petitioner society was held in the month of December.
Where is the vacancy?
Please, one submission. There was no election. The tenure of the second petitioner to the primary society is expired in the month of December 31st of 2024. Now the election result was declared in the month of October 2025. From the date of 1st January to 10th, October 1st, there was no election to this society. Section 18B mandates that, if the director ceased to be the member of primary society by operation of law of section 18B, he ceased to be the director of the either secondary society or apex society. So this is a case, He is already disqualified, second petitioner is already disqualified by operation of law of section 18B. Kindly take the 18B, my lord, for the moment.
Madam.
And the constitutional validity of the 18B was being questioned before this honorable court, my lord. This honorable court upheld the constitutional validity that was confirmed by honorable Supreme Court. So now, my lord, 18B, by virtue that, my lord, his tenure is expired in the December 2024, my lord. After the expiry of the tenure, by operation of law, he ceases to be the director of the secondary society. So
No,
the
this is, now you are co-opting other.
co-opting the other persons because he ceases to be the director in the month of December itself, my lord.
All right, we'll consider.
Please, the 18B, my lord, for the moment, my lord.
ಈಗ 11 ಗಂಟೆಗೆ ಏನಿದೆ?
ಈಗ
Please, now they have issued a notice to co-opt the person in respect of the
So,
member
hold your
society.
hands till
Member
Friday.
society.
please,
File your objections, hold your hands till Friday.
please,
All right?
please,
I'll take this on Friday.
please.
Heard the learned counsel Srimati Vidyavati Kotur Shettar appearing for the petition and learned additional advocate general, is Gangadhar. The petitioner is before this court. The subject petition was moved on a Sunday to be listed today, owing to certain urgency in the matter. The learned counsel for the petitioner had projected that a meeting is slated to be held at 11 a.m. today for co-opting a director in the teeth of the presence of the second petitioner, a director of the society. The learned counsel for the petitioner submits that the impugned order projects that there is the new a director should be co-opted is contrary to the facts. There is no vacancy is her emphatic submission. The learned additional advocate general, taking this court through section 18B of the Cooperative Societies Act 1909, would contend that by operation of law, i.e. section 18B, the second petitioner ceases to be a director and he has ceased to be a director with effect from
1st January 2020.
1st January 2025. And therefore, the co-option has to happen as there cannot be a vacuum.
Please.
The matter would require consideration. The learned counsel submits that at 11 o'clock, the meeting is, as observed here and above, the meeting is to be held at 11 o'clock. I therefore direct the state to hold, state to hold its hands.
Not
till-
state, my lord.
Respondent
Society.
number 3.
Third respondent
Number?
society.
3,
Third
my-
respondent society.
Point number 3, to hold its hands and not to hold the meeting or co-opt the director till the next date of hearing. List the matter on 7th at
May I request it on
One
Wednesday? Reason is that,
clarification.
my lord, reason is that now the election is.
One
scheduled-
submission,
Now
my
the
lord.
election is scheduled to the third respondent society. Third respondent society is required to be send its delegation to the apex society.
like, 3 days, nothing is, heavens are not going to fall.
Please, my
We'll take
lord.
it on
Your
Thursday.
lordship, in the impugned order, my lord, they have not mentioning the petitioner number 2. Petitioner number 1, my lord. Matakshetra. It is a society's representative.
We'll take it on Thursday. List on Thursday, objections be filed by then, if the state would so desire.
Please.
Yes.
Hand delivery, my lord.
ಇಲ್ಲೇ
I will
ಇದಾರಲ್ಲ.
inform, I will inform, I will inform.
So if they precipitate, then you move, tell me at 2:30.
I will inform, my lord. I
We
will
will see how they will do that.
I will inform.
Yes.
Grateful.
Time constraint ಅಲ್ಲಿ don't.
I will inform, I will inform,
Gangadhar will do it.
I will inform,
Once he says he will do it.
I will
he do
inform.
it.
Notice
I have
to-
that confidence.
Notice to respondent number 3.
Emergent, sorry, the respondents, other respondents.
Arvind
we
D.
serve
Arvind D. Kulkarni.
Only respondent number 3. Other 1 and 2 is the government.
3 is
and
Arvind D.
to
Kulkarni.
1 and 2 state. 3, Arvind D. Kulkarni is directed to accept notice, petitioner to serve set of papers upon the aforesaid council forthwith.
Please.
For matter for end of the list, my lord.
ಕೊಡಿ ಈಗ ಮೆಮೋಸ್ ಕೊಡಿ ಯಾವ್ದಾರು. 2:30 ಏನು?
Please, 230, ಅಂದ್ರೆ the respondent to claiming double maintenance, parallel maintenance.
ಡಬಲ್ ಮೇಂಟೆನೆನ್ಸ್. ಎಲ್ಲಿಂದ?
ಆಂಧ್ರದಲ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ, ಬಳ್ಳಾರಿಯಲ್ಲಿ ಕ್ಲೇಮ್ ಆರ್ಡರ್
ಓ,
ಆಗಿದೆ.
ಇರ್ಲಿ ಬಿಡಿ ಪರವಾಗಿಲ್ಲ.
230 ಮ್ಯಾಟರ್.
ಡಿಪೆಂಡ ನೀವು? ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
6,000 ಮಾಡಿದೆ ಸರ್. ಅಲ್ಲಿ 6,000, ಇಲ್ಲಿ ಅಲ್ಲಿ 10,000 ಮಾಡಿ, ಇಲ್ಲಿ 6,000 ಮಾಡಿದೆ. ಅದಕ್ಕೆ ಮಧ್ಯಾಹ್ನ 230 ಮ್ಯಾಮ್ ಪ್ಲೀಸ್.
ಈಗ ಎಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ರೆ ಎಲ್ಲೂ ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ದುಡ್ಡೇ ಇಲ್ಲ. Please. ಅದಕ್ಕೆ ಒಂದ್ ಯಾವ್ದಾದ್ರು ಡೈರೆಕ್ಷನ್.
ಈಗೇನು ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
ಹ್ಞೂ ಸರ್
ಓ,
ಪ್ಲೀಸ್.
ನಾಡಿದ್ದು ಬರಲಿ ಬಿಡಿ.
ಇಲ್ಲ
ಕೊಡಿ.
230
Get all the arrears.
230 ಮ್ಯಾಟರ್.
ಆಮೇಲೆ ನೋ ಇಂಟೆಲಿಜೆನ್ಸ್ ಫಾರ್ ಹಸ್ಬೆಂಡ್ಸ್ ಹು ಡೋಂಟ್ ಪೇ ಮೇಂಟೆನೆನ್ಸ್. ಆಂಧ್ರಲ್ಲೂ ಕೊಡಲ್ಲ, ಇಲ್ಲೂ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಆಂಧ್ರ ಕೋರ್ಟಲ್ಲಿ ಹೋಗಿ ಹೇಳಿರ್ತೀರಾ, ಕರ್ನಾಟಕದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ.
ಇಲ್ಲ, ನಾವು ಇಲ್ಲನ ಕೊಡ್ತಾ ಇಲ್ಲ ಅನ್ಕೋ, ಯಾವ್ದಾದ್ರು ಒಂದಾದ್ರೆ ಸರ್, ಎರಡು ಕಡೆ ಪ್ಲೀಸ್.
ಈಗ ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
ಸ್ವಾಮಿ
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
ಅರಿಯರ್ಸು 80,000 ಇರ್ಬೇಕು ಸರ್.
80,000ನ?
ಅದಕ್ಕೋಸ್ಕರ.
ಕೆಲಸ ಮಾಡಿ 1 ಲಕ್ಷ ಡಿ ಡಿ ತಗೊಂಡ್ಬಂದ್ಬಿಡಿ.
ಅಲ್ಲಿ ಎರಡು ಕಡೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ.
ಪರವಾಗಿಲ್ಲ, ಅದನ್ನ ನಾನು ಸೆಟ್ ಆಫ್ ಮಾಡೋಣ. 1 ಲಕ್ಷ ಡಿ ತಗೊಂಬನ್ನಿ ಈಗ, ಆಮೇಲೆ ಸ್ಟೇ ಮಾಡ್ತೀನಿ.
230 ಮ್ಯಾಟ್ರ್
ಡಿ ತಂದ್ರೆ 230.
ಇಲ್ಲ, ಅದು ರೆಸ್ಪಾಂಡ್ ಇದು ಕೃಷ್ಣ ರೀಜನ್ ಬಳ್ಳಾರಿ, ಇದು
ಬಳ್ಳಾರಿ
ಬಳ್ಳಾರಿಗೆ ಇದನ್ನ ಆರ್ಡರ್ ಆದ್ರೆ ಡೆಫಿನೆಟ್.
ನಾಳೆ ಆರ್ಡರ್ ಆದ್ರೆ ಅಲ್ಲ, ಆರ್ಡರ್ ಮುಂಚೆ ಬೇಕು.
ಯಾಕಂದ್ರೆ ಅವನು ಬಿಡು ಸರ್.
ನಾಳೆ ತಗೊಂತೀನಿ, 1 ಲಕ್ಷದ ಡಿ ತಗೊಂಬನ್ನಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 10ನೇ ತಾರೀಕು ಕೊಟ್ಬಿಡಿ.
Next week ತಗೊಂತೀನಿ.
10ನೇ ತಾರೀಕು
ತೊಂದ್ರೆನೇ ಇಲ್ಲ.
10 ಅವತ್ತು ಬೇಕಾದ್ರೆ ಇದು
ಹೌದು, ಕರೆಕ್ಟ್.
10.
One matter, demolition notice, my lord, has been issued.
ನೀವು ಹಸ್ಬೆಂಡ್
ಇಲ್ಲ, demolition notice.
Lords, with your lordship's kind permission,
230.
one matter which is at date given by your lordships at 18th, on 18th, my lords. There is urgency, my lords, may be taken up tomorrow. Tender matter, my lords.
ಟೆಂಡರ್
Tender matter,
ನಾಳೆ.
please, for tomorrow. Highly obliged, my lords.
ಎಸ್, ಕಾಲ್ ದಿ ಕೇಸ್.
This
My
one,
lord.
fresh matter, serial number 1.
Serial number 143, my lords.
ಯು ವಾಂಟ್ ಟು ವಿಡ್ರಾ?
My lord, yes, my lord. For
Right.
withdrawal, my lord.
Learned
On
counsel
behalf
for the
of Shri
petitioner
Prasad
seeks
Joshi.
leave of this court to withdraw the subject petition.
My lords,
143. Please.
my lords, serial number 109
Hmm.
is a faceless matter, my lords. Sorry,
Serial number
109, list 109.
109. I've already made a note of it. Yes. Faceless disposed. ವಿಜಯಲಕ್ಷ್ಮಿ ಮೇಡಮ್, ಫೇಸ್ಲೆಸ್ ಅಂತ ಕೇಳಿ ನಾಗವೇಣಿ ಕೊಡ್ತಾರೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಅಲ್ಲಿ ತಿರುಮಲೇಶ್ ಅಲ್ವಾ ಯಾರು?
Tirumale, sir.
ಎಂ ತಿರುಮಲೇಶ್ ಆಕ್ಸೆಪ್ಟ್ಸ್ ನೋಟಿಸ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಮಾಡಿ ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಫೇಸ್ಲೆಸ್ ನಾನೇನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಬ್ಯಾಂಗ್ಳೂರ್ಲಿ, ಅದನ್ನು ಸೇಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Grateful.
Number 1, Reddy Mallikarjun.
Worship, this is
Kindly, my lord. I am part of the petitioner, my lord. Petitioner is the employee of respondent poor, my lord. In special case, he appointed as the librarian.
Yes.
Yes, my lord.
What special case? First time ಬರ್ತಾ ಇರೋದಾ?
Your lordship, in this matter, I have secured a records document, your lordship, wherein he has given in writing, your lordship, I will withdraw the petition.
ಯಾಕೆ ಇವೆಲ್ಲ ಕೊಡ್ತೀರಾ?
No, my lord. The institution post to draw the case, my lord. That's he give the letter.
It is given to the council.
The respondent number 4 has forced to petitioner to withdraw the matter. Otherwise, we will.
It is submitted to the office also, your lordship.
I am not produced before this court, my lord. The respondent for my lord, college principal and chairman.
2023 ಅಲ್ಲಿ
ಹೌದು.
petition ಹಾಕಿರೋದು ಯಾವಾಗ?
ಅಲ್ಲ, ನಾ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಮಾಡ್ಯಾರ ಅದನ್ನ.
ಸರ್, 2021 ಅಲ್ಲಿ ಹಾಕಿರೋ ಪೆಟಿಷನ್ ಅಲ್ಲ,
23, my lord.
ಏನೇ ಹಾಕಿದೆ.
ಏನ್ ಮೇಡಮ್?
Filed on 23/8/21, your lordship. FR number 23.
ಯಾರಿದು?
21 FR number compliance ಆಗಿ
ಹಾ,
registration
ಮತ್ತೆ
number
21 2 ವರ್ಷ ಕಂಪ್ಲೈನ್ಸ್ಗೆ. ಏನ್ ಮ್ಯಾಟ್ರ್?
and this
The
ಅರಿಯರ್ಸ್ ಆಫ್ ಸ್ಯಾಲರಿ.
mandamus.
yes, my lord. I passed the writ of mandamus directed to respondent over one, my lord. Arrears.
ವೈ ಅರಿಯರ್ಸ್? Why?
My lord, they are appointing in to 1999, my lord. So-
ಲೈಬ್ರೇರಿಯನ್.
Yes, my lord.
When did you retire?
After 2020, my lord, the respondent number 1 appointed as a permanent on the special case, my lord.
When?
2020, my lord.
5/3/2020.
5/3/2020, my lord.
5/3/2020.
Yes, my lord.
Where is the appointment order? Regularize ಮಾಡಿದ್ದು?
G, my lord. G, annexure G, my lord.
Sir, annexure G ಅಲ್ಲಿ there is a condition that you will not claim anything. ಹೌದಾ?
Yes, my lord.
ಅರಿಯರ್ಸ್ ಆಫ್ ಸ್ಯಾಲರಿ ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯ್ ಕೊಡಕ್ ಸ್ಪೆಷಲ್ ಕೇಸ್ ಅಂತ ಮಾಡ್ತಾನೆ ಇರಲಿ.
Any benefit, my lord.
ಪೆನ್ಷನ್ಗೆ ಏನೇನು ಬರುತ್ತೆ ಅದು ತಗೊಳ್ಳಿ.
Yes, my lord.
ಮೇಡಮ್,
Please,
ಪೆನ್ಷನ್ ಬೆನಿಫಿಟ್ಸ್ ತಗೊಳ್ಳಿ, ಸ್ಯಾಲರಿ we will not give.
please, your lordship.
Yes, my lord.
As it is mandamus, your lordship, consideration.
That the petitioner is before this court seeking the following prayer. Heard so and so. The petitioner joins the services of the second respondent. Which respondent?
Fourth respondent.
Fourth respondent, aided institution, as a librarian, works about 30 years, is absorbed as or regularized as a librarian as a special case. The petitioner then submits a representation seeking salary of a regular employee from 1990 till the date he was regularized in the year 2020. The order that which regularizes him takes away certain benefits. Notwithstanding the same, a representation comes to be submitted by the petitioner. Though the petitioner may not be entitled to the regular salary of a regular employee, as he was absorbed or regularized in the services of a librarian only as a special case or imposing certain conditions. The petitioner would prima facie become entitled to certain terminal benefits of the service that he has rendered for 30 years. As an employee whose services have been taken for 30 long years cannot be left in the lurch without any terminal benefits that would that he would get he would become entitled to. In that light, I deem it appropriate to direct the respondents to consider the representation so submitted to that effect by the which respondent?
It's
By the
not for my lord, state.
by the state with an outer limit of 12 weeks from the date of receipt of the copy of the order and pass necessary orders in accordance with law. The learned counsel, the learned HCGP would submit that the petitioner has represented to the respondent that he would want to withdraw the petition and not claim arrears of salary or otherwise. The said undertaking so submitted by the petitioner is on the face of it opposed to public policy, as statutory benefits of an employee cannot be permitted to be withdrawn on a representation submitted by him, be it on coercion or otherwise. If the undertaking submitted before the authority that he would withdraw the petition, not claim any terminal benefit, it would, as observed here and above, be an unconscionable undertaking. In that light, the representation of the petitioner should merit consideration on its merit, as observed here and above, ordered accordingly. Yes, next.
Bill number 2, PG Chignargan.
This case, the petitioner sought for the service benefits of unaided period, your lordships. In fact,
Covered already, could you?
covered, your lordships. Day after tomorrow.
Yeah, day after tomorrow.
But I not brought the judgment.
Not but. This act is set aside, it is covered.
But the writ appeals are pending, your lordships.
Sorry, sir. That's Kodi, sir.
I will furnish
If
it.
you don't get another, if you have not got the judgment, take my judgment, dismissed.
Day after tomorrow, your lordships. I will furnish it.
Yes, madam, identical orders passed, madam, Bangalore.
Please, your lordship.
The petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioner is appointed as a lecturer on 8/6/1990 in the discipline of geography by the management. The appointment of the petitioner, the institute at the time when the petitioner was appointed was not admitted to grants at the hands of the state. It comes about on 4/3/2008. The issue is whether the petitioner would be entitled to all service and terminal benefits in terms of the terminal benefits, not for the period between 8/6/1990 to 4/3/2008, is the question that the learned counsel for the petitioner seeks to project. The issue need not detain this court for long or delve deep into the matter, as the act upon which the state is placing reliance upon to deny the terminal benefits has been held to be unconstitutional by this by a coordinate bench of this court, which are against which writ appeals are pending. In the writ appeals, there are certain orders passed that the terminal benefits be granted to these to all these employees, subject to the result of the writ appeal. In the adondu KB Nayak versus Union of India antide adanna kodtini. In the light of the said circumstance, the petitioner becomes entitled to a direction at the hands of this court to the respondent state to consider his case in terms of consideration that has met to all the teachers similarly circumstanced. The representation, representation. Kotilva.
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನಕ್ಕೆ ಬಂದ್ರಿ ಮತ್ತೆ?
Only they are challenging the act, your lordships.
What act is so and so? In the light of the act being held unconstitutional, the petitioner shall now submit a representation seeking those benefits and the state shall consider the same in accordance with law. Law, I mean the order passed by the coordinate bench and the directions issued by the division bench. Ordered accordingly. Representation Kodi first.
Please.
Kotre ಮಾಡಿ.
Please, your lordship.
Number 3, Arti Kulkarni.
Dharwad judgment ಎಲ್ಲ ನೀವು.
My lord, the petitioner is seeking mandamus against the respondents to consider the representation for promotion from the retrospective effect, as his juniors have been considered for that and they were given
Second respondent.
first and second respondent both.
First and agalla.
One second.
State government is there.
State ತಾನೆ?
It is for the commissioner
Petitioner
to.
is before this court seeking the following prayer. The heard so and so. The petitioner is appointed as a bill collector in the second respondent municipality on 29/3/1993. The petitioner claims that he is entitled to be promoted to the cadre of first grade revenue inspector from the date on which his juniors were promoted. The learned counsel for the petitioner takes this court through a seniority list dated 1/1/2007, in which the name of the petitioner does figure over and above the juniors that have been granted promotion to the cadre of first grade revenue inspector. In that light, the petitioner has submitted a representation seeking such promotion as is granted to his juniors to the cadre of first grade revenue inspector. Non-consideration of the said representation has driven him to this court in the subject petition. The learned counsel Girija Hirimat, HCGP, Girija Hirimat, appearing for the respondent state, would submit that if reasonable time is granted, the representation of the petitioner would merit consideration and appropriate orders would be passed in accordance with law. In the light of the said submission, without entering upon the merit of the claim of the petitioner, I deem it appropriate to dispose the petition with a direction to the respondent state to consider the case of the petitioner by considering the representation so submitted within 4 months from the date of receipt of the copy of this order, if not earlier ordered accordingly.
Bill number 4A is Patil.
For petitioners, my lord. My lord, the petitioner were directed to place any protection pay order, my lords. As such, there is no protection pay orders issued to the petitioner.
Pay protection order.
Pay protection orders, my lords. So, however, my lords, the grievance of the petitioner is that.
From where did you come?
My lord, previously I was working in Bhadravati, that paper mills in Bhadravati.
MPM?
Yes,
Mysore paper mills?
Yes, my lords. Thereafter, he has rendered his service for 2 years, 2 months.
Where?
In the paper mills, my lord. And thereafter, he submitted his resignation and he was working with the respondent number 5, my lord.
How did you enter fifth respondent? Notification?
Notification, through notification, my lord.
And application through proper channel?
Through proper channel. My lords, that service records, right now, I don't have, my lords. But the rules.
If you want to if you want to consider it to be a technical resignation under 252 of the KCSR, then you will have to show that you applied through proper channel and while submitting resignation, it was treated as technical resignation.
Please, my lords. One submission, my lords. There is.
Because it is not the same employer. MPM is a different entity.
Sure, my lords. But in the identical circumstances, my lord, regulation 182A, my lords, at annexure B.
Yavudradu? 182A yavudradu?
Karnataka Electricity Board
passed,
employs service regulation, my lord.
Allah. You joined the KPTCL, is it?
Yes, my lord, KPTCL, my lord. Thereafter, the regulation 182A provides, my lord, wherein the
182A says if it is a wing of the government, the resignation only it should be important. Anyway, 182A is interpreted, we'll close it saying that.
And the identical notice has to be ordered.
Notary will. BS Kamte?
Yes, my lord. 1 to 3, my lord.
Learned counsel BS Kamte is directed to accept notice for all the respondents. Petitioner to serve set of papers upon the aforesaid counsel.
My lords, one more submission, my lord.
Regulations on protecting pay.
4 to 5 is.
I have passed some order on 28/8/23.
23, man. Thereafter, the matter could not.
Regulations.
Regulations, pay protection order was there, my lord. So this.
My order in 2023 is not complied still.
There is no pay protection order, but the regulation is regulation 182A.
List the matter on 20th November.
My lord, one more submission. Respond number 4 and 5, Shivraj Mudhol, sir, my lord.
I thought 1 to 3 Kamte, 4 and 5 Shivraj Mudhol, sir.
We'll serve the set of the. Please, my lord.
Next.
Number 5, PG Chiknalur.
This case not be sought for mandamus not directing the respondents to not the refix the pension at not the as per annexure not the A page number 14 your lordships is basic page not 99,600 your lordships, but not the fixed pension at 45,250. Therefore, sought for modifying them not the.
95 ಎಷ್ಟು pension?
Pension about the 42,000, 45,250 has been fixed.
Basic pension ಎಷ್ಟು?
Basic pension about 99,600.
99,000 ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆಯಲ್ಲ 50%. ಏನ್ ತಪ್ಪಿದೆ?
Fix the pension at annexure C.
Last drawn pay ಎಷ್ಟು 99,650. 45,000 ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Please.
ಏನ್ ತಪ್ಪಿದೆ?
ಇಲ್ಲ ಕರೆಕ್ಟ್ 50% ಕಡಿಮೆ ಆಗುತ್ತೆ ಸರ್. 90,500 ಆಗುತ್ತೆ.
ಎಷ್ಟು 99,000 ಹೇಳಿ?
99,000 ಸರ್.
99,000.
99,000
ಫಿಕ್ಸ್ ಮಾಡಿರೋದು ಎಷ್ಟಕ್ಕೆ?
45,250 ಸರ್.
49,800.
49,250 ಅಂದ್ರೆ
ಇಲ್ಲ 45,250 has been not a fixed pension.
ಅದು 49,250 ಆಗ್ಬೇಕು.
ಹೌದು.
As simple as that. Consider. The petitioner is before this court seeking the following prayer. The
modifying that at annexure C.
One minute. ಆಗ್ಲೇ ಪಾಸ್ ಮಾಡಿದಾರೆ ಏನಾದ್ರು ಆರ್ಡರ್ ಇಲ್ಲಲ್ಲ?
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ annexure C ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ you unless you challenge that we will not direct.
Thought for modifying the said order.
Modifying ಆಗಲ್ಲ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು in so far as it fixes erroneously.
Amend the principle.
ಮಾಡಿ.
Please, sir.
List on Thursday.
Please.
Refreshment list. Yes, next.
Bill number 6, Madhusudan PN, Yuvraj is ordered.
My lord, this is a case where excess PF amount has been recovered from the employer. That is why we have.
I'm no longer on the panel of Union of India, my lords. I had informed Mr. Karvi. No.
ಯಾರಿದ್ದಾರೆ?
Mr. Karvi, I had informed him, my lords. Venkatesh Karvi.
Learned Counsel Shivraj Bodali submits that he is no longer a Central Government Council. Registry delete the name of Shivraj Bodali appearing for the respondent. Counsel MB Kanavi is directed to accept notice for respondent 1, 2. Because Grameen Bank ಇದೆ. Because Grameen Bank ಯಾರು appear ಆಗ್ತಾರಲ್ಲ? KVB.
No, this is not yet issued, my lord. Notices are not yet issued.
Emergent notice to the respondents. Sir.
Much obliged.
Yes, sir.
Bill number 7, Shivraj C. Badlaki.
Writ petition, my lord, against beneficiaries. Writ petition against the order passed, my lord, for redetermination of compensation of section 28A. Similar matters, my lord.
Tag this petition along with so and so, same order. ಅಲ್ಲಿ ಯಾರು ನೋಟಿಸ್ ಅಲ್ಲಿ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಾ ಅದ್ರಲ್ಲಿ ಯಾರಿಗೂ?
No, first.
ಇಲ್ಲ ಸರ್, ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ? ಯಾರು? ಜ್ಯೋತಿ ಮುಳಿಮುನಿ ಮೇಡಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸೂರಜ್ ಗೋವಿಂದ್. Stay issue notice.
Yes. Learned Counsel, Learned AGA is directed to accept notice for the respondent. Which respondent?
1 and 2.
1 and 2. ಇನ್ಯಾರಿದ್ದಾರೆ?
3, my lord, notice has to.
3 emergent notice. There shall be an interim. Learned Counsel for the petitioner submits an identical case as an interim order granted by coordinate bench of this court. In that light, there shall be an interim order stay spread for. Next.
Bill number 8, Rajshekar Burji.
I appear the petition. But the petitioners, my lord, are retired associate professors, my lord. They have called in question the order at annexure A, wherein, my lord, the revision of pension is ordered, my lord, in pursuance of annexure A.
Well, issue notice. ಯಾರ್ಯಾರಿಗೆ ಹೇಳಿ?
Comment ಇದೆ ಅಲ್ಲ?
ಎಲ್ಲ ಗವರ್ಮೆಂಟಾ?
ಹೌದು, comment.
Learned AGA is HCGP is directed to accept notice for the respondents. Refixation recovery na?
Refixation. Recovery illa, refixation order ಆಗಿದೆ. And in similar matters, my lord, this honorable court has already stayed the impugned order.
Counsel for the tag this petition along with so and so there shall be an interim order of stay as spread for list all these. ಎಷ್ಟಿದೆ? ಒಂದೇನಾ?
ಒಂದೇ ಇದೆ.
Tag this list both the matters on 21st November. Next.
Bill number 9, C.A. Shettar.
This matter, my lords, last week it was heard, it was posted for dictation. This is the matter, my dictating orders, it was passed over. Couldn't read. This is the matter, my lords, wherein a period of regularization from when it starts is the question. My lords,
there is some frequency there. I want those circulars of the government 119. Muralidhar, Dharwad district ಆದ್ಮೇಲೆ ಸರ್ಕ್ಯುಲರ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಲ್ಲ 1190 11 with effect from 1186 ಮಾಡಬೇಕು ಅಂತ ರೆಗ್ಯುಲರೈಸೇಷನ್. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? 6/8/1990 is the government order, all right. 6/8/1990 is pursuant to Dharwad district, all right. So ಅದರಲ್ಲಿ 1186 effect ಇಂದ ಮಾಡಬೇಕು if they've completed 10 years of service ಅಂತ ಇತ್ತು, ಹೌದಾ? ಅದು ಎಲ್ಲಿದೆ? Correct. 11/1976 ಮುಂಚೆ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ರೆ 1186 ಮುಂಚೆ ಆಗಿದ್ರೆ 1186 ಇಂದ ಮಾಡಬೇಕು. Otherwise 1190 ಅಂತ ಇದೆ. You get those government orders?
Please.
So just don't file, do some homework, get some things and come. Then we'll give you some relief. Yes.
Day after tomorrow.
Day after tomorrow. You ask Muralidhar.
Please.
Yes.
Get.
Next.
Much.
And Madan Goda in 13?
Appear for petition this case, Your Lordship. This matter is covered by judgment of Your Lordship, my Lord. It is Hindu Sadar Mali. Reservation pertaining to Hindu Sadar, Your Lordship. Earlier, my Lord, in 2008, my Lord, the petitioner was appointed as a driver cum conductor, my Lord. And he was dismissed in 2008 and after lapse of 10
ಅದೇ
years.
MB ಚಂದ್ರಕಾಂತ್ ತಾನೆ.
ಹೌದು sir.
Comment. Learned, heard, the petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list stands answered by the judgment rendered by the coordinate bench. Notice ಕೊಡೋದು ಬೇಡವಾ? NWKRTC covered ಅಂತ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರ ಆಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರತ್ತೆ. Learned AG is directed to accept notice for the respondents 1 to 3. Prashant Hosmani for the remaining respondents. List on Thursday in fresh matters.
Serial number 233, my Lord, is also similar matter, Your Lordship.
Let 233 come, sir.
Please, my Lord, please.
ಇರೋದು ಆಫೀಸಲ್ಲಿ, ಬರ್ತಾ ಇರೋದು VC ಅಲ್ಲಿ. 233 ಈಗಲೇ ಏನು ಅರ್ಜೆನ್ಸಿ?
Please, the similar matter.
ಸರಿ, ನೆಕ್ಸ್ಟ್.
Serial number 11, Sachin C. Kulkarni.
Petitioner being the employee, the pensioner of JESCOM, his representation to consider
Learned counsel
for increment.
BS Kamte is directed to act. JESCOM ಅವರೇನಾ?
JESCOM, Anup Deshpande ಅವರು.
Learned counsel Anup Deshpande is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 18th in fresh matters. Next.
Serial number 12, C. Jainer. S.C. Jainer.
S.C. Jainer has passed. S.C. Jainer, sir, he has passed away recently.
All right.
S.C.
The
Jainer.
learned counsel for the, sorry.
S.C. Jainer.
The counsel on record is no more. Issue court notice to the petitioner. Yes, next.
Serial number 13.
To the petitioner and the respondent both on madam. Next. 13. ಜೈನ ಯಾರು ಬೇರೆ ಹಾಕಿದ್ದಾರೆ? ಸಂತೋಷ್ ರಿಜಿಸ್ಟ್ರಿ ಟು ಡಿಲೀಟ್ ದಿ ನೇಮ್ ಆಫ್, ನೀವು ಯಾಕೆ ಸಿ ಜನ ಕರೆದ್ರಿ ಮತ್ತೆ? ಅದರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Registry to delete the name of S.C. Jainar is appearing for the petitioner. Learned counsel Prashant Hosmani is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 25th November. Yes, next.
13.
Emergent notice to the respondent. Chairman Canara Bank. ವಿಕಾಸ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ ಯಾರೋ ಇದ್ರಲ್ಲ ಮೇಡಮ್, ಕರ್ನಾಟಕ ವಿಕಾಸ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್. ಇದು ಬರೀ ಇನ್ಶೂರೆನ್ಸ್ ನೋಡಿ. ಅದೊಂದು ಬಿಟ್ಟು ಎಲ್ಲ ಇದೆ ಅಲ್ಲಿ. Emergent notice to the respondents. Yes, next. Girish Kulkarni. So and so accepts note. Previous matter li Karnataka Vikas Gramin Bank ಗೆ so and so accepts notice for the respondent ಅಂತ ಮಾಡಿ.
Shaila Beldikatti.
Lordship, it is with regard to compassionate appointment.
Learned
Annexure A,
counsel.
Your Lordship, that has been rejected, Your Lordship.
Correct, madam. Learned counsel. Date of death and madam?
Date of death is 2014, Your Lordship. The petitioner was minor at the time. Petitioner is born on 12/6/2001.
Yes. Learned Counsel Prashant Hosmani is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council 25th November. Next.
Obliged.
16 Srivatsa Hegde.
I represent the petitioner, my lord. This is second round of litigation, my lord. I have lost my land, my lord. The respondent acquired my land for formation of residential layout, my lord. I made a representation, my lord. That was not considered, my lord. Notice may be required.
Notice will issues. Yes. Notice will issues. Belgaum Urban Development Authority, yaru?
Gurudev Gachinmat, my lord.
Learned Counsel Gurudev Gachinmat is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council. List the matter on 18th November.
Please.
Yes.
16 Gayatri sir.
My lords, I appeal for the petition in this case, my lords.
Mr. Samir Gupta is appearing through BC, my lord.
Sorry?
Mr. Samir Gupta is appearing through BC.
My lords, I appeal for the petitioners in this case, my lords. That this matter pertains to section 74 of the GST, my lords. We have challenged the order on ground that the respondents have not issued the show.
Not the adjudicating authority and could not
No,
have
no,
passed the order.
I'm not pressing.
Then what are you on?
That my submission is that they have not issued the show cause notice to us.
Not issued?
Yes, not issued.
They heard the Sabir Gupta, right? Learned Counsel Sabir Gupta, heard Learned Counsel Sabir Gupta appearing for the petitioner. Respondent of state, commercial tax state. Learned AGA is directed to accept notice for the respondent. Learned Counsel Sabir Gupta, taking this court through the documents appended to the petition, would seek to demonstrate that the impugned action is taken without even issuance of a show cause notice to the petitioner, and therefore there is violation of the statute and principles of natural justice. In that light, there shall be an interim order of stay as spread for till the next date of hearing. List the matter on 26th in preliminary hearing. Objections, if any, by the respondent by then. Yes, next.
Great.
Please, oblige me.
Petitioner, my lord, that the petitioner lands has been utilized for the
Will direct.
road. The
Learned,
respondent number 1 is a MB Kanumal.
MB Kanvi 1, 2,
Respondent
3.
number 2 is state and respondent number 3 is this state.
ಈ ಕಡೆ ಅಂದ್ರೆ
It is in this.
ಶಿವಸಾಯಿ
Is a
ಪಾಟೀಲ್
ಶಿವಸಾಯಿ.
ಡೈರೆಕ್ಟೆಡ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ನೋಟ್ ಹೈವೇ ನೀವೇ ಅಲ್ವಾ
ಅದು national highway.
ಹೈವೇ
Dharwad, Matpati advocate.
ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ನೀವಿಲ್ವಾ
Dharwad, they are not giving me cases of Dharwad.
ಓ ಧಾರವಾಡ ಹೈವೇ ಬೇರೆ ಬೇರೆ ಬೆಳಗಾಂ ಹೈವೇ ಬೇರೆ
ಬೇರೆ law firm.
ಬಟ್ ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಲ್ವಾ ಅದು
Matpati advocate.
ಯಾರು
Matpati.
so and so accepts notice for 1 MB Kanvi, 2 and 3 so and so 27th November. Yes, next is in fresh matters. Next.
Bill number 18 Shivraj Ispadale.
Please, my lords. The second round of litigation, my lords. My land has been acquired at claim compensation of
36.50 lakhs.
Please, my lords. Only 30,000 has been awarded.
Learned Counsel B.S. Kamte is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid council forthwith. List the matter on 27th in fresh matters list.
Highly obliged.
Bill number 19 Rashikar Gunjali.
My lord, petitioner, my lord, Anganwadi worker, my lord, teacher, my lord. Initially, the provisional list, my lord, the name of the petitioner was forthcoming, my lord.
Correct. 4/3/24 agogide ella.
Yes, my lord.
1, 2,
1 to
3,
4.
4, 5.
1 to 4.
1 to 5.
Please, your lordship.
1 to 5 HC chief officer ನೀವಿಲ್ಲಲ್ಲ
That is
TMC.
town municipal council.
1 to 4 HCGP, 5 and 6 emergent notice. The appointment of the sixth respondent shall remain subject to the result of the petition.
Bill number 20 Shivsayi Patil.
Similar matters have been granted interim order.
So and so. Tag the petition along with so and so. Notice.
1, 2,
I will take
4.
notice for 3 and 8, my lord.
1 ನಿಮಿಷ sir. 3 and 8 ಯಾರು?
Shashank Hegde, I'm up.
ಶಶಾಂಕ್
KD,
ಹೆಗ್ಡೆ. 1, 2, 1 and 2 AGA.
4, 5, 6, all the rest of the age government advocate.
ಎಲ್ಲರೂ
All are
government.
government.
Yes, correct.
Other than the
3 and 8
8.
ಶಶಾಂಕ್ ಹೆಗ್ಡೆ. Remaining AGA.
AGA.
Please,
27th.
my lord, serial number 22, 23.
Tag this petition along with. ಇದರಲ್ಲಿ ಶಿವಸಾಯಿ ಪಾಟೀಲ್ ಯಾವ್ದಿದೆ ಇಲ್ಲಿ ತುಂಬಾ ಇದೆಯಲ್ಲ ಇವಾಗ.
Please, serial number 22, 23, 24 and 25.
ಬರ್ಕೊಂಡು ಬರೋಣ.
And they are posted on, maybe kindly posted on 511s. Connected matters are there on.
511.
Please, my lord.
Okay, all right, 511 ಎಲ್ಲ.
21 Anand Kumar.
Petitioner, my lord. My lord, the petitioner position of the land, my lord. In the year of 92, the
You are in possession even today?
Please, my lord.
My lords, this is a reserve forest land, my lords. May I take your lordship, page number 72?
As per the annexure C, my lord, in the year of 1992, Tahsildar issue Sagwali Chiti in favor of the petitioner, my lord.
Page number 72, my lords.
Forest
Reserve-
land ಅಲ್ಲಿ ಇದೆಯಾ?
Reserve forest land. my lord.
1964 to 1992, my lord, the land was the Gairana land.
Sanction of the central government is required, my lords. And this petition was, in similar petition, my lords, in respect to this survey number, may I take lordship, page number 72. Error number 4, wherein it is observed that it is a forest land, a reserve forest land. And it requires central government permission as per section 2 of the central government reserve forest land, my lords. And para number 5.
ಈಗ ಎನ್ಕ್ವೈರಿ 64A ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ದೀರಾ?
Yes.
Have you initiated inquiry?
Yes, yes, ma'am. This is the order, my lords.
64.
Yes, ma'am.
ಅವರು
Annexure K.
ಅವ್ರು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಾರಾ?
It's
secure instructions.
Please.
The learned AGA is directed to accept notice for the response. The learned AGA submits that the petitioners are in unauthorized occupation of reserved forest, and for any regularization of the possession of the petitioner in a reserved forest would require the permission of the government of India. And therefore, a 64A inquiry was conducted, and it is the inquiry is to the effect that the petitioners are in unauthorized occupation of reserved forest. The learned AGA therefore to secure instructions as to whether 64A inquiry has been conducted after giving adequate opportunity to the petitioner. The learned counsel for the petitioner submits that the petitioner is in possession of the land since 1964. And therefore, if the petitioner is not dispossessed as on today, he shall not be dispossessed till the next date of hearing. List the matter on 18th. in preliminary hearing.
R8 notice.
R8 ಯಾರು?
Gram Panchayat.
Sir,
1 to 7, 9 to 12.
Eighth respondent be served by way of hand summons. Yes, next.
Please.
Number 26, Sangram Kulkarni.
Mandamus to consider the representation and release the award amount passed by the Upper Krishna project, my lords. Also, I am seeking a interim order of stay, my lords.
What stay, sir?
Not to release the entire amount in respect of respondent, my lords, because order of partition and separate possession is passed in my favor, my lords. The properties are joint family properties.
What suit is pending?
So, RAC is filed, my lords. RAC is pending. RA was confirmed. OS is filed. That is also in my favor, my lords. FDP is filed, but since RAC.
First respondent ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ?
State, my lords.
State ಏನ? Learned AGA is directed to accept notice for respondent, first respondent. The remaining respondents be served by way of hand summons.
Please.
The compensation amount, if not disbursed as on today, shall not be disbursed till, without the leave of the court, till the next date of hearing. List the matter on 27th in preliminary hearing.
Obliged.
Next.
7, Anand Kumar, A. Magdu.
Widening of road. BRTS. 1 AGA.
1, 4 and 5.
1, 4 and 5 AGA. 2, 4 Gurudev Gachinmat. 2 and 3 BRTS ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? Last time Bekash case. Learned counsel Shivakumar Badavadgi is directed to accept notice for respondents 2 and 3. List the matter on 27th in preliminary hearing. Next.
28, Mallikarjun P. Madanadi.
Lordship, in regularization of the service, my lord.
Forest.
Please, my lord.
Learned HCGP is directed to accept notice for all the respondents. List the matter on 28th November in preliminary hearing. Please. Petitioner to serve set of papers upon the aforesaid counsel forthwith. Next.
29, MS Harvey.
Madam, the petitioner was working in the respondent company sugar factory as an assistant mechanical engineer. He retired from service in the year 2006. After the retirement, the respondent company has withheld the served.
Sugar industries.
Industries.
Private industry.
It is a factory.
Factory.
Sugar. It is a limited factory.
Writ petition mental.
That is a registered under the.
Registered under private sugar factory, sir.
Though, my lord, they have paid the gratuity amounts, only increment amount has been withheld, my lord. Let them consider and pass orders. My lord.
Pure private entity. Gratuity fine under the gratuity act.
Allah,
you are
that have
claiming.
paid, my lord. I approached the matter authority.
Gratuity under the gratuity act, you are entitled to claim. But this is a private entity. No
Authority, my lord.
mandamus would lie to a sugar factory.
This is, my lord, limited company, my lord.
Limited, unlimited, relief unlimited illa.
Let them consider and pass, my lord,
No,
orders.
sir. Yeah. Mandamus vegetable. Increment ado.
Increment amount, but they assured there at the time of appointment to give them, my lord, 20.
Contract, sir, how it would be maintainable? ಎಲ್ಲದಕ್ಕೂ ಕೇಳಕ್ಕಾಗಲ್ಲ.
My lord, so far as gratuity amount is concerned.
Gratuity ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರಿ.
So far, only, my lord, increment amount is they
You have to approach the ಯಾವ ಕೇಡ್ರಿ ನೀವು?
My lord, assistant mechanical engineer.
Approach the court. Increment ಎಲ್ಲ ಕೊಟ್ಟು. It is not maintainable.
Let them, my lord,
Notice
consider
ಮಾಡಿ.
the same and pass.
Consider ಇಲ್ಲ. Yes. Notice. Next. ನೋಡೋಣ. ಆಗಿದೆಯಾ?
ಆಗಿದೆ,
Serve
sir.
ಆಗಿದೆಯಾ?
They have served and unrepresented.
ಯಾಕೆ ಬರ್ತಾರೆ? ಬರಲ್ಲ ಅವ್ರು anyway. List on 28. Next. Consider ನಾನು ಕೊಡಲ್ಲ. Mandamus to a private entity will not give. Pending ಇರ್ಲಿ petition ಬರ್ಲಿ ಅವರು. Yes.
Bill number 30, SM Kalwar.
Please, my lord. The appeal by the Karnataka Nigam, Nigam, my lord, challenging the damage award. my lord.
Damage award ಗೊತ್ತು.
Please.
Identical matters ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ ಮೇಡಮ್. Dictating orders ಅಂತ ಒಂದು ಸುಮಾರು ಹಾಕ್ತೇನೆ ನೋಡಿ ಅವತ್ತು. MR 5th. Yes. List
Please,
on 5th.
Please.
Bill number 31, Sangram S. Kulkarni.
Seeking appointment of arbitrator, my lords, to resolve the disputes. My lords.
Arbitrator.
Please, my lords.
Respondent ಯಾರು?
Respondent notice as private parties, my lords.
Emergent notice to the respondent, both 30 and 31, 31 and 32. Emergent notice to the respondent. Petitioners will serve the respondent by way of hand summons as well. This the matter on 28th November and fresh matters. We'll dispose it on that.
33, SH Mittal Court.
Sought mandamus to consider representation where they have recovered excess amount as against the scheme under the veteran scheme. my lord. In all,
Vikas Gramin Bank ಯಾರಂದ್ರೆ?
yes, Mallikarjun.
Mageshri. ಗಾಯತ್ರಿ ಮೇಡಮ್ ನೀವಿದ್ದೀರಾ?
ರಾಘವೇಂದ್ರ ಸರ್ appears. ರಾಘವೇಂದ್ರ ಸರ್, ದಿನೇಶ್
ಇದು
ಕುಲಕರ್ಣಿ
ಯಾರಿದ್ದಾರೆ? ದಿನೇಶ್ ಕುಲಕರ್ಣಿ ಇದ್ದಾರಾ?
ಅವ್ರ colleague appear.
ಆಯ್ತು, whatever. So and so accepts notice for the respondent. Petitioner to serve set of papers upon the aforesaid council forthwith. List on 27th November. Next. In preliminary hearing.
After 27th. my lord.
28th. After 28th.
Yes,
34, Satish MS.
December 3rd.
yes.
Of mandamus, my lord.
Writ of mandamus. 30?
34, my lord.
Yes, Ramesh.
1 to 7 government. my lord.
ಎಲ್ಲ ನೀವೇ.
1 to 7, my lord.
1 to 7.
8 to 10 issue notice.
8, 9 and 10. ಅವ್ರು ಯಾಕೆ ಬೇಕು?
ಅದೇ
9 and 10 ಯಾಕೆ ಬೇಕು? ನೀವು ಮ್ಯಾಂಡಮಸ್ಗೆ ಅವ್ರು ಯಾಕೆ ಬೇಕು?
ಅಲ್ಲ 10 ದಾಗ ಅಮೌಂಟ್ ಡಿಸ್ಬರ್ಸ್ ಮಾಡಬಹುದು. ಅವರು
10 ದಾಗ ಆಗ್ಬೇಕಾ?
10 ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 10 ಗೆ
Yes. 7, 8, 10 emergent, sorry. Emergent notice returnable by 3rd December. List on 3rd December. Next.
35, Jay Shetty.
35, my lord, I am per the petitioner. There is some defects in the petition. I want to withdraw, my lord, with
Three
liberty.
mistakes, sommalla. Aye. Senate counsel for the petitioner seeks leave of this court to withdraw the petition and file a fresh petition on the same cause of action. Liberty so sought is granted.
Am I direct taking?
ಅದ್ರಲ್ಲಿ ಬರ್ಕೊಂಬಿಡಿ. Leonard heard so and so Ramesh Chegri. Yes.
36, K. Anand Kumar.
Same as 21.
Please.
21 ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ.
Government direct government.
ಇಲ್ಲ 21 ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ.
ಅಲ್ಲ ಇದು R12 ಇದಾರೆ, ಇಲ್ಲ R6 ಇದ್ದಾರೆ.
ಸರಿ, ಯಾರು ಹೇಳಿ?
R1 to 6 government.
1 to 6 state.
Please.
Leonard AG is directed to accept notice for 1 to 6. Next.
Please.
37, Saurabh Sandu.
Mandamus to consider representation.
Alternate route.
Sorry, Lords.
30?
Alternative road.
The alternate road.
Even Panchayat has written, my lords, to the deputy commissioner saying that that is the issue.
Learned AGA is directed to accept notice for the respondents. Will you secure instructions or should I dispose it?
Maybe disposed of it.
The petitioner is before this court seeking the following prayer. Owing to certain mining activities, the petitioner had represented for an alternate route for the mining trucks to move, as it had caused danger to the lives. The Gram Panchayat on the representation made by the petitioner is said to have suggested alternative route by utilizing all available resources. The representation to that effect has not merited consideration at the hands of the respondents. Therefore, the petitioner is before this court seeking the aforequoted prayer. In the light of the prayer being innocuous and a recommendation by the Gram Panchayat being in place, I deem it appropriate to dispose the petition with a direction to the respondent state to consider the representation and pass necessary orders in accordance with law at any rate within 12 weeks from the date of receipt of the copy of this order, ordered accordingly. Next.
38, Kiran Kumar Chettima.
Petitioner, my lords, writ of Madam seeking direction to respond number 1 to 5, my lord, to fix remuneration.
Honorarium, sir.
Please, my lord, honorarium.
Yes, government, huh?
Please, my lord, respond number 1 to 5.
Mandamus directing fix honorarium for service 1990 to 2015.
Please.
I'll take notice.
He's no more.
He's
No more, my
Lord.
lord.
Ship has paid up. My lord, the husband has
The
died.
petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is appointed as by the fifth respondent as Dalapatina.
Please, my lord.
In the Home Department.
Home Department.
In the Home Department of the state. It transpires that during service, the husband of the petitioner dies in harness. The wife submits a representation on 12/8/2024 seeking payment or honorarium that was fixed at rupees 1,000 in terms of the Karnataka Village Defence Party's Rules 1965 had not been paid to the husband, and therefore the wife submits a representation seeking such payment from 10/8/1990 to 25/8/2015. The learned AGA submits that appropriate action on verification of the records would be taken if reasonable time is granted to the state. In the light of the said submission, without entering into the claim of the petitioner, the respondent state shall verify the records as to whether the honorarium to the husband of the petitioner has been paid. If not paid, consider the representation and take action in accordance with law. At any rate, within 4 months from the date of receipt of the copy of the order, ordered accordingly. Next.
9, Lakshmi Kant K.
You. The petitioner is the husband, seeks maintenance from the hands of the wife on the score that he is physically handicapped and not in a position to work while the wife is working. The concerned court has rejected the same, therefore the petitioner is before this court. The petitioner shall serve on the counsel who represents the respondent wife in the trial proceedings and file an acknowledgement to that effect. List the matter on 29th November. Next.
Number 14,
Oh,
Reena
sorry,
Kumar.
28th November. Silamar? 40.
Lord, the petitioner is seeking appointment on compassionate grounds.
Reserve Police.
Your Lordship, he is the son of second wife, Your Lordship. Earlier also, second wife has filed an application and he died on 15/8/2015, Your Lordship. And they have filed application earlier 4/12/2018, wherein they are supposed to file application within 1 year of the death, Your Lordship, but they have filed
Right after the demise,
lately.
right after the demise of the petitioner's father, The second wife has filed an application before the trial court. She has moved a PNSC application seeking,
ಆಯ್ತು ಏನಾಯ್ತು ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ರ?
it was compromised. The first wife,
ಅಲ್ಲೇನ ಕಾಂಪ್ರಮೈಸ್ ಕಂಡೀಷನ್ ಏನು?
the first wife received the pension and half of the gratuity amount. Half of the gratuity amount was given to second wife.
Second wife's son wants compassion.
Yes, my lord. And that is covered by order, my lord.
Application is also not at all filed, your lordship, within a stipulated time.
What covered by?
Consideration.
The children of the second wife are entitled to appointment on compassionate grounds, my lord.
ಇಲ್ಲ
And
ಅಂದ್ರೆ
in this,
They're not disputing.
in this,
You're not saying that not entitled, but your
in
lordship.
time.
yes, my lord, that I agree, ma'am. In this case, madam, kindly,
Anyway, notice ತಗೊಂಡ್ರಿ ಮೇಡಮ್.
my lord,
First
kindly, the
Learned HCGP is directed to accept notice for the respondent. KSRP ನೀವೇ
How the
Yes.
case.
respondent petitioners. Copy ಇದೆ ಮೇಡಮ್?
Madam.
Copy
Your
ಇದೆಯಲ್ಲ?
in this
Copy ಇದೆ,
matter,
your lordship.
27th, yes.
Number 41, Jagdish Patil.
Here sought direction to register FIR by
In a
forging.
purely civil matter, where will they do it, sir?
Alla, my lord, kindly see page,
Civil suit pending ilva?
page 10. No, illa. Page 10, my lord. Is the Aadhaar card number,
Yes.
Aadhaar card number, my lord, in
Is
It is civil in nature, my lord. Dispute is civil in nature. Based on, according to them, they based on the forged.
File a private complaint, sir. Register a private complaint.
Aadhaar card number differs, my lord, kindly see.
ಆಮೇಲೆ
Page,
ಬೇರೆ ಏನಿದೆ ಗ್ರೌಂಡ್?
ಅಲ್ಲ, it's forged ಮಾಡಿದ್ದಾರೆ.
ವಾಟ್ ಆಧಾರ್ ಕಾರ್ಡ್ ನಂಬರ್ ಡಿಫರ್ಸ್ ಒಂದು ಬಿಟ್ಟು ಬೇರೆ ಏನಿದೆ ಅಂತ?
ಏನಿಲ್ಲ, we have not signed it. Even the address is also different in the sale deed.
ಫೈಲ್ ಸಿವಿಲ್ ಸೂಟ್, ಸೀಕ್ annulment of the sale deed. ಹಿಂಗೆ ಪೊಲೀಸ್ನವ್ರಿಗೆ ನಾವು ಸಿವಿಲ್ ಕೇಸಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಕ್ ಕೊಟ್ಟು ಬರೋದವ್ರೆಲ್ಲ. ಆಮೇಲೆ 482 ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಪ್ಯೂರ್ಲಿ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ ಕ್ರೈಮ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್.
Not civil by forging the
ಫೈಲ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
next week.
ಅದೇನು ಇವತ್ತೇ ಕೊಟ್ಬಿಡ್ತೀನಿ ಮಾಡಿ. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the crime is not being registered. I will not hold anything civil until bariyalla. Crime is not registered. The petitioner has not produced any document to demonstrate that he has availed of the remedy available in law, i.e. 154(1) of the CRPC / 175(1) of the BNSS, 154(3) / 175(3) of the BNSS, and 220 and 200 of the CRPC by filing a private complaint, 200 / 223 of the BNSS by filing a private complaint. In the therefore, I deem it appropriate to dispose the petition with the direction to the respondent petitioner to avail the remedy as available in law, and in the event of need, approach this court in future. Ordered according. Yes.
42, Balgowda A. Patil. Bhushan Kulkarni.
My lord, tender matter, my lord.
Tender matter, 30 days ಆಗಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ.
About 2 crores.
Yes, my lord.
That is relaxable. 15 days.
Yes, my lord. But they have not given any application to the superior authority, my lord. Not only this, my lord, as per my lord, the finance department circular, my lord, if the tender amount is more than 10 crore, they have EMD must be 1%, my lord.
We'll see. The last date ಏನೋ ಆಗೋಗಿದೆಯಾ? Who are you? You have participated, is it?
Yes, my lord, I have participated, my lord.
So why are you, how can you challenge?
My lord, I have participated, my lord.
ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ವಾ ಈಗ?
No, my lord.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
No, my lord. Work order is not yet issued, my lord.
To whom?
Not issued, my lord.
Why did you participate in this condition?
I have
ಈಗ
participated.
ಯಾರಿಗೂ ಇಶ್ಯೂ ಮಾಡಿಲ್ವಾ?
No, my lord.
Not. The learned AGA is directed to accept notice for respondents, all respondents?
My lord, already served, my lord.
Yes.
Respond number 3, Jila Panchayat Balkot is represented by Bhushan Kulkarni, my
So
lord.
long. Represented, serial number and madam?
42, my lord.
No representation on behalf of the third respondent. List the matter day after tomorrow.
In preliminary.
Entry ಮಾಡಿದ್ಯಾ?
No, my lord. In preliminary.
Preliminary hearing.
43 VM Shilvan.
My lords, challenging annexure D, my lords. It's an order of Deputy Commissioner, my lords, wherein they have granted the property in question, that is land in question to R2 and R3 for
Correct.
establishing the KV power
1
distribution
minute.
center.
Please take. Learned AGA is directed to accept notice for respondents 1, 2 and 3. BS Kamte for the fourth respondent, petitioner to serve set of papers upon council's BS Kamte forthwith, list on 27th.
Seeking for stay, my lords.
What?
We are in,
Be in
my
stay,
lords, we
madam.
are in the possession, my lords.
Oh, be in possession. ತೊಂದ್ರೆ ಯಾರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನಿಮಗೆ?
And they have already, corporation have submitted the report, my lords, KPCT.
The petitioner, if not dispossessed as on today, shall not be dispossessed till the next date. Yes.
Great.
44 Sunil S. Desai. MB Hiremat.
Principal.
Password.
ಯಾಕೆ ಸುನಿಲ್ ದೇಸಾಯಿ ಬಂದಿಲ್ವ ಇನ್ನು? ಇವತ್ತು ನಾನು ಕೊಡಲ್ಲ ಟೈಮ್. ಪಾಸ್ ಓವರ್.
That's instead of Passover, your lordship may have it tomorrow.
Tomorrow, fresh matters.
Let's pass on.
ನಾಳೆ.
Yes, great. There is an interim order, my lords, in connected.
That will continue. Yes. Next.
Rajat Balloli.
I am impugning my lords annexure A, passed by my lords the.
Emergent notice to the respondent. The petitioner is at liberty to serve on the council who represented the respondent in the consumer proceedings. There shall be an interim order of stay as prayed for till the next date of hearing. Yes, next.
46
Oblige.
Shalvi Bolma.
ಬೇರೆ ಏನೇನು ಬೇಕಾ?
No. Oblige. Petitioner, my lords. Pertaining to consumer forum matter, my lords.
Matter pending before the PF tribunal?
Please, my lords. It is also pending and also WP got disposed of for non-prosecution, my lords.
Same order.
Oblige.
ಏನ್ ಹೇಳಿ ಸೇಮ್ order ನಕ್ಕ? Petitioner shall serve on the council who represented the respondent in the consumer proceedings. The learned counsel for the petitioner submits that the claimant,
Please.
the complainant before the consumer forum has availed of several remedies. One such remedy is pending before the Provident Funds Tribunal. Therefore, there shall be an interim order of stay as prayed for to the next date. Yes.
Oblige.
47 Tejpalan.
Appointment ಆಗೋಗಿದೆ.
Yes, ma'am.
Subject, the petitioner, learned HCGP is directed to accept notice for respondent 1 to 8, 9 also madam.
9 is the private.
Women and child welfare. ಯಾರು? ಈ ಕಡೆ ಬನ್ನಿ ಮೇಡಮ್, ಕೇಳಿಸೋದೇ ಇಲ್ಲ.
Respondent number 9 is appointee, your lordship.
10 is the appointee.
Yes.
9 is CDPO. Deputy Director Women and Child.
Please,
Ah,
your lordship, I'll
yes.
take.
ಅದಕ್ಕೆ 1 to 9 HCGP, 10 emergent notice. The appointment of the 10th respondent as Anganwadi worker ಅಲ್ಲ?
Yes, ma'am.
Anganwadi ಕಾರ್ಯಕರ್ತೆ will remain subject to the result of the petition.
Please.
Next.
48 Manjunath Patil.
13/5/25 are terminated
Yes.
without enquiry.
Please.
It's covered, madam, actually. Learned HCGP is directed to accept notice for the respondent. Where is my judgment?
Sorry.
It's completely covered, but what I've already written. Without enquiry, you cannot terminate. 10 judgment.
Order passed by Gram Panchayat, your lordship.
Right, ಅವರೇ ಮಾಡಂಗಿಲ್ಲ. Learned 1 ಇವರು ಬಂದಿಲ್ಲ. ಯಾರ್ಯಾರಿಗೆ ಮೇಡಮ್ ನೀವು?
One government.
1?
Government.
1 HCGP ಗೊತ್ತು. 2, 3, 4,
Notice.
5
Notice.
emergent notice returnable by the 3rd of December. Get judgment. Is that dismissed, ma'am?
49
In the meanwhile,
Manoj
madam.
Huh?
In the meanwhile.
Interim order. 13/5/25 ಆಗಿರೋ termination order, can I put it back? ಅದಕ್ಕೆ you should get the judgments, we'll finish it off. ನಾನೇ ಕೊಡ್ತೀನಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಆಯ್ತು. 3rd December.
49
Seeking for consequential benefits, your lordship, wherein, please respond.
HCGP is directed to accept notice for respondent 1, 2,
9 to
MB Kanavi 3,
To 5, your lordship.
3 to 5 MB Kanavi.
6 Apurva Somannar will be appearing for cantonment board, your lordship.
ಯಾರ ಪೇರ?
Apurva Somannar.
ಅದೇ ಬರ್ಕೊಳ್ಳಿ. So and so. This is the matter on 28th and fresh matters.
Please, oblige.
Petitioner to serve set of papers upon the aforesaid council forthwith. Next.
50 Guru Baswaraj.
Petitioners.
Police protection.
Police protection.
Ah.
My lord, My lord, civil suit is pending
Civil
between this.
injunction ಯಾರ ಫೇವರ್ ಇದೆ ಸರ್?
Injunction is in favor of plaintiffs, my lord.
Plaintiff ತಾನೆ?
Plaintiff
You are the
means-
defendant there.
Petitioner, plaintiffs, my lord.
ಮತ್ತೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
Defendants ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ ನಾಟ್ ಟು ಅಲಿನೇಟ್ ಅಂತ ಇದೆ ಅಷ್ಟೇ.
Not to alienate ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ in order to avoid the my lords the
conflict
and quarrel, that is the request made.
They go back to the same court and ask modification of the order, and even police protection you can ask there only. We will direct.
My lord.
ಈ ಕೊಟ್ಟಿರೋದನ್ನ will not disturb.
My lord,
ಸುಮ್ಮನೆ ಗಲಾಟೆ ಮಾಡ್ತೀರಿ ನೀವು.
My lord, there is a dispute.
ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್, ಆ ಪ್ರಾಬ್ಲಮ್ಗೆ police protection.
They are giving dispute with us, my lord. My lord, there are report with respect
Them
to.
with you go before the civil court.
My lord,
In
there are.
fact, you have to file an application at 151 before the civil court and take an order. ಅವಾಗಲೇ ಕರೆಕ್ಟ್ ಆಗಿರೋದು. Now, to protect law and order, they have passed an order.
My lord, Annexure E and E1 are the reports given by revenue inspector and village accountant.
That you are in possession of the property.
Yes, my lord.
Allogi.
Since more than 25 years, we are in possession.
You should
By
go
virtue
not
of-
to alienate ಅಂತಾನೆ ಆಗಿರೋದು. You are the plaintiff.
Yes, my lord.
Not to
By
alienate.
virtue of this order, my lord, they are picking up quarrel with us frequently, my lord.
That is why, yes, sir. Crime register ಮಾಡಿದಿರಲ್ಲ ಹೆಂಗ?
Yes, my lord. There is a complaint and counter complaint.
ಆಗ್ಲೇ you have already, you are on the fist already. Any modification, go before the civil court. The petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioners are the plaintiffs. In OS 8 of 2025, an order is passed by the concerned court directing the parties not to, directing not to alienate the property. On the strength of the said direction, it appears that the parties to the list have ended up in a squabble. This squabble has resulted in registration of a case and a counter case against by the petitioners and against the petitioners. In the teeth of the said circumstance, the jurisdictional Tahsildar has opined that police protection should be accorded for maintenance of status quo in the property. That is what is challenged by the petitioner before this court. The petitioner, being the plaintiff, has a remedy before the civil court to seek modification or seek police protection as the case would be. The state having taken a step in the teeth of the case and counter case being registered against the petitioner and by the petitioner, no fault can be found with the said action. The petitioner is always at liberty to move the civil court in OS 8 of 2025 and seek appropriate relief ordered accordingly. Yes.
51, Prashant Escardeva.
Withdrawing the writ petition.
Thank you, sir.
Not interested to pursue the matter.
Not interested.
Both are sisters, lordship.
Oh.
ಅದೇನೋ subsequent is all.
Alright. Learned counsel for the petitioner seeks leave of this court to withdraw the petition. As the petitioner is not wanting to pursue the writ petition. Submission is placed on record, petition disposed as withdrawn. Please.
52, Amir
Notice.
Khan.
ಅವರು ತೊಗೊಳ್ಳಿ. Separate order sheet ಅಲ್ಲಿ HCGP ಗಿರಿಜಾ ಹಿರೇಮಠ್ heard so and so ಆಮೇಲೆ. Yes.
Please.
52.
Permission to travel ಕೊಡಿ. ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
State.
Short validity passport.
Please.
State.
Yes.
But Union of India party ಮಾಡಿಲ್ವಾ ನೀವು?
Yes.
Mike, Union of India party ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, my lords.
There's
Because
only
the
for issuance of
representation was
NOC.
given to the SP, my lords. Representation was given to the SP.
SP cannot do anything, sir.
No, my lords.
Unless
To
you
issue
make-
the NOC, my lords. To issue the NOC,
NOC for what?
the authorities were seeking for the NOC from the
One
jurisdiction of
NOC for passport or what?
passport, my lords.
The petitioner is before this court seeking the following prayer. The petitioner is wanting to travel to Dubai, UAE, sorry. Wanting to travel to the United Arab Emirates. The same is not seeks passport renewal. The passport of the petitioner has stood expired is the averment in the petition. Therefore, submits an application seeking renewal of the passport. The renewal is not considered on the score of pendency of criminal cases against the petitioner. ಎಷ್ಟು ಕೇಸ್ ಇದೆ?
My lords, there are more than 15 cases have been registered. My lords, these cases were filed against the son-in-law of the petitioner, my lords.
15 cases.
Yes, my lords.
Brief
Husband and
facts are
wife problem.
Yes, my lords.
ಅದಕ್ಕೆ ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ಆಗೋದು 10 ಮೇಲೆ.
Yes.
ಎಸ್ ಬೇರೆದೆಲ್ಲ 1-2 ಕ್ರಿಮಿನಲ್ ಕೇಸ್. Husband and wife ಇದ್ರೆ 20 cases minimum. Yes. The learned counsel for the petitioner submits that the petitioner is the father-in-law of ಯಾರದು name?
One person, Ayub Nadimullah, my lords.
Ayub Nadim so and so, who has registered about 15 cases against his son, and therefore he is caught in the crossfire without a passport being issued to him on the score of pendency of those cases against the family. In the light of the pendency of the cases, I deem it appropriate to pendency of the cases, the jurisdictional superintendent of police has not issued a no objection for renewing the passport. While the petitioner cannot get a regular validity passport to travel, but nonetheless would get a short validity passport in the light of the law laid down by this court in so and so. This court has held as follows. Purti madbidi. Same order.
Please. Obliged.
Yes, next. Ordered according.
Hanumareddy.
For the petitioner,
Notice.
Your Lordship, we are challenging annexure E, Your
Yes,
Lordship.
madam.
That is an endorsement issued by respondent number 3. Your
Hubli,
Lordship,
ಯಾರು ಮೇಡಮ್ ಇದು? ESCOM
managing.
Kamte. Learned counsel B.S. Kamte is directed to accept notice for the respondent petitioner to serve set of papers upon the first counsel list on 26th and 24th November. Fresh matters. Next.
54, Gauri Shankar Mo.
Externment.
Connected matter, they have withdrawn notice lordship in other.
Withdraw
cases.
ಮಾಡಿದಾರಾ?
In other cases, they have withdrawn lordship.
ಇದ್ರಲ್ಲೂ ಮಾಡಿದ್ದೀರಾ?
I will assert.
Learned counsel for the petitioner submits that ನೀವು withdraw ಮಾಡ್ಬಿಡಿ ಇಲ್ಲ ಅಂದ್ರೆ
I
revive ಮಾಡಿ.
verify lordship.
The learned counsel for the petitioner submits that in all identical cases, notice of externment against the petitioner has been withdrawn, including the case. Therefore, I deem it appropriate to dispose the petition, reserving liberty to the petitioner to revive the subject petition in the event the notice has not been withdrawn. Yes, ordered accordingly. Next.
55,
Same connected lordship.
Same.
56, Amrita Sanjoy.
My lord, appearing for the petitioner in this matter, my lord.
Termination, Anganwadi
Yes,
worker.
ma'am. Yes,
How
my lord,
many
this
steps
matter has
up
been
from-
disposed of on 29/10/2025. Similar
Same
order
order.
has been passed.
Up to 61, Your Lordship.
Up to 61.
Similar order has been passed on 29/10/2025, my lord.
Correct, sir. Where is that order?
It has not been uploaded, my lord.
Number kodi.
104375 of 2025, my lord.
Same order, up to 61.
And 179, my lord.
179 also.
Obliged.
Number ಬರ್ಕೊಂಡ್ರ? ಅದು ನೋಡಿ ಯಾರ್ದಾಗಿದೆ. Yes, next.
PV Soma.
ಅದ್ರೆಲ್ಲ HCGP accepts notice ಅಂತ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ ಅಲ್ಲ?
Please, Your Lordship.
Please.
62, PV Soma.
Obliged.
Please, ma'am.
60?
62, Your Lordship. 62.
The petitioner is under suspension since 1/10/2024 and he has not been given. I filed I-2 for direction.
ವೇರ್ ಹೌಸಿಂಗ್ ಕಾರ್ಪೊರೇಷನ್ ಯಾರು?
Please, Minister.
ಇದು ಒಂದು 2 ಲಕ್ಷ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡುವ. Petitioner to serve the respondent warehousing corporation by way of hand summons.
Please.
The learned counsel for the petitioner submits that he was placed under suspension ಯಾವಾಗ?
1/10/2024.
On 1/10/2024 and has not been paid even a rupee of subsistence allowance for the last 13 months. Therefore, the respondent to show cause as to why exemplary cost should not be imposed upon the first respondent, the managing director of the Karnataka State Warehousing Corporation, with a direction to pay the cost from the pocket of the managing director in the teeth of the fact that the employee who is placed under suspension has not been paid a rupee of subsistence allowance. List the matter, serve madi. Learned counsel for the petitioner shall serve respondents 1, 2, 3.
1 to 3.
1 to 3.
Please.
By way of hand summons and file an acknowledgement of such service by Friday. List the matter on 18th November in fresh matters list.
Please.
Yes. Next.
63, Sanjay's category.
Please.
Petitioner was.
Compromise decree.
Yes,
Yes, sir.
in fact, there was earlier compromise.
No problem. Date,
That was in the year 2003, my lord, Annexure B.
This also is 11/2/2023, sir.
Yes.
What were you doing till now?
No, in fact, this property was allotted to me in the year two.
See, petitioner shall serve the respondents by way of hand summons and file an acknowledgement of such service by the 14th of November. List the matter on 18th November and fresh matters list. Merely because notice is issued that the petition is pending, the rights accrued to the parties under the compromise shall not be altered. Yes, next.
In fact, it is given effect in the revenue records.
Yes, next.
64 PN Hosmani.
Without
Notice.
Without notice, he's removed from the service. Not
Without notice, removed him.
Yes, without inquiry.
Final order, sir.
Yes, madam, without inquiry.
Interim model ವಾಪಸ್ ಹಾಕಕ್ಕಾಗಲ್ಲ. Learned HCGP is directed to accept notice for respondent.
1 to 3.
1, 2, 3.
3, madam. 4 to
4
7.
and 5.
4
to 7.
Bhushan
Emergent notice.
Bhushan Kulkarni.
Bhushan Kulkarni accepts notice 4 to 7. List the matter on 28th in preliminary hearing. Yes, next.
65.
You're a disabled employee, la?
Please.
Disabled employee.
Disabled employee for purpose of special.
60?
65 minutes.
65.
Fishing.
Yes, fishing, minutes, Annexure B.
The
65. Spandana.
learned AGA is directed to accept notice for the respondent's petitioner to serve set of papers upon the aforesaid council. The fishing activity of the petitioner, if not discontinued as on today, shall not be discontinued till the next date of hearing. List the matter on 19th November and preliminary hearing. Next.
Number 66. इसके कायक में
Same matter, identical matter.
My lord, 166 sub clause 3 of MU Act.
Identical matter ಎಲ್ಲಿದೆ? ಕೊಡಿ ಸರ್ ಒಂದು.
Fourth of this month, my lord.
ಈ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ಕೊಡಿ ಸರ್, ಟ್ಯಾಗ್ ಮಾಡಕ್ ಹೇಳಕ್ಕೆ.
I'll give it, my lord.
ಅವ್ರು ಡಿಸ್ಮಿಸ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ
I'll give the number.
ಕೊಡಿ. ಎಸ್ ಟ್ಯಾಗ್ ಸೋ ಅಂಡ್ ಸೋ ಸೇಮ್ ಆರ್ಡರ್.
67. Sunil Desai.
Please, my lord.
Kiaji.
Whereas the tender was for 12 blocks, they have applied only for 2
Rule
blocks.
22.
How?
Sunil Desai ಬರಲ್ವಾ? Pass over. Today we'll finish this.
Please, my lord. And the timeline is discussion of the district tender committee antane tender document ile.
Where is my judgment?
I'll submit when ide, my lord. I had the judgment.
ರಜಾ ಮಾಡ್ತೀನಿ ಈಗ.
He's held up before total 2 minutes.
What is this? He's dodging the court.
No, no, that's only.
Pass over.
Please.
68. Base Kamte.
Yedrami sir.
Please, my lord.
Judgment ತಗೊಂಬನ್ನಿ.
Please, my lord.
ಇಲ್ದರೆ I will allow this.
Please.
You can take my judgment.
Please, my lord.
Serial
Stay
number.
with me. I'll submit to your lordship.
Serial number 68, 75 and 83 are arising out of the Telegraph Act matter.
Same order.
May I request the dates in there, those are on 10th, my lord. These three may be a week to serve
Same
the
date.
hand summons.
Same date. ಅದು ಟ್ಯಾಗ್ along with so and so ಅವ್ರು ಏನೇನು ನೋಟಿಸ್ ಮಾಡಿದೀನಿ ಅದು ಸೇಮ್ ಡೇಟ್. ನೆಕ್ಸ್ಟ್.
Your Lordship, serial number 69, I'm appearing for the petitioner. I've challenged the order of the first appellate authority under the GST Act. Your Lordship, may I just submit, although there is no other remedy that is available, the appellate authority has dismissed my appeal on the ground
limitation.
that... No, illa,
On
limitation alla. Limitation alla. Opportunity of hearing kottbittu bandilla anta. Your Lordship, the entire order of the first appellate authority is 53
We'll
pages.
set it aside and send it back.
Yes, Your Lordship.
Input tax credit.
Your Lordship, from page number 6 to 52, I have given detailed annexures, grounds of appeal. Nothing has been considered.
We'll see.
Not appeared on the page number 69, Your Lordship, findings and conclusions. I have given notice, but not.
One minute. Learned AGA is directed to accept notice for the rest. Copy diya? Yes. List on Thursday in fresh matters list. We'll dispose it on the day, not company. Yes.
Yes. May I just submit one, Your Lordship? Section
Yes,
100, section 107.
so that's all right,
subsection
madam.
12.
On Thursday, we'll dispose it and send it
Yes.
back.
Yes, Your Lord, obliged.
70, Shubham NM.
My lords, here the petitioner is
70?
challenging. Please, my lords. Here the petitioner is challenging the show cause notice along with the order in original.
Ex parte decree?
Ex parte decree, my lord. The opportunity was not given to the petitioner, my lord. Also, notice was not served.
Decree en bantu?
Decree.
Order.
Order in appeal.
Order in original.
Order in original and order in appeal, my lord. Annexure B and
Both are
C.
ex parte?
Both are ex parte, my lord.
The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that both the order in original and order in appeal impugned in the subject petition are orders which are passed in blatant violation of principles of natural justice, as they are admittedly ex parte orders. In that light, there shall be an interim order of stay as prayed for till the next date of hearing.
My lord, notice to
Learned AG, commercial tax, central tax, Tirumalesh.
Girish Shulimani, sir.
Girish Shulmani is directed to accept notice for the respondents, petitioner to serve set of papers upon the aforesaid council forthwith, list the matter on 28th. Next.
Grateful.
71, Reddy Mallappa.
Notice.
Interim order, my lords.
Interim order in bantu, sir.
That factory is in the residential area, my lords.
No, sir. Unless I hear them, Magala. Who are the respondents? Different GMCPC na? Yen challenge madradu?
The factory has been.
Yen challenge madidira?
The order of the annexure J, my lords.
Order,
Annexure J.
whose order?
Lower court order, my lords. In the appeal.
GMCPC ಆಗ್ಬೇಕಿದ್ದು. Compromise decree na?
No, my lords.
ಮತ್ತೆ?
It is a OS suit and a MA, my lords.
The petition, the registry to appropriately classify the subject petition, place it before the bench having roster. Yes, next.
72, Santosh Rao.
Husband, notice, next. Hello, wife. Notice, emergent notice to the respondent returnable by the 4th of December. Next.
73, Jay Shetty.
The learned counsel, learned AGA is
1 and
directed
2,
to
ma'am.
accept notice for the respondent. 1 and
2.
1 and 2, emergent notice to the other respondents. Returnable by the 5th of December. There shall be an interim order of stay spread for till the next date of hearing. Next.
74,
Same.
Same,
76, HR Kambiyavar.
same.
No, my lord. This is
75
under,
ಯಾಕೆ? ಎಲ್ಲ ಆಯ್ತು.
ಅದು ಕಮ್ತೆ ಅವ್ರದ್ದು.
ಕಮಿಟಿ ಅವ್ರದ್ದು ಆಯ್ತಲ್ಲ, ಕರೆಕ್ಟ್. ಕಂಬಿ ಅವ್ರು ಏನ್ ನಿಮ್ದು?
This is GST, this is a royalty matter, this covered by the Supreme Court.
ಕೊಡಿ.
Last paragraph conclusion ಇದೆ ಅಲ್ಲ.
ಕನ್ಕ್ಲೂಷನ್ ಮಾತ್ರ ಕವರ್ಡ್? ಅದೇ ತಾನೆ.
ಅಲ್ಲ, ಇಶ್ಯೂ ಇಸ್ ಕವರ್ಡ್ ಮಲ್ಲ. ಆ ಕನ್ಕ್ಲೂಷನ್ ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ಲ, ಅಷ್ಟು ಕೊಟ್ರೆ
ಸಾಕಾ?
ಅಲ್ಲ, I can urge before I get benefit ಮಲ್ಲ.
Yes, government.
And other issue is aware kept open.
2, 1, 2 AGA. 3 MB Kanavi.
4 also AGA ಮಲ್ಲ.
4, 5 AGA.
Please.
ಇದು ನೋಡಿದ್ದೀರಾ ಜಿ? ರಾಯಲ್ಟಿ.
Second and third prayer.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner, Jay Shetre, dismiss ಮಾಡಿದ್ದೀನಿ ಎರಡನ್ನು. No representation. Yes. The petitioner is before this court seeking the following prayer. ಎರಡರಲ್ಲೂ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ. The petitioner is before this court seeking the following prayer. The learned counsel of the petitioner submits that the issue in the list stands answered by judgment rendered by the apex court in ಇದು SCC ಇಸ್ಕೊಳ್ಳಿ ಕೊಡ್ತಾರೆ. SCC. So and so. The learned counsel, ಯಾವ paragraph?
Conclusion my lord.
Wherein the apex court
Capital
has held as follows. The learned AGA would not dispute the position with regard to the matter being covered qua the royalty is concerned, but will have to be considered by the appropriate authority as is directed by the apex court. In that light, the petition deserves to succeed, albeit in part, with a direction to the authorities to consider the
my representation annexure A also.
ಅದನ್ನೇ ಹೇಳಕ್ ಬಿಟ್ರೆ ತಾನೆ. Representation, by directing authorities to consider the representation of the petitioner, quay the royalty as is directed by the, and bearing in mind the observations made by the apex court in the aforesaid within 12 weeks from the date of receipt of the copy of the order, ordered accordingly. All other contentions remain
kept
open.
open.
77
ಯಾಕಂದ್ರೆ ಬೇರೆ ಇಶ್ಯೂನು ಇರ್ತಾವ.
ಭಾಳ ಇರ್ತಾವ ಬಿಡ್ರಿ ವಿಷಯ. 70? Notice.
Yes, Sanjay Chanal appears, my lords.
So and so
Standing.
accepts notice for
Both the respondents,
both
respondent
the
and one.
respondents. Yes. Petitioner to serve set of papers upon the aforesaid council, 28th.
Great.
Yes, next.
78 P.C. Gnanaya Swami.
Last occasion, my
Last
lord.
order. List of rowdies.
Oh. Instructions ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. Next week. Instructions ಬಂದಿಲ್ಲ ಇನ್ನ.
List delete ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. What is this?
He has acquitted all the.
Rowdy list ಅದು ಮಾತ್ರ ಅಲ್ಲ. You follow the judgment of the coordinate bench and then pass orders.
B.S. Prakash.
B.S. Prakash. ಮಾಡ್ಲಾ? The petitioner is before this court seeking the following prayer. The learned counsel appearing for the, heard so and so. Owing to the prayer of the petitioner, this court had on 30th October 2025 passed the following order. The learned AGA submits that the representation of the petitioner for deletion of his name from the list of rowdies in the third respondent police station would be taken strictly in consonance with law. Therefore, I deem it appropriate to dispose the petition directing the consideration of the representation of the petitioner, bearing in mind the observations made by the coordinate bench in B.N. Prakash versus Unit, State of Karnataka, 4254 of 2022, disposed on 22/4/2023. The other box birth on the Dikshit Sahab's order.
ತಮ್ಮದೇ
ನಂದೇ ಇದೆಯಾ?
ನಿಮ್ದೇ.
So and so. In the light of ಇಲ್ಲ ಇದೆ ಸೇಮ್ ಇದನ್ನೇ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಡಿ. So and so. In the light, the respondent states, which respondent, sir?
Respondent number.
3.
That's 3, 2 and 3.
2 and 3.
Respondents 2 and 3 shall consider the representation of the petitioner bearing in mind the aforequoted guidelines by the coordinate bench and pass necessary orders in accordance with law within 12 weeks from the date of receipt of the copy of the order, if not earlier. Yes. Ordered accordingly.
Ithinal Parasappa.
Clubbing of reference case is wrong. Learned AGA is directed to accept notice for
1 and 2.
1 and 2. Emergent notice to the remaining respondents. Next.
80 Anuradha RD.
Lok Adalat.
Short accommodation,
Why?
kindly.
Lok Adalat compromise.
Sorry, Lordship, I am not a counsel on record, Your Lordship.
Don't worry, madam.
She's, sure, may I
Petitioner
request
to serve on the counsel who represents the respondent in the trial proceedings. What is called in question is a compromise decree and a decree drawn on compromise in criminal miscellaneous 224 of 2024. In that light, hearing the respondent would be necessary prior to passage of any interim order. List on 25th November.
Obliged.
81 Manoj N. Bikananaur.
Select list of 2024.
Please, Your Worship, with regard to aided languages,
Sorry, but
2% weightage was not considered. I worked in that college since 2014 for a
it
meager
can't be by
pay.
way of an interim order, you can't do anything.
Because
1, 2, 3,
1 to 4.
4 HCGP, 5, 6 and 7 emergent notice returnable by 3rd December, list on 3rd December.
Your Lordship, seeking for the interim stay.
Interim stay ಹೆಂಗಾಗುತ್ತೆ?
Since Your Lordship, I worked in that.
Select list is 2024. 1 ವರ್ಷ ಆದ್ಮೇಲೆ stay ಮಾಡಿ.
There was a writ petition, in fact,
Maybe,
challenging that
sir.
selection list.
Maybe,
But there was no stay from that writ petition.
ಕೊಡಂಗ ನಾನೇ ಕೊಡ್ತೀನಿ.
The condition
ನೀವು
of
ಕೇಳದೆ ಬೇಕಾಗಿಲ್ಲ.
the condition of the private aided teachers is very
Definitely, it's a
worse, Your
relief that
Lordship.
should be granted by final hearing, not at the
In
interim.
fact, they work for a very meager amount. There will be some understanding of the education
All
institution.
law and sympathy is with you, but not interim order.
82, Umme Salman.
AGA.
16 years.
Rejection of
First time
parole. Rejection of parole application.
Rejection, go
Annex
through.
F. Page number 97.
Yes, 15 years and?
Yes, your lordship. First time parole, your lordship.
15 years, 9 months, 3 days, first time parole.
Yes.
302, na?
There are several cases.
How do you
in page
lordship?
number 3. In page
Any
number
cases
3.
yavaga?
ಇದು
Inside the prison?
SC number 2011 ಅಲ್ಲಿ ಆಮೇಲೆ
Get
17 ಅಲ್ಲಿ 17
get the information. Learned AGA is
Your
directed.
lordship, it's a 2 years. Your lordship,
Learned,
co-accused has been granted parole. Your lordship, he has undergone
learned
all the
AGA.
conviction, your
Wait,
lordship.
madam.
380 case.
Wait. ಯಾವ್ದು ಪಾರ್ಕಿಂದ ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಕೂಗ್ತಾನೆ ಇದ್ದೀರಾ? wait.
Your lordship, High Court, your lordship.
Learned AGA is directed to accept notice for respondent 2, 3, 4, 4, 5. MB Kanvi for the first respondent. List the matter on Friday.
Please.
Friday, but Thursday in fresh matters list.
Oh,
Yes,
bless
next.
84, Haji
Appearing
Salim.
for petition, my lord. My lord, appearing for petitioner. Order challenge. Appearing for petition, the challenge. The order passed by CGM Belgaum under section 14 of Surface Act. My lord.
ಆಯ್ತು, ಈಗ ಎಷ್ಟಿದೆ?
20,22,000 is the outstanding amount.
ಮನೇನಾ?
Money is only. House. Respondent is ready to pay 25% of amount within the area.
All right, you pay 10 lakhs now.
No, 5 lakhs, sir. My lord, the 25% of is 5 lakh 5,000. Is a loss of the deceased borrower.
The petitioner to serve on any panel counsel representing the respondent bank. The bank shall not take any precipitative action against the petitioner, qua the proceedings, subject to the condition that the petitioner would pay 5 lakhs within the next 3 weeks. List the matter on 28th November. In the event the petitioner would not pay the said amount by the said date, the respondent would be at liberty to take any action in accordance with law. Though the petition would not be entertainable, it is entertained only on the score that the petitioner is living in the said house and it is a residential property and would be on the streets if no protective order is granted. Yes, next.
85, Chan Baswaraj, C.S. Shettar.
My lords, the petitioner's land was acquired, my lords, and 85, my lords.
Information ಕೊಟ್ಟಿಲ್ವಾ? Rehabilitation officer.
Please. The land was acquired, my lords, and alternate land was not granted to us.
ಬಾಗಲಕೋಟ್ ಡೆವಲಪ್ಮೆಂಟ್.
Please, my lords, Bagalkot.
ಇಲ್ವಾ? ಯಾರ ಪೇರತ್ತಮ್ಮ? ಯಾವುದೋ ಮತ್ತೆ ನೋಟಿಸ್ ಕೊಟ್ಟವಲ್ಲ ಈಗ? ಬೆಳಗಾಂ ಅದು.
Shri Sanjay Channal is the counsel appearing for.
Accepts notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 27th.
Please, much obliged.
86, Roshan Saib Thapi.
27th November.
The petitioners have suffered ex parte order. The impugned order is at Annexure A.
Petitioner 1 AGA.
1 to 5.
1 to 5 AGA. 6.
Shivraj is Paduli.
Shivraj
Paduli, sir.
The petitioner is before this court calling in question execution ಹಾಕಿದ್ದಾರೆ ಈಗ.
Execution ಹಾಕಿದ್ದಾರೆ my lord.
Execution proceedings which arose out of an ex parte award against the petitioner. In that light, further proceedings before. In that light, there shall be an interim order as spread for. Copy code.
Please.
Yes, next.
87, A.B. Patil, M.B. Kanvi.
I beg to represent Mr. Patil. Petitions filed challenging the award of 100% of the
MSME.
tender, MSME. In this regard, the public policy is to grant 25%
if he comes within the price band of L1 plus 15%.
Ah.
Here, there are 4 qualified elements, including the
The
MSc.
issue is this.
Yes.
Whether in a public procurement,
Yes.
100% could be awarded to the MSME, or it should be restricted to 25%. That's the
That is the
issue.
issue. That is to encourage the MSCs.
For
A public
whatever
procurement
reason
body
it
is
is,
done.
whatever
25%.
reason, in the case here,
Yes.
100% is given to the MSCs. All right. You did participate in the tender.
I participated
Why
in
did
tender.
you
I was
participate
also
in
L1.
Why did you participate in the tender?
That is, then they allowed me to participate in the tender, though knowing that I'm only an MSME, not an MSc. So
You are also declared L1?
I am also declared L1. There are 2 other persons who are also declared L1. The MSc is also declared L1. All of them got the same marks in the technical evaluation.
Same marks.
Same marks. So when such a thing is there, then the procedure to be followed is page 21. Lordship may kindly see. Page 21, below the disclaimer, clause 15. Any ATC clause in contract GEM clause 4. So in case of multiple L1 bidders,
All right.
multiple against the service bid, the buyer shall place the contract by selection of a bidder amongst the L1 bidders through random algorithm executed by a GEM system. The GEM system automatically will do the
Select
lottery.
some. All right. What happened?
So suppose I am selected.
All right. Algorithm I understand, but what happened, Delhi?
They didn't do that. They straight away awarded 100% to the MSc without considering my bid. That's unconstitutional.
We have no choice to select, Lordship. It is the atom.
So did you put it to the GEM portal and algorithm has selected the MSME?
One second, Lordship. It is the GEM which has selected the respondent number 4. We have not selected the respondent 4. We have selected 7.
GEM did not file its counter here. GEM did not file its counter here.
Who is the GEM?
The GEM should say that it has done the algorithm.
ಏನ್ ಮಾಡಿದ್ರಿ? 4 ಸರ್ತಿ ಹಿಯರಿಂಗ್ ಆಗಿದೆ ಈಗ. I'll set aside everything.
Delhi, my lords.
What? Yeah, Delhi.
Parties from Delhi.
And Delhi is too far. Get it by mail, sir. List day after tomorrow in the fresh matters list. In the event the GEM, which respondent are you?
Number 2.
2. In the event the respondent number 2 would not come up with an answer as to selection of the successful bidder, this court would be left with no choice but to consider the submissions of the counsel for the petitioner and pass appropriate orders in accordance with law. List day after tomorrow in fresh matters list. Yes, next.
88, J. Gachinmat.
Interim, meantime, the interim stay may be extended.
Stay there.
Stay is there.
Interim order will be extended. Yes. Yes, next.
Petitioner, my lords, was appointed as a Hindi teacher, my lords, in the year 1995.
Notice.
Respond number 8, my lords.
1 to
1 to 6, my lords, government.
1 to 6 state. 7.
7, my lords. Earlier, J. Shetty has appeared, my lords, in the earlier round of
J.
litigation.
Shetty is directed to accept notice for the 7th respondent.
I will also take out notice in addition to that.
Learned counsel of the petition submits. Counsel J. Shetty had represented the 7th respondent in earlier proceedings. Therefore, J. Shetty is directed to accept notice. In the event the counsel would not accept notice, the emergent notice to the 7th respondent. Yes.
The date may be given. She is a retired employee.
Returnable by 3rd December, 4th December.
Great.
89, Vasudev Sai.
I filed suit for partition. As a counterblast, my lord, maintenance was filed against me. Meanwhile, I have lost job also.
Oh, yo.
Please, my lord.
Search a job, sir.
Allah, I am searching. I am dependent on my wife, my lord.
Oh.
Because of her, my lord, I am living in her residence. That's the problem.
Search a job. Idu yarig maintenance kotradu?
Parents.
Correct.
Allah, but I am not, my condition is not, financial condition is not there.
Search a job, sir.
They have all the property, my lord. I filed suit for partition. I'll search job, my lord. Meanwhile,
Good job, you search.
please. I am relieved, my lord.
What's your qualification?
I'm lecturer. MSc, MPhil.
MSc, MPhil.
Please.
ಹಾಗಾದ್ರೆ ಒಂದು 10,000 ಜಾಸ್ತಿ ಮಾಡೋಣ
ಅಲ್ಲ
ಮೇಂಟೆನೆನ್ಸ್.
ಹಂಗ್ ಬೇಡ. Kindly, my lord.
ಏನ್ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ರಿಲೀವಿಂಗ್ ಲೆಟರ್, my lord.
So what?
Contractual employee.
ಅದು ಯಾರಿಗೆ ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂದಾಗ ನೀವು ಒಂದ್ ಕೆಲಸದಿಂದ
Much before the order,
ಇರಲ್ಲ.
Much before the
All
order.
these will come, sir. ಏನ್ ಮಾಡಕ್ಕೆ?
Much before the order.
Maintain your parents.
ಅಲ್ಲ I'll
You
maintain.
maintain your parents, your wife will maintain you. Correct ಆಗುತ್ತೆ.
ಅಲ್ಲ financial condition is very much.
ತಂದೆ ತಾಯಿ ಕೊಡಕ್ಕೆ ಫೈನಾನ್ಷಿಯಲ್ ಕಂಡೀಷನ್. Yes, anything else?
Lord. Allah, he is only because he has filed suit for partition, my lord. The property has been alienated in the name of respondent number 1.
Only because ಅವೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. Under the Act Section 9 permits 10,000 rupees to be granted. It is granted.
Please.
Anything else?
These are the main points, my lord. He's lost his job. And there is another daughter also.
You are the son, sir.
Please, that is there.
ಆಮೇಲೆ ಬರ್ಲಿ. You should not fight shy of maintaining your parents.
Because I do not have a job, my lord, that is a difficulty.
Anything else? The petitioner is before this court seeking the following prayer heard so and so. The petitioner, the parents of the petitioner have registered before invoking section 9 of the Senior Citizens Act, have approached the deputy assistant commissioner. The assistant
commissioner alla 125 CRPC.
CRPC na?
Please, man. BNS is there.
Anyway, then we'll see. List emergent notice to the respondents returnable by 3rd December, 4th December.
Meanwhile, stay, my lord.
ಬರ್ಲಿ. Yes. Arrears ಎಷ್ಟಿದೆ? Arrears ಎಷ್ಟಿದೆ?
Arrears ಅಲ್ಲ, arrears around 40,000-50,000.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
50% may be deposited.
There shall be an interim order of stay as prayed for subject to deposit of 30,000 rupees before this court in the next 3 weeks. List the matter on 3rd December.
Obliged.
190 BN Mulimani.
Guest.
Yes, lecturer, Your Lordship, she has been terminated because as papers were not tallied on that.
They already terminated.
ಆಗಿದೆ.
ಅದು ಸೂರಜ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಇತ್ತಲ್ಲ ಕೊಡಿ.
ಆಗಿದೆ.
24-25 my lord, allowed to continue, whereas respondent number 3 has denied her accession for the re-entry. Hence,
ಅವರು ಫ್ರೀಸ್ ಆಗಿದೆ, ವಾಯ್ಸ್ ಬರ್ತಾ ಇದೆ.
according to Annexure D, the clause para number 3, 24-25ನೇ ಸಾಲಿನಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿ 25-26ನೇ ಸಾಲಿಗೆ ಮುಂದುವರಿಸಲು ಪರಿಗಣಿಸುತ್ತಿರುವ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರ ಅರ್ಜಿಗಳಲ್ಲಿ ಮಾತ್ರ ಅಲ್ಪ ಪ್ರಮಾಣದ ಲೋಪದೋಷಗಳಿದ್ದಲ್ಲಿ ಅವುಗಳನ್ನು ನಿರ್ಲಕ್ಷಿಸಿ ಅವರನ್ನು ಮುಂದುವರಿಸಬೇಕು. This is the clause as per which the petitioner claims her continuation, my lord.
Sir, ಒಂದು ನಿಮಿಷ ಇರ್ತೀರಾ? ಸೈಲೆಂಟ್ ಆಗಿ.
Your Lordship, for 24-25, Your Lordship, as papers were not tallied ಅಂತ ಹೇಳಿ not.
ಸೂರಜ್ ಅವ್ರದ್ದು ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, should we dispose it on that ground or just terminate ಆಗೋಗಿದೆ ಇಲ್ಲಿ?
ಹಾಗೆ
would secure instructions.
Please, Your Lordship.
Learned HCGP is directed to accept notice for respondents 1 and 2. Thursday ತಗೊಳ್ಳ ಅಥವಾ?
Please, Your Lordship.
Just on Thursday. Yes. Fresh matters. ಇವ್ರದ್ದು 3-4 ಇದೆ ಇವತ್ತು. Next.
91.
This I appear for the petition, my lord. I number 3 filed by the petitioner, Your Lordship, is the
DNA test ಬೇಕಾ sir?
Yes.
ಕೊಡಲ್ಲ.
Your Lordship, my case in.
Oh, way.
Even Your Lordship in the plaint also, Your Lordship, I averred in para number 10 of my plaint also, Your Lordship, I award that, Your Lordship, the petitioner.
Suit for what?
Suit for declaration that regarding the nullity of marriage, Your Lordship. And Your Lordship, in para number 16 of my plaint also, I specifically stated that the petitioner is ready and willing to medical checkup for DNA test, blood test of the petitioner respond number 2 to 4 and respond number 5, so that the truth will come out.
You're disputing
Yes.
the child, is it?
Yes. Because in the 1 month, Your Lordship, she left the company of the plaintiff, Your Lordship.
Oh, amale.
That, Your Lordship, 4 children are born. And even
Children?
4 children.
1 month Allah.
No, Your Lordship, not 1 month.
Then?
Not 1 month, Your Lordship. That, Your Lordship, I am seeking that. She is claiming that she will, out of marriage of the plaintiff, they may claim that, Your Lordship, they are the children of the plaintiff.
ಎಷ್ಟು ವರ್ಷ ಮದುವೆ ಆಗಿತ್ತು ಸರ್?
92, Your Lordship.
92 ಮದುವೆ ಆಗಿದ್ದು.
ಹೌದು.
ಈಗ ಡಿಸ್ಪ್ಯೂಟ್ ಶುರು ಆಗಿದ್ದು ಯಾವಾಗ ಸರ್?
Dispute, Your Lordship, I have filed, Your Lordship, in the suit, Your Lordship, in the year 19, in the MC number 2023, Your Lordship.
23.
23.
92 20 ವರ್ಷ ಆಯ್ತು.
Yes.
ಎಷ್ಟು ವರ್ಷ
They are
ಸಂಸಾರ
not
ಮಾಡಿದ್ದೀರಾ?
deciding, Your Lordship.
ಎಷ್ಟು ವರ್ಷ ಸಂಸಾರ ಮಾಡಿದ್ದೀರಾ?
Only 15 days, Your Lordship. 15 days. That I associated my, Your Lordship, in
ಬಿಡಿ 92 ಮದುವೆ ಆಯ್ತಾ?
Yes.
ನೀವು MC ಪೆಟಿಷನ್ ಹಾಕಿರೋದು ಯಾವಾಗ ಸರ್?
2023.
21 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
That, Your Lordship, they have not, because, Your Lordship, in the
No, 21 years, what did you do?
21 years, Your Lordship.
ಏನು
Even, Your Lordship, in para number 4 of my plain, I stated also that the respondent came to the petitioner to lead marital life after 15 days after marriage. The respondent went to parents' house after 15 days.
So 15 days
Yes.
ಅಷ್ಟೇ ಆಗಿದ್ದು.
ಅಷ್ಟೇ life.
4 ಮಕ್ಕಳಾಗಿದೆ.
So, Your Lordship, I also stated.
4
I also
ಮಕ್ಕಳಾಗಿದೆ.
implied.
ಆಮೇಲೆ 21 ವರ್ಷ ಆದ್ಮೇಲೆ
I
ನೀವು
also
MC
implied,
petition
Your
ಹಾಕಿದ್ರಿ.
Lordship, the respond number 5.
ಈಗ ಎಷ್ಟು ಕಾಸ್ಟ್
So, Your
ಇಂಪೋಸ್
Lordship,
ಮಾಡಬೇಕು?
can you see? I also implied defend number 5. That, Your Lordship, along with the company of the defend number 5, Your Lordship, their children are born. I specifically stated in that, Your Lordship, Mallava claiming to that I am the Mallava, Your Lordship, claimed to the wife of the plaintiff. And the defend number 5, Your Lordship, along with her, Your Lordship, out of relationship, these children are born. That is the crux of the matter, Your Lordship. That is the thing. And, Your Lordship, the trial court has rejected the IA number 3 only on the ground that, Your Lordship, it is a fag end of the evidence, the IA is filed. But it is matter of evidence, Your Lordship, it is posted for evidence. Not, Your Lordship, evidence is not completed. Even, Your Lordship, I have implied defend number 5 also. That, Your Lordship, along with her, Your Lordship, the relationship, the defend number 1, those children are born.
Oh, not with you.
Not with me. Even I implied defend number 5 in the present case also, in the suit also, Your Lordship. Even they not filed objections, they have not filed written statement before the trial court.
Anything else, sir?
That, Your Lordship, after considering, even, Your Lordship, the only on the ground that if Your Lordship, only on the ground that, Your Lordship, it is in para number 8 of my, in the order, it is fag end of the matter, Your Lordship, the I number 3 was filed. It only on the ground. But I also
ಸರ್ಪ್ರೈಸಿಂಗ್ ಇಸ್ 15 ದಿನ ಜೊತೆಗಿದ್ದಕ್ಕೆ 21 ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಾ ನೀವು ಮಾಡಕ್ಕೆ. ಸೊ 15 ಡೇಸ್ ಇಂಪ್ಯಾಕ್ಟ್ 20 ಇಯರ್ಸ್ ನಡೆದಿದೆ.
Yes.
ಪರವಾಗಿಲ್ಲ. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? ಕಾಸ್ಟ್ ಎಷ್ಟು ಅಂತ ಲೆಕ್ಕ ಹಾಕ್ತಾ
I'm not seeking because
ನೀವು ಕಾಸ್ಟ್ ಕೇಳಬೇಡಿ, ನಾನು ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ.
Yes, Your Lordship may impose. I am not come in the way, Lordship. Because, Lordship, it is a crux of the matter, Your Lordship.
What crux, sir? 21 years you take to
because
file
of the
MC petition, bring up all frivolous grounds saying that 15 ದಿನ ಮಾತ್ರ ಸಂಸಾರ ಮಾಡಿದ್ದು 21 ವರ್ಷ ಆದ್ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ದೀನಿ. What is that?
Even, Your Lordship, I have not made a averment regarding, Your Lordship, regarding the allegation regarding defend number 5, I can understand. Even in my written statement, in my plaint also, I stated in para number 13 that the petitioner has not treated the adulterous life of the respondent living with Hanma Gaji with a view to maintain dignity, respect and status of both the family of the petitioner and respondent number 1.
ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಇದ್ರ ನೀವು?
Yes, that is the
dignity of the family maintained.
And, Your Lordship, in the 2016, she has filed a suit for partition separate position. That the defend number 1. That is also there, Your Lordship.
Heard the learned counsel, sorry, the petitioner is before this court seeking the following prayer. Heard the learned counsel appearing for the petitioner. The petitioner is the
also relying upon 2 judgments, Your Lordship.
Please, sir, very important. ಹಂಗಾರೆ ಕಾಸ್ಟ್ ಅಂತೂ ಹಾಕ್ಲೇಬೇಕು ಕೊಡಿ.
Even your lordship, to prove the lordship regarding that DNA test also is necessary.
Correct.
This honorable court also has held that your lordship.
Which honorable? My order?
Not.
Oh, no, sir, these are all old. 2025, my judgment is there. Yalla, DNA will not be given just for the asking like this. It affects right to privacy. You can't expect DNA to be bartered like this. Every husband will come up with this plea that the child is not mine. Yakandre alimony maintenance ella irutte.
No, because lordship, I also made a different number 5 also party, also award regarding the allegation also.
The petitioner is before this court. Yaar petitioner neeva?
Yes, plaintiff.
73 ವರ್ಷ.
Yes. 73. The MC petition also filed in the 2023.
2023 73 years ನಿಮ್ಗೆ ಆವಾಗ ಈಗ ಒಂದು 75 ಆಗಿದೆ. ನಿಮ್ನೆ ಯಾರೋ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕು, ಇನ್ನೇನ್ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತೀರ? ನಿಮಗೆ ಯಾಕೆ ಈ ವಯಸ್ಸು DNA ಅದೆಲ್ಲ?
Because lordship, they claim that your lordship, they are the children of out of born of the marriage with the defined number 1. So in future also your lordship there will be problem.
In future, ಯಾವ future?
Because lordship, they claim the property will also your lordship.
ಅಲ್ಲ ಯಾವ future?
Because lordship, when they are not born, defined number 2 to 3, they are not born out of the marriage of the defined number 1. That is also there.
You can live for 100 years, but ಬೇರೆ ಮಾತು, you are talking as you are 25. And future problem ಆಗ್ತಾ ಇದೆ.
Because in the 2000 also filed a suit for partition also. In my when the plaint also I stated regarding the filing of the suit by the defendant.
The petitioner is before this court calling in question rejection of an application in IA3 in MC 152 of 2023 dated 7/7/2025, rejecting the claim of the petitioner for a DNA test of.
Even your lordship, after living the so many years, the plaintiff, the respondent number 1, defined number 1, has filed the maintenance case of 2016.
We are on DNA. Yes. The petitioner is the plaintiff. The petitioner is the husband. The first respondent, his wife. ಎಷ್ಟು ಫಸ್ಟ್ ಯಾರು?
ಫಸ್ಟ್
ರೆಸ್ಪಾಂಡ್ 50 ವರ್ಷ. ಫಸ್ಟ್ ವೈಫಾ? ಓನ್ಲಿ ವೈಫ್?
ಓನ್ಲಿ ವೈಫ್.
You are 75, she is 50.
Yes.
The petitioner, ಯಾಕೋ ಇದರಲ್ಲಿ ಬೇಕಾಗ್ಬೋದು ಒಂದು ನಿಮಿಷ. Emergent notice to the respondents returnable. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings. List the matter on 27th. Further proceedings before the concerned court shall remain stayed.
92?
Only because looking at the age of the petitioner and the wife. 25 ವರ್ಷ. Yes.
92, Pramod is Dharwad.
Limitation. ಯಾರು ನೋಡ್ತಾ ಇದ್ದೀರಾ?
I'm just intrigued by the survey parody is my.
That's all right. Yes, on limitation it is rejected. Learned AGA, Central Excise, sorry, Tirumalesh.
Yes.
M. Tirumalesh is directed to accept notice for both the respondents. Petitioner to serve set of papers upon the aforesaid counsel list on 28th. We'll dispose it on that day.
Please.
Yes, next.
93, SC Hiremat.
Directing the petition respondents not to interfere with the civil matter. They are calling and making the petitioner to sit.
ಇದಕ್ಕೊಂದು mandamus ಬೇಕಾ?
My lords,
Yes.
kindly see the prayer, my lords.
ಇಲ್ಲ ಪ್ರೇಯರ್ ಏನಾರು ಇರ್ಲಿ, ನೀವು ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಲಿ ಹೋಗಿ
We are not interfering.
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಾ?
ಎರಡು ಕೇಸ್ ನಮ್ಮ ಬಳಿಕ ಬಂದು they have bet my client. There are 2 cases registered
against you.
Against me one and against.
ಹಂಗಾದ್ರೆ ಅವ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲೇಬೇಕು. We can't stop investigation.
Enquiry ಕರೆಸಲೇಬೇಕಾಗ್ತದೆ, ಕರೆಸ್ತೀವಿ ಅವ್ರನ್ನ. And the second
the petitioner is before this court seeking the following prayer. A strange mandamus is sought at the hands of this court by seeking a direction to the third respondent, the station house officer, not to interfere with a civil dispute and pressurize the petitioners to arrive at a settlement. The allegation is that the police are wanting to settle the dispute. The submission in thin air cannot be accepted. Crime is registered, a case and counter case is registered both by the petitioner and against the petitioner, and the police are investigating into the crime.
Case investigation, let them investigate.
Correct. Investigating into the crime. The prayer that is sought indirectly stops such investigation. Therefore, such a prayer cannot be granted. If the petitioner is aggrieved of, it is open for the petitioner to avail of such remedy as available in law, ordered accordingly. Next.
94, page 5.
The government has issued an endorsement by
KPID.
rejecting. Yes, ma'am.
One nimsham. 1 AGA. 1, 2, 3,
1 to 5 and
4,
13.
5 AGA. Government of India.
And 13, my lords.
MB Kanvi 5. Mikala Society. Petitioner to serve. ಅಲ್ಲ ಸಾರಿ ಇನ್ನು ಯಾರು ಬಾಕಿ ಇಲ್ವಾ ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಪಾರ್ಟಿ
ಇಲ್ಲ ಮ್ಯಾಮ್
20 ಜನ ಇದೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
ಇವ್ರಿಗೆ
ಅಲ್ಲ 9 to 12 emergent notice. 13 Viresh Budihal 27th. Next.
Please.
95, Shashank.
27th ಅಲ್ಲ 4th December.
GST matter, my lord. The show cause notice has been issued based on the CBDT data. This honorable court has the lordship judgment, my lord.
ಕೊಡಿ ಟ್ಯಾಗ್ ದಿಸ್ ಪೆಟಿಷನ್ ಇದು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಅಥವಾ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಕೊಡಿ
And date may be given, my lord.
AGA
No, my lord. Girish Hulmani for respondent 234, my lord. Girish Hulmani.
ಸೇವಾ ಟ್ರಸ್ಟ್ ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
Learned Counsel Girish Hulmani is directed to accept notice for the respondents.
234, my lord. Respondent number 1 is the Union of India, MB Kanvi.
MB Kanvi 1, 234 Girish Hulmani. List on Thursday in fresh matters.
Yes.
Chinmaya Seva Trust. ಅವ್ರಿಗೆ ಹೇಳಿ ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ.
Yes, yes.
ಇಲ್ಲ ಈಗಲೇ ಕೇಳ್ಕೊಂಬಂದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ.
He is not there, my lord.
All right. Yes. Next.
6 Gaurashankar Mode.
Externment. Externment.
No, madam. I have filed wakalat for the in the.
Filed wakalat.
Rejected, my lords, by the Dharwad.
Without any reason, the wakalat has been rejected.
Without reason.
Page
They are
number
stating.
13.
Page number 13.
Where have you filed wakalat?
Page number 13, 19.8, I have filed wakalat for respondent, for defendant number 1 and 2.
Initially, it's accepted. Thereafter,
The emergent notice to the respondents.
I mean, direct take
1, 2, 3.
4 and 5
ಇಲ್ಲ
dispense.
ಬೇಡದೆಲ್ಲ ಮಾಡ್ತೀರಾ.
4 and 5 dispense, sir.
No notice need be issued to 4 and 5 as no relief is sought against them. List tomorrow in fresh matters list. We'll dispose it tomorrow.
Please.
Yes. Next.
7 Ravi Hegde.
Interest.
Yes, 97, 98, 100, 187.
97, 98, 100, 197. All
180
Prashant
187.
Vaswani is directed to accept notice for the respondents. ಯಾವತ್ತಿಗೆ ಹಾಕಿದ್ದೀನಿ ಅದು?
18th,
List on 18th.
187 serial.
187 ಬರ್ಕೊಂಡು ಐಸಿ. 70 ಎಷ್ಟು 97
98, 100, 187.
107 ಇಲ್ವಾ?
ಇಲ್ಲ
107 ಇಲ್ಲ.
ಬರುತ್ತೆ.
99 Shivraj Balloli.
Your lordship, for petitioner in this matter, your honor.
Anganwadi.
Pardon your
90?
lordship.
Anganwadi. 9.
99.
Anganwadi.
Anganwadi.
Anganwadi education. And for petitioner in this matter, your honor, the brief facts of the case is the petitioner's mother was.
Compassion appointment ಇವ್ರಿಗೂ ಇದೆಯಾ? ಮದರ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ
ಇದೆ.
ಇದೆಯಾ? The learned HCGP is directed to accept notice for the respondents. The vacancy created on account of the death of the mother of the petitioner shall not be filled without the leave of the court. List the matter on 18th.
Your honor, I also asked for interim care.
ಅದೇ ಕೊಟ್ಟಿದ್ದೆ.
Oblige you.
101 Girish Yadwad.
In mandamus, petitioner is the wife, my lord, response number 7 is the husband.
ಆಯ್ತು, ನಿಮ್ಮ ಹೆಸರು ಬರ್ಬೇಕಾ?
Please, my lord.
ಯಾಕೆ?
I am the first wife, my lord.
First wife. Second wife has a problem ಅಲ್ಲ ಸರ್, ಏನ್ ಮಾಡೋದು?
But my lord,
ನೀರಾವರಿ ನಿಗಮ ಯಾರ ಪೇರ?
Chetan Munoli.
Huh?
Chetan Munoli.
Council Chetan Munoli is directed to accept notice for 1 to 8.
1 to 6, my lord.
1 to 6. Husband is there, huh?
Yes.
Husband is there, huh? Get him. We'll ask him, yes.
Yes.
Emergent notice to the 7th respondent written. The petitioner shall serve the 7th respondent by way of hand summons.
Yes.
List on 28th.
Yes.
Next.
102, MS service.
The petitioner,
Alternate job.
alternative
Later
job, my lord,
job, Prashant.
rejected, my lord. Prashant was.
Council Prashant Hosmani is directed to accept notice for the respondent. Light job.
These medical certificate, my lords, on basis of which lighter jobs have been, my lords, they are claiming. But these medical certificates, my lords,
ಏನ ಸೆಟ್ರೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಎಷ್ಟು?
in fact, lords, I am trying to get these matters disposed of since January. What matters were referred to mediation. There, my lords, only few cases could be settled. But as far as the corporation is concerned, my lords, the offer is we will continue them in the lighter job. Let them bring the certificate under the new provision.
Written those orders on what
That,
happened?
lords, the matter has been, lords, have been dragged on. my lords.
Numbers ಕೊಡಿ ಎಲ್ಲ ಒಂದ್ಸರಿ dispose
Please,
ಮಾಡಿ.
please.
I think there are 20 or 30.
More than that.
Then give all the
Please.
numbers. We'll list them all on probably on 21st or 21st we'll see.
Please.
Till then, we will continue.
ನೀವು continue. The petitioner is said to have been offered a lighter job by the corporation owing to his disability. In that light, the petitioner shall not be disturbed from the said job till the next date of hearing. The learned counsel Prashant Hosmani is directed to accept notice for the respondent to respond. Copy the petition to serve set of papers upon the aforesaid counsel forthwith. List kodi full.
Please.
We'll post them all on 21st November.
Yes.
102, Tunya Tata Banki.
Challenging the
103 and 104. ಇನ್ನೊಂದು ಯಾವ್ದು ಇದೆಯಲ್ಲ?
no, only two.
ಎರಡೇನಾ? No? What is 138?
138, my lord, that is compensate appointment regarding.
Land acquisition matter, compassionate appointment, ah?
No, my lord, sorry.
38 ಏನು?
138.
ಅದೇನು?
Lord, regarding lake, my lord.
Where is Mrityunjay?
138.
Lordship, that is regarding acquisition, your lordship.
ಎಲ್ಲ acquisition ಮೂರು ಒಂದೇನೆ.
That is different, your lordship.
Yes, one. Learned AG is directed to accept notice for the first respondent, Belagavi Gurudev Gachinmat. Belagavi Urban Development Authority, Gurudev Gachinmat was the second respondent. ಎರಡರಲ್ಲೂ ಅಷ್ಟೇ same.
Please.
103 and 104. 105, 138 ಬೇರೆ. Yes.
105, BN Mulimani.
Guest.
My lordship.
ನೀವು ಸುಮ್ಮನೆ ಇರಿ ಸರ್, ಒಂದ್ ನಿಮಿಷ. Thursday ಅಲ್ಲ? Learned HCGP is directed to accept notice for the respondents list on Thursday.
Same
In fresh matters list.
106,
106 is same, yes.
125.
107,
DNA. Why ನಿಮಗೆ DNA?
My lord, there is a dispute regarding the marriage between the first petitioner and the husband, my lord.
Yes, how old are you?
It's immediately after this, and they claiming that marriage has been performed. In the 2018 itself, it is the marriage is in the 2018. From then itself, it is disputes has started. Habeas corpus is filed.
ಅದಲ್ಲ ಆಯ್ತು, 2018 marriage, ah?
Marriage, they claiming that marriage has performed 2018. No marriage has been performed, my lord.
Oh.
No solemnity of marriage.
ಇದು MC ಹಾಕಿದ್ದು ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಹಾಕಿದ್ದಲ್ಲ ಯಾವಾಗ?
MC husband has filed, that has been rejected. Against that, the appeal has been filed, which is pending. 101/838 up to.
DNA is allowed, ah?
Each has been allowed, my lord. DNA has been allowed.
You are the husband?
I am for the husband, my lord.
Who sought DNA?
The wife has sought the DNA of second petitioner child with the father.
ಉಲ್ಟಾ ಆಗುತ್ತೆ. Yes, anyway, the emergent notice to the respondent. Petitioner shall serve on the council who represent the first respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 4th December. Further proceedings before the concerned courts. The order impugned shall remain state till the next date.
Much obliged.
Yes, next.
Okay, Chetan Kulkarni.
Seek for passover, madam. Kindly pass over.
Oh, you pass over.
The council on record.
Arms license. ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ?
ಅವ್ರಿಗೆ ಇದು ಏನು ಇದು ಇಲ್ಲ, ಥ್ರೆಟ್ ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ, renewal of arms license ಹೊಸ್ತೇನು ಕೇಳ್ತಾ ಇಲ್ವಲ್ಲ? ಇದ್ದಿದ್ ಮುಂಚೆ. There was a crime, I think I have quashed it.
Yes.
Then why?
Take instructions.
The learned AGA is directed to accept notice for respondent 1 and 2. The learned AGA to secure instructions as to why the license of the arms license of the petitioner which was subsisting earlier has not been renewed, is not being permitted to be renewed. List the matter on 18th, on 19th in fresh matters list. Next.
110, Santosh B. Mallikwad.
I appear for petition seeking regularization, temporary lecturer, PUC, 1 and 2 malord respondent.
ಎಷ್ಟು ವರ್ಷ?
15 years.
One state ಅಲ್ಲ?
Yes, 1 and 2 state malord, third respondent is the institution.
1 and 2 state, 3 emergent notice returnable by 4th December, list on 4th.
Please.
Next.
Along with my hand
Petitioner to
summons.
serve set of papers and so on so.
Please.
Copy ಇದೆಯಾ madam? Copy ಉಂಟಾ? ಸರ್ ಬೇಡ. ಸರ್ ಬೇಡ.
Sadhana is Desai.
ಸರ್ವನ್ ಬೇಡ.
Appearing for petitioners, my lord. Kindly pass over, kindly hear at 2:30, my lords.
2:30 ಟೈಮ್ ನೀವು ಫಿಕ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಪಾಸ್ ಓವರ್.
Please, my lords, seniors held up in other things.
ಪಾಸ್ ಓವರ್.
112.
Yes.
Indappa Malli.
Plus petition is the land loser, lords. Plus without showing the name, lords, in the notifications, award has been passed.
The petitioner.
Page number 146, award, lords.
Union of India.
Lords.
Highway ಶಿವಸಾಯಿ ಪಾಟೀಲ್ ಇಲ್ವಾ?
Lords, BP Matapati.
BB ಮಠ್ ಧಾರವಾಡದ ಇದು?
Please, ಇಲ್ಲ.
ಇದು ಬೆಳಗಾವಿ.
ಬೆಳಗಾವಿ. BP Matapati is panel advocate.
ಆಯ್ತು. BB Matapati accepts notice for respondents. The petitioner to serve set of papers upon the aforesaid council forthwith. List the matter on next Tuesday, beda. List the matter on 19th. The respondent shall not precipitate the matter till the next date. Yes.
113, Santosh Nambal.
Madam, D and D.
And for respondent.
Respondent number 2 and 3.
Kims.
Teams, please.
Dispose ಮಾಡದ next week ತಗೊಳ್ಳ.
Next week, maybe 17th or 19th.
Learned Council, Learned HCGP 1, 2, 3 and 4.
3 and 4.
So and so. List the matter on 18th in fresh matters list.
3 and 4.
Not so.
114, Jagdish Patil.
Writ of mandamus, my lords, seeking direction for implementing annexure H.
Page 67, comment. 67 order implement ಮಾಡಕ್ಕೆ ಇನ್ನೊಂದು mandamus ಬೇಕಾ? Learned AGA is directed to accept notice for the respondent. 1, Mohammed Ali na yaradu?
Mohammed Ali.
Please, my lords. Respondents 1 to 4, my lords.
Mohammed 1 to 4 ಅಲ್ಲ sir. 1 AGA, 2 to 4 Mohammed Ali. Petitioner to serve set of papers upon ಯಾರು ಮೇಡಮ್ ಲಾಡ್ಕಾನ ಮೊಹಮ್ಮದ್ ಅಲಿ ಯಾರು? ಮೊಹಮ್ಮದ್ ಅಲಿ. The petitioner to serve set of papers upon the aforesaid council forthwith. List the matter on 28th November. Or 26th November. Next, yes.
115, Shekhar Gowda Namnodi.
Compassionate
Library
appointment.
supervisor.
Please, my lords, covered by lordship's decision, my lords.
Learned HCGP is directed to accept notice for
1, 2 and 6. 1, 2 and 6.
1, 2 and 6.
3 to 5, Shivraj Hiremat, sir, appears.
3 to 5 Shivraj Hiremat.
Para number 11, my lords, page number 8.
Yes, madam. ನೋಡ್ತೀರಾ? Close ಮಾಡಿ. Consider.
Shivraj Hiremat is also.
I'll serve copy on him, my lords.
So and so. List day after tomorrow in fresh matters list. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
Please.
Next.
116, Vijay Kumar B. Mulatti.
The petitioner has prayed for a mandamus
Annexure F, my lord, seeking for direction to be issued to the respondent number 2 to implement his own order. Lord, sir, petitioner is the owner of land bearing survey number 441.
To implement his own order, learned AGA is directed to accept notice for the respondents. Pollution Control Board, yaru?
3, my lord, Gachinmachi.
Pollution Control Board.
And 4 is, my lord, Shivraj Mudhod.
3, Gurudev Gachinmat. 4, Shivraj Mudhod. 1, 2 and 5, AGA, 17th.
Much.
Yes.
117, I.Y. Patil.
General parallel lords.
Parallel.
302 lords.
302, ಎಷ್ಟು ವರ್ಷ?
3 years, 1 month.
3 years, 1 month.
Is in discussion.
ಸ್ವಲ್ಪ ದಿನ ಇರಿ. Yes. List the matter on 5th December. Yes. Huh? Learned AGA is directed to accept notice for the response. Next.
118, Girisham Patil.
Parole matters, my lords.
Offense.
302, my lords.
ಎಷ್ಟು ವರ್ಷ?
I am inside prison since 8 years. I have been already released once. And my lord, the only reason why my application has been rejected is that there are 2 cases pending against me.
Cases when? Inside the prison or what?
Inside the prison, but in one case I have been acquitted. And in another case I have been bailed out, my lord.
Learned AGA is directed to accept notice for a respondent, secure instructions with regard to the conduct of the petitioner in the prison and make submissions on the next date. List the matter on 18th.
And those
On
orders
10th.
also,
List the matter on 10th, Monday.
and those orders also have annexed, my lord.
Right.
Yes, obliged.
Monday. Thanks.
King Girishadwa.
Please, for petitioners now, seeking mandamus, my lord. Earlier, the petitioners who approached this honorable court, my lord, this honorable court has directed the respondent to allot the alternative share in life compensation, my lord.
Alternate site.
Please, my lord.
Sorry.
Now, I submitted the representation.
One. Notice ಕೊಡುವ ತಾಳಿ.
Please.
Learned AGA.
1.
1. Housing board ಯಾರು?
HR Gundappa, sir.
Huh?
HR Gundappa.
Words. 2 and 3. Petitioner to serve ಬರ್ಕೊಂಡ್ರ? AC. ಬರ್ಕೊಂಡ್ರ? So. List the matter on 18th.
120, Santosh Kumar.
Lord, I appear for petitioner, my lord, seeking terminal benefits, my lord. Denied on the ground that criminal proceedings are pending. Identical matter, division bench of this honorable court has directed. Shivraj Mudhod sir appears for all respondents.
2016 in the pending ಇದೆ. Counsel Shivraj Mudhod is directed to accept notice for
All respondents.
all respondents. Petitioner to serve set of papers upon the aforesaid counsel forthwith.
Please.
List the matter on 20th.
Same stage, my lord.
Same.
Covered in that.
Correct.
Please.
List the matter on, hello, one ನಿಮಿಷ. List the matter on 20th November in fresh matters.
Please.
Yes.
Obliged.
121, Girishadwa.
This is regarding the recreation club, my lords. Earlier, this honorable court has granted, my lords. Now I am seeking interim stay, my lord. Now,
Interim stay why?
please, my lord. Now, my lords, what happened is, in the earlier, whenever new officer has come to the jurisdiction, my lord,
Obviously, sir, new officer ಬಂದಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
orally command, my lord, close the my club, my lord. More than 2 months, more than 1.5 months, my lord.
When Yes, the learned AGA is directed to accept notice for the respondent. List day after tomorrow in fresh matters list.
Please.
Copy code.
Please.
Interim stay and dispose ಮಾಡ್ತೀನಿ.
Please.
Next, yes.
122, Arunel Nilopal.
Minutes. Challenge to impute resolution, my lordship. Dated 5/9/2025, wherein the
Third, the learned
respondents.
counsel appearing for the petitioner. The ಯಾರ್ಯಾರು ಮೇಡಮ್ ಇದು? 1 2 to 7 emergent notice. 2 to 14 emergent notice. The resolution dated 5/9/2025 shall remain stayed only if it is not given effect to or implemented as on today. Yes.
Grateful, my lordship.
123,
If
Gangadhar.
it is given effect to and implemented as on today, it shall remain subject to the result of the petition.
At least, my lordship, policy decision, not to take any policy decisions, my lordship. If it is implemented.
If it is implemented, that we'll see.
Grateful.
You move the matter if there is any urgency that way. Yes, next.
123, Gangadhar.
Lord,
ಈ
seeking
mandamus to comply, ಏನ್ ಪ್ರತಿ ಸರಿ ಹಿಂಗ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
I will just take instructions.
ಇವರು ಕಂಟೆಂಪ್ಟ್ ಟೈಮ್ ಆಗಿ ಹೋಗಿದೆ ಅನ್ಬಿಟ್ಟು ಹಾಕಿರಲ್ಲ, ಹಂಗಂತ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಬಾರ್ದು ಅಂತಿಲ್ಲ.
First time it is.
ಅದು ಗೊತ್ತಾಯ್ತು, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕಾಸ್ಟ್
1 to 5.
1, 2, 3 ಎಲ್ಲರಿಗೂ
1 to 5 government.
1 to 5.
6 emergent notice.
6 emergent, ಬೇಕಾ 6?
Please, ಅವರೇ ರಿಲೀಸ್
ಫ್ರೀಸಿಂಗ್ ಗೊತ್ತಾಯ್ತು. 6 emergent notice.
Please.
Returnable by 3rd December. Yes, list
Please.
on 3rd. Next.
124.
Yeah, 3rd in fresh matters list.
Appearing for petitioner, my lord. Appearing for petitioner, my lord, in this case.
ಅಂಗನವಾಡಿ
My lord, ಹೌದು. My lord,
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗೋಗಿದ್ಯಾ?
selection. ಇಲ್ಲ, ಇನ್ನು ಫೈನಲ್ ಲಿಸ್ಟ್
Issued
ಮಾಡಿಲ್ಲ.
a provisional list, my lord. Next year, F.
ಪ್ರಾವಿಷನಲ್ ಲಿಸ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೀವಿ ಅನಕ್ಷರ.
ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್?
They have not
ಇನ್ನು
considered.
ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. They may try-
ಕನ್ಸಿಡರ್ ಬಿಡಿ. Learned HCGP is directed to accept notice for the respondents. Will dispose it directing to consider the objection.
Please, my lord.
The petitioner is a participant in the selection process instituted for the purpose of appointment of Anganwadi worker. ಏನಿದು? ಅಂಗನವಾಡಿ ವರ್ಕರ್ at ಹಬಲಕಟ್ಟಿ, ಅದೇನೋ ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಇದೆ. ತುಂಬಾ ಕಾಂಪ್ಲಿಕೇಟೆಡ್.
ಹಲಬಗಟ್ಟಿ.
ಅಲ್ಲ ನೋಡ್ಕೊಂತಾರೆ. So and so. The learned counsel for the petitioner, R.P. Somshekhara, would submit that the petitioner, pursuant to the notification of the provisional select list, has submitted detailed objections. The apprehension is that the final select list would be notified without considering the objections of the petitioner. Therefore, the objections of the petitioner, in the light of the said apprehension, the learned HCGP, Srimati Girija Hiremat, would submit that the objections of the petitioner, if not already considered, would be considered strictly in accordance with law, and appropriate orders would, steps would be taken. In the light of the said submission, I deem it appropriate to dispose the subject petition with a direction to the respondent selecting authority to consider the objections filed by the petitioner to the provisional select list and take the issue to its logical conclusion, ordered accordingly.
ಒಂದ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ, ಅಲ್ಲಿ ಕಾಸ್ಟೇಟ್ ಅಲ್ಲಿ ಡಾಟ್ರಾಫ್ ಅಂತ ಹಾಕ್ಬೇಕು, ಸಣ್ಣ ಅಪ್ ಅಂತ ಟೈಪ್ ಆಗಿದೆ.
ಕಾಸ್ಟೇಟ್ ಅಲ್ಲಿ
ಡಾಟ್ರಾಫ್ ಅಂತ ಟೈಪ್ ಹೊಡಿಬೇಕು, ಸಣ್ಣ ಅಪ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಪರ್ಮಿಟೆಡ್.
ಗಂಡಸರು ಕೊಡ್ತಾರ?
ಇಲ್ಲ, ಅದು ಡಾಟ್ರಾಫ್ ಅಂತ ಟೈಪ್ ಆಗ್ಬೇಕಾಯ್ತು, ಸಣ್ಣ ಅಪ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಅದಕ್ಕೋಸ್ಕರ ಪರ್ಮಿಟೆಡ್ ಕರೆಕ್ಟ್ ಟೈಪೋಗ್ರಫಿಕಲ್ ಎರರ್.
ಫಾದರ್ ಕರೆಕ್ಟಾ?
ಫಾದರ್ ಕರೆಕ್ಟ್.
ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಯಾವ್ದ್ರದ್ದು?
ಡಾಟ್ರಾಫ್ ಅಂತ ಹಾಕ್ಬೇಕು.
ಡಾಕ್ಟರ್ ಅಂತ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಗೆಸ್ಟ್ ಥರ್ಸ್ಡೇ ಸೇಮ್ ಆರ್ಡರ್. ಬೇರೆ ಗೆಸ್ಟ್ ಇತ್ತಲ್ಲ, ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್? 133. ಹಾ, ಅವ್ರಿಗೆ ಸುಮ್ಮನೆ ಇರಕ್ಕೆ ಹೇಳಿ.
126 ಸಂಜನಾ ಸ್ಮೃತಿ.
Second respondent mode rejected, ma'am.
ಸಂಜನಾ ಮುದಳ್.
126.
120
mode 126 mode.
ಇರೇನಾ?
Covered matter mode.
Page 123 covered. Yes.
127 ರವಿ.
Same order is page 123 ಅಲ್ಲಿ ಏನಿದೆ ಸೇಮ್ order. Next. ಬೇರೆ ಯಾರಿಲ್ವಾ ಫ್ಯಾಮಿಲಿಲಿ?
Father is
ಬ್ರದರ್, ಡಿಸ್ಟೆಂಟ್ ರಿಲೇಟಿವ್ ಎಲ್ಲರಿಗೂ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಬಿಡೋಣ. Learned counsel Prashant Hosmani is directed to accept notice for. ಪ್ರಶಾಂತ್, ನಿಮ್ ಸ್ಕೀಮ್ ಸ್ವಲ್ಪ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡ್ಬಿಡಿ. ಬ್ರದರ್, ಸಿಸ್ಟರ್, ಡಿಸ್ಟೆಂಟ್ ರಿಲೇಟಿವ್ಸ್ ಯಾರು ಬಂದ್ರು ಕೊಟ್ಬಿಡ್ಬೋದು. ಇದರಲ್ಲಿ ಬ್ರದರ್
there is one judgment, my lords.
ಕೊಡ್ಬೋದು ಅಂತ.
ಹೌದು, that is also my lords have to file a writ appeal.
ಅದು ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಇನ್ನೊಂದು ರಿಲ್ಯಾಕ್ಸೇಷನ್. No, you set the things right.
Because in that case, my lords, it seems there was nobody except on that protects, my lords. It was, but again, that is being challenged, my lords.
ನಗ್ತಾ ಇದ್ದಾರೆ. ಏನ್ ಅದು ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾರಿಗೆ ಬೇಕಾದ್ರೆ ಕೊಡ್ಬೋದು.
May I make one? 99 death, my lord.
Death 99, sir.
Now, my lord,
25, my lord, is the representation.
that financial distress, my lord, is also
26 years admele.
Maybe disposed.
Dispose, dismiss.
Please.
Not correct.
Please.
Not correct. The petitioner is before this court seeking the following prayer. The learned counsel Prashant Hosmani is directed to accept notice and is heard in the matter. The learned counsel for the petitioner takes this court through the documents appended to the petition seeking to prima facie demonstrate that the petitioner, who is the brother of the deceased employee of the corporation, who died in harness in the year 1999, is entitled to be considered for appointment on compassionate grounds in the year 2025, which is 26 years after the death. The said submission does not merit any acceptance, as compassionate appointment is granted to the family to tide over the crisis that happens on the death of the breadwinner of the family. The crisis would be immediate crisis, except in exceptional circumstances where there is default or fault on the part of the employer in not considering the application for long time. In the case at hand, if any direction is issued to consider even, would run foul of the judgment of the apex court in the case of State of Jammu and Kashmir versus Sajjad Ahmad Mir, 2006, 6 SCC page 766. Therefore, the finding no merit in the petition stands rejected.
Please.
128, Prashant Iskardewar.
Please. Therefore, the petitioner,
Your
Lord,
Lordship,
as
age-
per Annexure C,
Your Lordship,
on
AG
28
Vijay
10
Kumar is appearing, Your
2025.
Lordship.
Yaru?
AG Vijay Kumar.
Vijay Kumar.
Lords can permission.
Vijay Kumar, ಕಾರಿಂದೆಲ್ಲ ಬಿಡಲ್ಲ ನಾನು.
My lords, 230. I beg for my lords forgiveness. Please, my lords. Please.
230,
Please.
yes.
Obliged.
ಕಾರು ಪಾರ್ಕು ಇದೆಲ್ಲ ಆಗಲ್ಲ. ವಿಸಿಲ್ ಬನ್ನಿ
ಕ್ಷಮಿಸಿ ಸ್ವಾಮಿ, ಕ್ಷಮಿಸಿ. Please, please.
129, Muralidhar KB.
I'm sorry.
Regularization. Regularization.
Fourth time endorsement.
Fourth time ಬರ್ತಾ ಇದೆ ನನ್ನ ಮುಂದೆ.
ತಮ್ಮ ಮುಂದಿನ ಈ ಕೋರ್ಟಿಗೆ fourth time
Endorsement fourth time.
endorsement fourth time.
10 years not completed.
ಯಾವತ್ on what day?
Your Lordship, earlier.
Dates ಹೇಳಿ.
Gates, my lord, he was appointed in year 1990. Lord, he was terminated, my lord, in order to appoint some other person in the year 1992. Lord, he made a representation to the authority, my lord. Before that, he had been to labor and conciliation officer, which did not work out. He had made a representation to the authorities, my lord, for his reinstatement, my lord. The respondent, my lord, the second respondent, my lord, while passing the order, quoting the government order that, my lord, a person who has served for more than 240 days cannot be terminated. And a junior engineer, my lord, is entitled for regularization if he is appointed after 1784 and before 15/10/1992. My lord, the second respondent held that, my lord, he is entitled for continuation of service, but without back wages. My lord, when he gave a representation, my lord, after 10 years of service, my lord, that my case has to be regularized. The second respondent issued an endorsement saying that, my lord, you were reappointed on 5/7/1999. Therefore, my lord,
ಉಮಾದೇವಿ 10 years ಆಗಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಉಮಾದೇವಿ ಹೇಳ್ತಿಲ್ಲ ಅವರು. Intervening period cannot be counted for the purpose of service.
Madam, if continuity of service is granted,
yes,
accepted.
This court, my lord,
back wages ಅದೆಲ್ಲ ಇಲ್ಲ,
ಬೇಡ,
ತೊಂದ್ರೆ
ನಾನು
ಇಲ್ಲ.
ಕೇಳ್ತಾ ಇಲ್ಲ.
But service will have to be taken, regularization will have to be considered.
Please.
Your Lordship, if at all we have taken it also, Your Lordship, it is comes 7 years ಅಷ್ಟೇ ಬರುತ್ತೆ ಅವ್ರದ್ದು.
99 ಇಂದ.
Please, Your Lordship,
ಅಲ್ಲ, ಎಲ್ಲಿಂದ
99 ಇಂದ
7 years?
ಅವ್ರಿಗೆ continuation ಇಲ್ಲ, Your Lordship.
Continuity of service ಇದೆ ಅಂದ್ರೆ ಈಗ?
Continuity of service ಅಂತ this court has passed an order, my lord.
After order of this court, Your Lordship.
2007 ಅಲ್ಲೇ ಆರ್ಡರ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ. They issued an endorsement saying that it amounts to new employment. Once again, he challenged this order, that order. This court once again held that you are not looked into
ಇದು
that.
fourth time.
Fourth time ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಹೊಸ ನೇಮಕಾತಿ ಆಗತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ. This time we will stop it.
Please.
ಯಾಕಂದ್ರೆ ಒಂದು 2 ಲಕ್ಷ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರೆ ಅವು ಮತ್ತೆ ಫಿಫ್ತ್ ಟೈಮ್ ಬರಲ್ಲ ಇಲ್ಲಿ.
Your Lordship, I'll file my objections, Your Lordship.
Learned HCGP is directed to accept notice for the respondents.
One and two. ಇಬ್ರೆ 1 and 2.
Respondents objections if any by the next date, list on 3rd December. The learned counsel appearing for the petitioner takes this court through the documents appended to the petition seeking to prima facie demonstrate that the action of the state in repeatedly driving the petitioner to this court is arbitrary, for the reason that the petitioner, who was appointed in the year 1990, was though terminated in the year 1992, there has been an order of reinstatement and continuity of service which was denied has been granted by a coordinate bench of this court. Therefore, he has continuously served from what date, 1992?
Till now he is sorry.
1992 till 1990 till this date, and is now seeking regularization. It has been denied on the score that the re-employment of the petitioner has been a new employment, ignoring the fact that there is an order of continuity of service passed by the coordinate bench of this court. Therefore, the respondent shall explain as to why exemplary cost should not be imposed upon them for deliberately ignoring the order of the coordinate bench which directed continuity of service. List the matter on 4th December.
Same stage.
Same stage.
Please.
ಈಗೇನ್ ಮಾಡಲ್ಲ ಬನ್ನಿ, ಸರಿ ಹೋಗುತ್ತೆ.
Agreed.
130 J.
Petitioner, my lords, was working as a principal. My lords, and he has been placed under suspension. Impugned order is at Annexure D, page 26, may kindly be seen for a moment. The reasons assigned, my lords, for suspension is that, my lords, there was an RTI activist, my lords, who visited
Correct,
the
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. HDMC ಹಿಂಗೆ ಆಗದ ಸಸ್ಪೆನ್ಷನ್ ಎಲ್ಲ.
lords, Annexure D, my lords, just
ಡಿಫೆಂಡ್ ಮಾಡ್ತೀರಾ ಇಂಥ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ಗಳನ್ನೆಲ್ಲ?
ಇಲ್ಲ. I have not defended any suspension orders, my lords. Kindly see, my lords, page 26 for a moment. Page 26, my lords.
No problem, 1 minute.
Paragraph 3.
ಯಾರು residential schools, Christ, who appears?
My lords, I have to take out notice, my lords.
No, there is some counsel. Learned counsel, Sarvan D. Nagaya. Learned counsel D. Nagaya is directed to accept notice for the first respondent. You will find him.
Please.
He is the counsel who represents them. So and so. List the matter on 17th. ಯಾವಾಗ suspension ಆಗಿರೋದು?
Lord, suspension, my lords, was passed on 29/9. Kindly see the reasons, my lords, for a moment.
Reason ಏನಿರ್ಬೋದು?
ಅಲ್ಲ, reason ಅಂದ್ರೆ ಅವ್ರು active activist, he has come to the school. ಅವ್ರ ಸ್ಕೂಲಿಗೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನಮ್ ಸಸ್ಪೆಂಡ್
3 ತಿಂಗಳು 3 months ಆದ್ಮೇಲೆ ಸ್ಟೇ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ನೀವು ಸರ್ವ್ ಮಾಡಿದ್ರೆ I will
take out hand summons. I'll take out hand summons.
Better petitioner to serve the respondent by way of hand summons. The petitioner is before this court calling in question the order of suspension of the petitioner. The order of suspension reads, the reason to pass the order of suspension is as follows.
Paragraph 3, my lords. ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಪರಿಶೀಲಿಸಲಾಗಿ ನಾಗರಾಜ್ ಕಳಸಾಪುರ,
The
that is
preamble to the order of suspension is as follows, page 26. A perusal at the order would clearly indicate that there is no application of mind on the part of the competent authority as obtaining under sub-rule 3 of Rule 10 of the KCS CCA 1957, which mandates consideration and application of mind while placing the placing any government servant or employee under suspension. In the light of the lack of reasons and lack of application of mind prima facie, the order of suspension shall remain stayed.
Correct.
Yes. Next.
131 Srinivas Nayak.
Lord, application seeking interim Lord relief.
Identical order ಒಂದು ಮಾಡಿದ್ನಲ್ಲ ಇಲ್ವಾ?
ಇದೆ ನಂದೇ.
ಅದಕ್ಕೆ ಕೊಡಿ.
ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್
ನಿಮ್ದೆ
ಅಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರೋದು
ಅದು ಕೊಡಿ. ಇದನ್ನ ಫಾಲೋ ಮಾಡಿ ಮೊನ್ನೆ ಯಾವ್ದೋ ಬರ್ದೆ ನಾನು, ಅದಕ್ಕೆ ಹಂಗಾಗಿ ಗೊತ್ತೆ. Yes. Learned AGA is directed to accept notice for respondents.
1, 3 and 4. 1, 3 and 4.
ಇವರಿಗೆ
ಅನ್ಸ್ಟೇಟ್ ಇಲ್ಲ
ಡಿಸ್ಪೋಸ್ ಮಾಡದ ಇದನ್ನ ತಗೊಂಡು
ನಾವಿಲ್ಲ 1 to 4 ಅಲ್ಲ ಮಾಡ್ಬೋದು, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು.
ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ, ಯಾರ್ಯಾರು ನೋಟಿಸ್ ಬರ್ಕೊಂಡ್ಬಿಡಿ ಅಲ್ಲಿ.
1, 3 and 4 GA, Lord, and dispensation for R2. I'll file them.
Main memo, but learned counsel for R2 ga?
R2.
Learned counsel for the petitioner submits, no relief is claimed against the second respondent. In the light of the said submission, at the risk of the petitioner, notice, service of notice upon the second respondent is dispensed with.
Yes.
It's covered by this Punacha sir.
Yes.
132 Highway Party.
Parole.
Marriage, for marriage purpose.
Marriage?
He's putting.
Yardo?
His
His marriage?
Convict, lords.
Convict is getting married.
Yes, lords.
The marriage card also produced, Lord.
Lords. 3 cases conviction and another 3 cases are pending. As kindly see, conviction
14 years.
imprisonment certificate, page 12.
Huh?
Page 12.
ಯಾವತ್ತಿದೆ ಮದುವೆ?
December 6, Lord. Marriage card also put at page number 20, Lord. Earlier time when the granted the parole, engagement is taken place.
Earlier ಮದುವೆಗೆ ಅಂತಾನೆ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ engagement ಆಗಿತ್ತು ಸ್ವಾಮಿ. Engagement ಕೊಟ್ಟಿತ್ತು ಸ್ವಾಮಿ. Marriage is fixed.
ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮ್ಯಾರೇಜ್ ಆಗ್ಲೇಬೇಕಲ್ಲ?
14 ವರ್ಷ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎಷ್ಟು?
14 ವರ್ಷ ಇದ್ದಾರೆ.
14 ವರ್ಷ ಇದ್ದೀರಾ?
ಜೈಲಲ್ಲಿ.
ಓ, ನಿಮ್ಗೆ ಏಜ್ 32. 18 years ಗೆ ಕನ್ವರ್ಟ್
ಅವ್ರದಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಹುಡುಗಿದ್ದು ಸ್ವಾಮಿ, ಅದು ಏಜ್ 32.
The convict age ಎಷ್ಟು? The petitioner is said to be the fiancé of the convict, is wanting to get married to the convict. This court on an earlier occasion had granted parole to the convict on a petition filed by his brother for the engagement ceremony. The convict has been in prison for the last 16 years and has availed parole on several occasions.
14 years, Lord.
14 years, and has availed parole on several occasions. The offense alleged are the ones punishable under section 302, 326 and 323 of the IPC. In the light of the earlier grant of parole for the engagement ceremony, and now the fiancé is seeking release of parole of the petition of the convict for a marriage, which is said to be performed on 6/12/2020, which is slated to be performed on 6/12/2025. I deem it appropriate to grant the petitioner parole for a period of
90 days.
ಮದುವೆಗೆ ಸಾಕು. Yes, for a period of 60 days. ಸಾಕಲ್ಲ? 60 days. Same conditions ಹಾಕ್ಬಿಡಿ.
133 ಬೇನ್ ಮೂಲಿಮನಿ.
Guest lectures.
Guest. ಅವ್ರಿಗೆ ಸುಮ್ಮನೆ ಇರಕ್ಕೆ ಹೇಳಿ. Same Thursday, same order.
134 ಗಿರೀಶ್ ವಿ ಭಟ್.
With the commutation while retirement.
ಇದರಲ್ಲಿ I want to write how commutation works. ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ವರ್ಕೇ ಮಾಡಲ್ಲ. ರಿಕವರಿ ಬಿಯಾಂಡ್ ಎ ಪೀರಿಯಡ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ಇದು 5,05,000 was the sanctioned amount. 6,60,000 already recovered.
The 1 and 2 HCGP, 3, 4, 1, 2, 5 HCGP, 3, 4 KL.
Shriyarsh Nilopant is also there.
Sriharsh Nilopant, 3 and 4. Petitioner to serve set of papers upon the aforesaid council forthwith. There shall be an interim order spread for till the next date of hearing. List the matter on 5th December.
Please, Manas.
Yes, next.
35 J. Tata Bangi.
Compassionate appointment.
Compassionate.
My representation at G, annexure G. Page number.
ನೀರಾವರಿ ನಿಗಮ.
Please, KNN.
ಯಾವ ಡೇಟ್ ಆಫ್ ಡೆತ್ ಏನು ಇದರಲ್ಲಿ?
Lord, actually 2011 date of death, my lord. After 2 months, I have given representation.
Application ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, then.
Who appears ನೀರಾವರಿ ನಿಗಮ?
Rajshekhar Burji, sir.
Rajshekhar Burji. Council Rajshekhar Burji is directed to accept notice for all the respondents. Petitioner to serve set of papers upon the aforesaid council. List the matter on 5th December. Next.
136 Srinivas Nayak.
Voting.
Voting ಇಲ್ಲ ಇದು. Defer ಮಾಡಿದ್ದಾರೆ. President election is been deferred twice.
Why?
First instance it was for
Yes.
non quorum.
Ramesha, ಇವರ ಮಾರಿಡಿನ.
But he appears for returning officer.
Who?
Baramgowd.
ನೀವಿಲ್ಲ ಬಿಡಿ. Baramgowd. Why deferred? Take your instructions. Learned Council Baramgowd is directed to accept notice for ನೀವಿಲ್ಲ Rajay.
State is not a party.
One Baramgowd, two.
Two, my lord, it may be dispensed with.
Two ಬೇಡವಾ?
ಬೇಡ. Society formal party.
One. Two memo ಕೊಡಿ.
I'll
Council for the petitioner files a memo seeking dispensation of issuance of notice to the second respondent dispensed with at the risk of the petitioner. Yes.
Lord,
We'll list on Thursday.
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 Because there is a
I know
mandate.
the urgency, sir, yes.
There is a mandate under the.
Thursday, we'll dispose it on, let him get instructions.
Yes.
137, Sangrami School Karni.
The petitioner is challenging annexure H, my lords. KSSIDC,
KSIDC.
please, my lords, had allotted a plot, my lords.
Balance sale, who appears KSIDC?
Gurudev Ganchinmat sir appears.
Learned Counsel Gurudev Gachinmat is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 17th in fresh matters.
Praying for an interim order of stay, my lords.
The
Annexure H.
status quo where the property be maintained till the next date of hearing.
Please.
List on 18th of the matter.
Oblige.
Next,
58, Mrtyunjay Tata Bangi.
where the land acquisition.
Your Lordship, petitioners.
Learned AGA is directed to accept notice for the respondents. You are in possession.
Please, Lordship.
Prayer ಅಷ್ಟೇ ಇರೋದು anyway. For the respondent, 1, 2, Krishna Bhagya, ಯಾರು KBJNL? AGA, 1, 2, 5, 6, 7, 5, 6, 7, ಆಮೇಲೆ 3 and 4. KBJNL ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? You are there? ಮೃತ್ಯುಂಜಯ ಹಳ್ಳಿಕೆರೆ.
Avinash Angdi.
Sorry. Avinash Angdi is directed to accept notice for respondent.
3 and 4.
Respondents 3 and Mikkorge. State ಯಾರಿಗೆ ಹೇಳಿದೆ ಅವ್ರು ಮಿಕ್ಕಿದ petition to serve set of papers upon the aforesaid council. 28th.
Please.
Yes.
139, BC Gnanaya Swami.
Memo for withdrawal in terms of memo.
Petitioner number 12 man.
12
First. Yes.
ಅವ್ರು ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು ಇಲ್ಲ ಅವ್ರು ಅಷ್ಟೇ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ ಸರ್. In respect of 12 man.
In terms of memo.
Please. And date may be fixed man, it is small. Next week ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್.
2022 ದಲ್ವಾ?
ಹೌದು.
List on 7th.
Please.
ಬೇಡ. We'll take it on 17th November. Next.
140. Vinay
Withdrawal.
Kotelgi.
Memo for withdrawal.
I may permit to withdraw the.
Thank you, sir.
141, Avinash Mangri.
Your Lordship has directed me to get the judgment, or recent judgment on 376. Promise to marry.
Fakirappa. So you've got it. Either up to the latest judgment, I've covered everything.
Please.
That's why I asked you to get it. Very refer ಮಾಡಬೇಕಾಗಿಲ್ಲ.
From para number 9 to remaining.
My judgment.
Please.
Amol Bhagavan is also there. That's the latest. Madhyana order pass.
Oblige. Grateful.
Respondent is served unrepresented in
Agir.
230 dictate.
Oblige.
142, Raviraj Patil. Awaiting.
Post immediately after service of notice upon the sixth respondent.
142, 144 and 145. Let's in this, I undertake to appear for respond number 6.
One ನಿಮಿಷ. Saurabh ಯಾರಿಗೆ?
Respond number 6, unserved respond number 6.
Learned counsel so and so undertakes to enter appearance for the sixth respondent. ಎಲ್ಲದರಲ್ಲೂ?
Same.
Thus completes the service of notice.
Notes one submission. If the parties are to be relegated to section 70 minutes, I've casted my vote which is kept in the sealed cover. Your Lordship, in that,
order.
This is covered by your Lordship's judgment. Delegation of a same person for more than 2 times for elections in a cooperative society.
That may not be the case as per the instructions
Anyway,
because
then list the matter tomorrow in fresh matters.
I seek 1 week's time for filing of statement in that case, Milords, because it appears by a new board he has been redelegated. I'll just take instructions to that regard.
Because I have myself, a division bench ಏನಾಯ್ತು?
Division bench ಅಲ್ಲಿ interim order ಕೊಟ್ಟಿದ್ದು.
Stay ಆಗಿದೆಯಾ? ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ? So then we'll follow it.
1 week's time to file my statement.
Learned counsel Saurabh seeks a week's time to file interim order ಇದೆಯಾ?
Just the votes to be kept in a separate sealed cover.
List the matter on 17th in fresh matters list. Objections if any.
One submission, my lord. Board comes to an end on November 10th, my lord. So, my lord, before the prior date.
10th
Statement ಹಾಕ್ಲಿಕ್ಕೆ time
ಅಲ್ಲ
ಬೇಕಲ್ವಾ
prior
ಅಣ್ಣ?
date ಇದೆ ಯಾಕಂದ್ರೆ 10th
7th 3 ದಿವಸದಲ್ಲಿ ಹಾಕಿ objection ಹಂಗಾರೆ list on 7th.
6, 7, it's some functions in the home. I request on 10th itself, Milords, I'll meet.
10th.
Obliged.
146, Subhash Tebaddi.
Here in this insured,
Office objections que maintainability stands overruled.
the insured himself is filed the claim petition under seeking.
List tomorrow and fresh matters list. Yes.
Hearing on AM matters, 147, SN Irgupi.
Recalling the order.
Following IA number 1, production of documents.
ಅಲ್ಲ ಇದ್ಯಾವ್ದು recalling the order ಅಂತ ಇದೆ?
ಅದೇ IA number 1 for production of document.
Dismiss ಆಗಿತ್ತಾ?
Reject ಆಗಿದೆ because he was not present.
For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the order dated 6/8/2024 stands recalled. The application in IA 1 of 2025 seeking production of documents is restored to file. The IA 1 of 2025 shall be considered along with the main matter. Post the matter in B group. Oh, yes. Next.
148, Priyanka H. Pawar.
This I may permit it. My lord, in page 55 annexure.
Permission denied. ಹೇಳಿ.
In page 55 annexure K, my lord, I had challenged suspension order. Suspension order was challenged. In meanwhile, my lord, cancellation order was passed. Annexure K, my lord, the writ petition was dismissed with the liberty to challenge it. My lord, notice annexure in page 54. One notice was, my lord, issued, calling me upon to reply within 3 days, which was on 10/6/22. On 13/3, my lord, order of cancellation is passed.
Where is that order?
My lord,
Notice. Page 55, Justice Devdas order.
55 there was a order challenging me to.
ಆಮೇಲೆ ಏನಾಯ್ತು?
My lord, in page 54, 3 ದಿನ notice ಕೊಟ್ರು 10/6 ಗೆ.
10/6/2022 3 ದಿನ notice ಕೊಟ್ರು.
Notice ಕೊಟ್ರು. 13/6 ಗೆ order ಮಾಡ್ಬಿಟ್ಟು cancellation. My lord, annexure L in page 58. Relevant portion 59. Within 3 days, my lord, on the third day it has
13/6/22. ಅಷ್ಟೇ. Close. The petitioner is before this court seeking the following prayer. Heard the learned counsel Sadiq Godwala appearing for the petitioner and
ಅವ್ರದೇ ಇರ್ಲಿ ಒಂದು ಬ್ಯಾಗ್.
ಆಯ್ತು. ಹೆಸರೇನು?
Priyanka Pawar.
Priyanka Pawar appearing for the petitioner. The learned counsel, ಸ್ಟೇಟ್ ಮಾತ್ರ ತಾನೆ? ಬೇರೆ ಯಾರು ಇದಾರೆ?
ಇಲ್ಲ, ಅವರು ಪಾರ್ಟಿ ಅವ್ರ ಹೆಸರು ಹಾಕಿದ್ದಾರೆ ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಅಂತ. By mistake, my lord, earlier advocate, he has named his name.
The heard so and so. Okay. The petitioner is allotted a license to run a fair price shop. The license is suspended. During the suspension of which is called in question in writ petition 101,996 of 2022. The said petition comes to be disposed on the ground that during the subsistence of the said petition, an order of cancellation of license is passed. The coordinate bench disposes the petition by the following order. What follows is a notice issued to the petitioner, show cause notice issued to the petitioner on 10/6/2022. The show cause notice directs the petitioner to submit the reply within 3 days from the date of receipt of the said notice. The notice is dated 10/6/2022. Upon what day it is served is not forthcoming. The impugned order is passed on 13/6/2022, 3 days after the issuance of, 3 days after the date of issuance of notice to the petitioner. Therefore, the petitioner could not object to the petitioner, therefore none of the submissions, reply al kotre?
Reply illa, nam mutte illa.
Therefore, the petitioner could not submit his reply to the show cause notice as the order is passed even before the ink on the show cause notice could dry. In that light, there has been blatant violation of principles of natural justice in the case at hand. Therefore, without going into the merit or demerit of the claim or defense of the petition of the respondent state, I deem it appropriate to set aside the order passed, which is in violation of principles of natural justice, and direct the respondent to afford an opportunity to the petitioner to submit his reply to the show cause notice dated 10/6/2022 and then take the issue to its logical conclusion. In the light of the said circumstance, the order impugned is rendered unsustainable. For the aforesaid reasons, the following order. writ petition is allowed in part, the order dated 13/6/2022 stands quashed. The petitioner becomes entitled to all consequential benefits that would flow from the quashment of the order. The respondent shall now grant adequate opportunity to submit, for the petitioner to submit his reply to the show cause notice dated 10/6/2022, ordered accordingly. Yes, next.
49, Girish Patil.
My lord, I appear for the petitioner. My lord, it is a time barred claim for the alleged my lord, deficit stamp duty, hopelessly time barred. The matter is covered by judgments of this honorable court.
So I pray 1 week time. Yes, you want to appear in this.
The learned, heard the learned senior counsel Nayak appearing for the petitioner. The learned AGA submits that the additional advocate general would be making his submissions. List the matter on 18th in preliminary hearing.
Please.
18th. Grateful.
150, Ravi Hegde. Ravi
Delay.
Hegde, RN Javed.
Review petition.
My lord, minor 3 children.
Minor 3 children.
My lord, in this
Oh,
case,
this
the
is
deceased
minor-
having the minor 3 children and the wife and the mothers only allowed this case, my lord. The remaining,
Mother is 77 years old.
No, he was
bedridden.
telling minor wife.
Beloved.
Last time.
my lord, 3 children, only, see, having the 70 years old and having the pension and the other.
1,000 rupees pension.
Apportionment. Correct agide, no review.
50%, what about the minor children?
ನೀವು ಯಾರು?
Wife. ಅಲ್ಲ ವೈಫ್ಗೆ ತಾಯಿಗೆ ಅಷ್ಟೇ 50-50 ಕೊಟ್ಟು ಮಕ್ಕಳಿಗೆ ಏನ್ ಮಾಡು?
ವೈಫ್ ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ 50% ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ?
ಮಕ್ಕಳು
ಅಲ್ಲ ಅವ್ರು 70 ಇಯರ್ಸ್ ಮತ್ತೆ ಇನ್ನ ಅವ್ರಿಗೆ 2 ಜನ ಮಕ್ಕಳು 3 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ. ಅವ್ರು 70 ವರ್ಷ. ಈಗ 50% ಅಂದ್ರೆ ಮಕ್ಕಳು ಸ್ವಲ್ಪ ಯಾಕೆ ಮೈನರ್ ಇದ್ದಾಗ ಅವ್ರಿಗೆ ಕಾಲೇಜ್ ಎಜುಕೇಶನ್ ಆಗ್ಬೇಕು, ಇನ್ನು ಲೈಫ್ ಲೀಡ್ ಆಗ್ಬೇಕು. ಅವ್ರ ಎಂಡ್ ಇದ್ರಿಗೆ ಬಂದಿದೆ.
ಆಯ್ತು, ವಿಲ್ ಸಿ. Afternoon will pass the order. To pass over. ಬೇಡವಾ?
ಇಲ್ಲಿ ಪಾಸ್.
ಮನೆಗೆ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ.
ನಾಳೆ ತಗೊಂತೀನಿ. ಲಿಸ್ಟ್ ಟುಮಾರೋ.
ಬೇಡ.
ಪಾಸ್.
ಇವತ್ತೇ.
151, Girish V. Bhatt.
Appointment to the post of Hindi teacher under Christ Milots. What had happened is earlier in the 2003, some of the Vidya Hindi Parangat.
Yes. Not to be seen.
Lord, I held up in quote number 2.
We'll vacate all interim orders.
Total, I was there.
In the connected matter, she is seeking Pastor Milos, but Milos.
Veena Hegde.
Notification is of 2017. Final selection list was on 9/6/2020. After participating in the selection process, having failed, now they are before this score in 2024.
The statement Milos regarding having failed would not be true, Milos, because I am in the selection list. The question is, when in 2003 Hindi Parangat and some other courses are declared as equivalent. 2017, before passing their calling for the applications itself, the government has revoked those degrees to be equivalent. Now, there is a vacuum created. Those degrees which the respondents have, private respondents have, is not considered as equivalent to the regular courses. Now, Milos, pursuant to that also, Milos, they have called the application and we have the regular degrees. And Milos, instead of selecting us, Milos, they have continued with the degrees which have been declared to be non-equivalent. At any length of time, Milos, they cannot regularize it.
List the matter. All applications pending would be considered along with the main matter. List the matter of preliminary hearing on 18th.
Please, grateful.
We'll close this.
Please.
52, Surabhi Kulkarni.
For the petition, my lords.
Early hearing.
My lords, the reason is this, my lords, there is an interim order, my lord, but interim order, my lords, they are not allowing the petitioner to join for the duty.
Right job.
My lord, the reason is that they are stating that they relieved the petitioner from the service, but it is subsequent to the interim order, my lords, that is 13/1/2025.
Date of relief. Reason for relieving?
He has worked there for
terminated.
He has worked there for it's an administrative transfer. After 12 years, Lord, he has been transferred to another division.
12 years.
My lord,
12 years.
May I submit two submissions, my lords. The petition has been transferred on administrative grounds, my lord, along with 43 employees, my lord, who have been transferred on request. My lord, the regulation, my lord, does not permit, my lord, the transfer of division-wise posts, my lord, in a routine or casual manner. Only in extraordinary circumstance, my lord, with reasons they have to transfer, my lord, past the order.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಅಲ್ಲಿದ್ದೀವ್ರು?
12 years.
It's a division post, my lords, KSRTC.
What happens
Anything else, sir?
From Chikkodi,
ಮಾಡಿದ್ದಾರೆ?
from Chikkodi to Belgaum?
Khanapur. It's
It
a
comes under
distance, my lord. is
Belgaum division.
Inconvenience, my lords, to the petitioner.
ಯಾವ್ದು ಯಾವ ಇನ್ಕಮ್? ಚಿಕ್ಕೋಡಿಯಿಂದ ಬೆಳಗಾವಿ.
Allah, it is Khanapur, my lord. He is native is, my lord, Vichapur.
List tomorrow in fresh matters.
Please.
ಅಲ್ಲ ಅಷ್ಟೇ, ಕ್ಲೋಸ್ ಇಟ್. ಸಾಕು 12 years ಇಲ್ಲಿ. ಮನೆ ಪಕ್ಕದಲ್ಲಿ ಆಫೀಸ್ ಇರ್ಬೇಕು ಅಂದ್ರೆ ಆಗಲ್ಲ ಸರ್. ಅಷ್ಟೇ.
It is neither his service, his seniority, nothing will be affected, my lords. It will carry all those that he has worked.
Entry order ಇದೆಯಾ?
There is, my lords.
That is my grievance, my lords. Entry order, my lord, has not been given effect to, my lords, by the corporation.
It is subject to his joining the duty. Relieving order is also passed. Thereafter, my lords, he has obtained.
Relieving is subsequent to the interim order.
Tomorrow we'll relieve this petition.
Please.
153, Kushal V. Bolma, Mbikandvi.
The matter arises under the GST.
Yes.
And I have filed application for adoption of additional grounds, my lord.
Will be considered along with the main matter.
If that may be admitted, if my learned friend has no
The
serious objection.
application in IA 1 of 2025 for additional grounds will be considered along with the main matter.
Lordship, would like to give a specific date, my lord, if it's not.
Yes, sir.
This is a shorter matter. Can
Maybe.
we just dispose of?
Interim order ಇದೆ sir, yes.
Yeah, interim order.
List the yeah,
Interim order is there.
no, yeah, yes. List the matter on, should not say yeah,
18th or 19th, if it's convenient to, 19th or 20th,
19th,
19th.
yes.
Oblige, my lord, for final disposal.
That we'll see.
154, Kartik Anchari.
Appear for the petitioner in this case, Madam. 154. The issue stands covered by your lordship's judgment for allegations pertaining to 2016 to 18. Articles of charge are issued in 2024 onwards, Madam.
Delay.
Delay, squarely on the point of delay. This,
Retired employee, yeah.
retired employee. Both of them are retired. One retired in 2020, one in 23.
214 2A B2. Anything else, sir?
I statement of objection, my lord.
No, yes.
Corporation.
ಆಯ್ತು ಸರಿ. The learned counsel, the respondent seeks 10 days time finally to file statement.
I'm told day after tomorrow a similar batch is coming up.
But objection ಆಗ್ಬೇಕಲ್ಲ ಅವ್ರು anyway. The learned senior counsel Vikram Holigold appearing for the petitioner submits that the issue in the list stands answered by plethora of judgments rendered by this court. The learned senior counsel submits that the petitioners retire on attaining the age of superannuation in the year 2018 and the articles of
20
charge.
and 23. 20 and 23, correct. 23.
20 and 23, yeah.
Yes, ma'am. There are two petitioners. There are two petitioners.
All right, but how is it then 214?
No, now one retires in 2020, one retires in 23. Now my contention is 2024 they issue articles of charge for alleged irregularities in the year 2016 to 18.
Correct. 2016 to 18.
Yes, ma'am, correct.
But ಅಲ್ಲಿ 2020 ರಿಟೈರ್ ಇದಾರಲ್ಲ ಒಬ್ರು.
Correct, that is true. I'll make out specific.
So and so. ಏನ್ ಹೇಳ್ದೆ? Wait. No. 2020 and 2023 and the allegations pertain to between 2016 to 18 and would submit that the issue, the inquiry is impermissible in the light of rule 214 to 8. Which organization is this?
KPTCL.
Government servant,
KPTCL.
KPTCL, our separate is
171B.
171.
Yes, in terms of 171B. Yes, next. List the matter on 10 days time. List the matter on 18th. Yes, next.
Great.
155, Mahbul Ahmad Empati.
Challenging Lok Adalat decree, my lords. The decree has been drawn without
Notice
my
ಆಗಿದೆಯಲ್ಲ?
notice agide, my lords.
Dispensation
Of order sheet, my lords. Typed copy of the order sheet.
For the reasons indicated in the affidavit accompanying the application, being satisfied with the same, IA for dispensation is allowed.
My lords,
Post the matter in preliminary hearing on 18th. Next.
Small issue, the decree has been passed without my consent and no signature is.
We'll send it back, sir. Yes.
Please. Grateful.
156, Afshan Abdul Aziz.
What is this tender?
I appear for respondent, file for vacating the stay, ma'am.
Dispensation same order ಮಾಡ್ಬಿಡಿ for being satisfied so and so. ಏನ್ tender?
Lord, the postal department has called tender.
List tomorrow in fresh matters list.
Lord, I filed an IA is not put up.
The registry to put up the application seeking vacation of the interim. Tender matters, they should get over fast. Next.
157, Saurabh Hegde.
My lords, may I request 10 days time? The instruction not yet received, my lords.
Learned AGA seeks 10 more days time to file statement of objections. List the matter on 20. List the matter on 20th November.
In the fresh
Objections,
matters.
if any, by then.
In the fresh matters.
No, preliminary hearing. Next.
158, Sunil Court.
Lord, appear for the petitioners in this case. On the last occasion, my lord, Mr. Gachinmat, my lord, entered appearance for respondent
He
three.
is here, sir.
He has
He has entered the court hall also.
His name is not shown, my lord, in the list. As well, my lord, Mr. Kausalgi's name is also not shown.
Even my name is
I appear for respondent number 6 in this matter, my lords.
Registry to print the name of Gurudev Gachinmat as appearing for
Respondent number 3, my lord.
R3. Yaro Sheikh anta ide R3?
Last time, my lord, the order was
In place of SP Sheikh. Amale.
And Hulyal also. In place of Hulyal, my lords.
In place of
Hulyal and
MA
SB Sheikh,
Hulyal
both.
and SP Sheikh. Registry to delete the name of MA Hulyal and SB Sheikh. Neevu yarige?
Respond number 7, Vinay Kausalgi.
Learned Counsel Vinay Kausalgi accepts notice for respond number 7. Registry to print the name of so and so for respond number 7. What's the matter?
Now, my lord, in the meantime, I have also filed an application seeking amendment of the petition. During the pendency of, my lord, this petition notice was issued by R7. That was sought to be produced, my lord, by way of production of additional document, its stay and, my lord, impleading of R7. R7 impleading was done, interim order was granted. I'm seeking, my lord, relevant, my lord, amendment of the petition in that regard. Application is filed.
No objection. The application seeking amendment of the petition is unopposed. Therefore, the amendment stands.
Yes, my lord, it is filed on 29th.
Filed alla ivat list agidya.
Literally, my lord, not shown, but it is placed.
Put up on madidara.
Yes.
The application stands allowed. A petitioner to amend the petition, file an amended petition in the next fortnight.
17th.
List the matter on
My
17th.
lords, may I request for 10th, my lords?
17th.
10th, my lords, may I request for 10th, my lords, this matter? Because
you want it on 10th?
10th, my lords, because I have
Both
just
sides would not
consulted
have
with
engaged
the
in it.
petitioner counsel as well,
7th.
because both sides senior counsel are engaged in this matter.
List on 17th.
Interim order, my lord, be.
Interim order subsisting will continue to the next date of hearing.
Great.
Grateful, my lords.
Continue on.
My lords, with your kind permission, serial number 155, date may be fixed in the next week, my lord.
One
For preliminary.
We'll see.
Lordship's kind permission. Serial number 110, my lord, seeking for regularization, my lord, temporary lecture. They are about to relieve. Interim order, my lord, not to relieve.
110 barkoli. 110. The service of the petitioner shall not be dispensed with in the event it is not dispensed as on today.
Obliged.
That's serial number 169, madam. That's serial number 169. That's I need to secure some information from.
Madam, objection idre adjournment ಕೊಡ್ಬೇಡಿ. ಇದರ ಯಾರಿಗೆ ಬೇಕು adjournment?
My lords, one submission, my lords. See, in serial number 160, my lords, there is another identical matter, my lords. It may be connected with this matter, my lords.
My lords, serial number 172 and 173, my lords, are seeking for a short accommodation. The date may kindly be fixed.
So 169 adjournment beda sir. I am seeking for disposal.
Sir, 169 adjournment ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಬೇಡ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಅದು ಡಿಸ್ಪೋಸಲ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆಲ್ರೆಡಿ 2006 ಇಂದ ಎನ್ಕ್ವೈರಿ ನಡೆದಿದೆ.
Okay, sir.
Madam, serial number 238. Court officer.
Madam.
Court officer,
Yes.
serial number 238. 238.
238.
ಹಾ ಮೇಡಮ್ ಅದು 25th ಗೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಕೊಂಡು.
Okay, madam.
ಹಾ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿ ಮೇಡಮ್ 25th.
Court officer, sir. Court officer, sir.
Court officer, sir. Court officer, sir. Court officer, sir. No, are they? Am I audible to them?
ಸರ್ ಹೇಳಿ.
Madam, ಕೇಳಿಸ್ತಿದ್ಯಾ madam?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
Thank you.
ಓಕೆ ಸರ್.
ಯಾವುದು? ಬೇರೆ ಕಡೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Lordship's leave, Lord.
Yes.
Yes, Lord, there's one matter pertaining to Credit Cooperative Bank, where the elections are over, Lord. The counting is held up because of directions of this honorable court. It had come up on Friday. It has been posted on 19th. There is some urgency in this matter, Lord, because the administrator has also resigned.
What do you want?
And Lord, matter could be taken up anytime this week, Lord.
ಅಷ್ಟೇನಾ? ಮೆಮೊ ಯಾರಿದ್ದಾರೆ ಕೊಡಕ್ಕೆ?
ಇದು ಯಾಜಿಗಳು ನಾರಾಯಣ್ ಯಾಜಿ.
Day after tomorrow.
Yes, Lord. Yeah, Thursday, day after tomorrow, please. Please. Oblige.
Yes.
Serial number 159. HV Gaonkar.
ಕೊಡೋದು ಕಷ್ಟನಾ? ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಕೊಡೋದು ಕಷ್ಟನಾ?
Records kotre, they have to file affidavit, my lords.
Who?
That the party who.
He will file.
Yes.
The petitioner is before this court seeking the following prayer. The petitioner files an application under the Right to Information Act on 21/12/2019 seeking certain documents of the family before the Tahsildar, which comes to be rejected, and an appeal thereon also comes to be rejected. Therefore, the petitioner is before the court seeking a direction to furnish appropriate genealogical tree or give information or submit the information, furnish the information that is sought for. The learned AGA submits that the authorities will have a relook at the application and pass necessary orders in accordance with law. Only after receipt of an affidavit from the hands of the petitioner with regard to the necessity of the documents if he is not a family member. In the event the petitioner is a stranger or not a family member, the application so filed be considered in accordance with law and the documents to be furnished or otherwise to be decided. In the light of the opinion of the court that the respondent should have a relook at the application, I deem it appropriate to set aside the orders dated, orders impugned in the subject petition with a direction to the respondent to reconsider the application and pass necessary orders in accordance with law, ordered accordingly.
161, Chetan T. Limbekai.
Still called in question, let's.
Let the state come up with the objections.
Let's reason for dismissal is
charge sheet in POCSO.
Subsequently, that conviction order is challenged before this honorable court.
Challenge ಅಷ್ಟೇ. Is it set aside?
Set aside.
ಹೌದು ಕೊಡಿ.
Sir, the judgment is not yet released. On 30th October 2025.
ಏನಾಗಿದೆ ಇದರಲ್ಲಿ?
Allowed ಆಗಿದೆ.
Allowed?
ಹೌದು. Allowed and conviction order is set aside.
Conviction order is set aside? Where is the order of dismissal here?
Annexure A,
Page?
Page number 13,
13.
The only reason is crime?
Yes, the only reason.
And even your lordship, he was in custody from 25/10/2023 to 31/10/23.
That's why, once he
5 days, 48 hours ಆದ್ಮೇಲೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದೀರಾ?
Please.
ಆಮೇಲೆ ಕನ್ವಿಕ್ಷನ್ ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೀರಾ?
ಹೌದು.
ಅಷ್ಟೇ. ಈ ಕನ್ವಿಕ್ಷನ್ ಆರ್ಡರ್ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡ್ತೀರಾ? ಟೈಮ್ ಲಿಮಿಟ್ ನಾವು ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. The petitioner is before this court in POCSO,
POCSO,
section 8.
A section 8.
The petitioner is before this court seeking the following prayer. Heard so and so. Facts adumbrated are as follows. The petitioner, ಎಲ್ಲಿ employee, government servant,
Please notes, he is a high school teacher, my lords.
high school teacher.
Music teacher.
ಬೇರೆ ಎಲ್ಲ ಯಾಕೆ ಮಾಡಬೇಕು? The petitioner, blind music teacher.
Blind music teacher, ಅವ್ರ ಮೇಲೆ 100% blindness.
The petitioner is said to be 100% blind and is a music teacher. A music teacher in Government Model High School at Yelaburga. On 12/9/2017, an allegation comes to be made against him that he has sexually exploited a 6th standard student, and therefore a crime comes to be registered in crime number 128 of 2017 for offences punishable under section 354 of the IPC and section 8 of the POCSO, read with section 31W and 325A of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, hereinafter referred to as the Act for short. After the registration of the crime, the petitioner is said to have been taken into custody, where he is in custody for 6 days, and by the operation of a deeming fiction under Rule 10(2)A of the KCS CCA rules, the petitioner is placed under suspension. Later, the petitioner is convicted of the offence. Owing to the said conviction, the order of his dismissal comes to be passed on 25/11/2024. The order of dismissal reads as follows. A perusal at the order of dismissal, what is ostensible is that the petitioner was not proceeded departmentally, but the dismissal order comes about only on the conviction of the petitioner. While a government servant gets convicted, he need not be proceeded departmentally. The conviction would be a circumstance enough for dismissal from service. Next para. The petitioner called the said order of conviction in question before this court, before coordinate bench of this court in criminal appeal 570 of 2023. It transpires that the coordinate bench, in terms of its order dated 30th October 2025, has set aside the order of conviction. Since set aside the order of conviction and acquittal,
please,
and passed an order of acquittal. Since the order impugned quoted supra was passed only on the conviction of the petitioner, and the sword of conviction now being taken away by the order of the coordinate bench, the respondent state will have to consider the case of the petitioner for reinstatement into his services. As there was no other reason for placing the petitioner under, there was no other reason for dismissing the petitioner from service. In that light, the petition deserves to succeed for a direction to the state to consider the case of the petitioner for reinstatement into his services, owing to the observations made in the course of the order. In the light of the said circumstance, as a matter of form, FORM, as a matter of form, the order impugned dated 25/11/2024, which stood passed only on the conviction of the petitioner, stands obliterated. In the light of, for the aforesaid reasons, the following got allowed in part bantala stands allowed in part so and so cost. The respondent state shall now consider the case of the petitioner for his reinstatement with an outer limit of reinstatement, bearing in mind the observations made in the course of the order, within an outer limit of 8 weeks from the date of receipt of the copy of the order. All consequential benefits would, the petitioner would become entitled to all consequential benefits except salary for the period that he was out of service, as a consequence of the quashment of the orders.
Just one clarification, Your Lordship. If the order is challenged by the state.
In the event the order of acquittal is challenged by the state and is stayed or reversed by the apex court. Apex court, yes. By the apex court, the order of dismissal It is needless to observe that the order of dismissal would revive.
162 Shivaji Nilopan, Shivraj
The
Palladu.
criminal appeal ಎಲ್ಲ ಇಲ್ಲಿದೆ ಇದು criminal appeal.
Matter pertains to recruitment of the post of
Constable.
constable in CRPF. The lordship had passed an interim order on
ಒಂದ
21. Yes, my lord.
ಯಾವ ಒಂದು ವರ್ಷದ ಕೆಳಗ
18/2/2025.
31/2025.
There is a tie between the petitioner and another candidate, and there is a rules how to resolve it.
One post was kept vacant according to the order.
The rules provides, my lordship kindly see.
Now what is, ಹೇಳಿ.
Please. Lord, now he is entitled under the cutoff marks, whatever announced by the respondent. Lord,
He becomes eligible, is it?
eligible. And 10 members have, my lord, taken employment in a different department. Posts, 66 posts are vacant, my lord.
ಏನ್ ಮಾಡ್ತೀರಾ vacancy ಇಟ್ಕೊಂಡು?
Sir, my lord, rules itself makes provision. Lordship kindly see page 42, my lord. Rules 42/15. Married. There is a resolution in cases of tie cases. In the event of tie of in scores of candidate in CBT, such case will be resolved by applying following criteria one after the another. Here, my lord, first one is marks in part A. In that itself, he has lost. Lordship kindly see in a statement of
Page 42 one after the another ಏನಿದೆ? Tie cases ಅಲ್ಲಿ.
Yes, ma'am.
In the event of tie in scores of the candidates,
Yes, ma'am.
such cases will be resolved by applying the following criteria. Marks in part A.
One after the another. First part alle ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾನೆ ಅವನು. Lordship
15.1 ಅಲ್ಲೇ qualify ಆಗಿಲ್ವಾ?
he is disqualified. But my statement of objection.
Why disqualified in that?
Because his score is 17.50. Selected candidate is 19.25.
Select candidate join ಆಗಿದಾರಾ? Join ಆಗಿದಾರಾ?
He has joined.
ಇಲ್ಲ, join ಆಗಿಲ್ಲ.
ಅಲ್ಲ, he has joined. Selected candidate has joined.
ಈಗ ವೇಕೆನ್ಸಿ ನೆಕ್ಸ್ಟ್ ಯಾವ್ದಿದೆ?
ಅಲ್ಲ, now that recruitment.
ಎಷ್ಟು ವೇಕೆನ್ಸಿ ಇದ್ದಿದ್ದು?
That
66, my lord.
All 66 are filled?
No, my lord, 10 are vacant.
ಅಲ್ಲ, that recruitment process is completed, my lord.
No, ಆ 10 are vacant ಅಂದ್ರೆ?
Yes. Cut off marks 43.25.
ಇಲ್ಲ, cut off ಬರಲ್ಲ ಈಗ.
Cut off ಪ್ರಶ್ನೆ ಅಲ್ಲ. ನಾವು 10 vacant ಅಂದ್ರೆ out of 66, 56 fill up ಆಗಿದಾರಾ?
56 fill up ಆಗಿದೆ.
ಹೌದಾ?
It is only orally he is
ಒಂದು ನಿಮಿಷ ಸರ್.
Yes, sorry, ma'am.
56 fill up ಆಗಿದಾರಾ?
Yes, please.
56 ಅಲ್ಲಿ who is less than you in score?
Lord, page 103, my lord.
ಇದಾರಾ ಇಲ್ವಾ?
ಇದಾರೆ.
17.5 ಗಿಂತ ಕಮ್ಮಿ ಇದಾರಾ?
ಇದಾರೆ.
Yes, sir.
I will file, my lord, affidavit to that effect.
17.5 ಗಿಂತ ಕಮ್ಮಿ ಇದ್ರೆ vacancy ಇದ್ರೆ ತಗೊಳ್ಳಿ.
My instructions is that my selected candidate is joined and no vacancy. If he's
The learned counsel for the petitioner submits that out of the 66 vacancies called pursuant to the application, only 56 have joined and 10 have remained vacant. The learned counsel submits that in the 56 candidates, there are many candidates who have scored far less than the petitioner who have been selected. The learned counsel M.B. Kanvi would dispute the position and contend that there is no vacancy left. All 66 are filled. Therefore, respective affidavits be filed by the next date with regard to vacancy position in the pursuant to the subject recruitment. List the matter on 27th in preliminary hearing.
164 Akash R. Naik, KL Patil.
Karnataka University's order, Your Lordship.
Anganwadi.
KUD, University, Your Lordship. Karnataka University of Dharwad.
University has to answer.
Please, Your Lordship.
There is no representation. We have the petitioner. List the matter after 2 weeks. Registry is directed not to list the matter prior to the expiry of 2 weeks. Next.
165 Ravi Hegde, SC Booty.
Hearing for the respondent, Lord, the WP become infructuous on the ground that, my Lord, the already inquiry has been conducted and posted for orders, my Lord. Suspension order has been challenged in this writ petition by the petitioner.
ಅದಕ್ಕೆ infructuous ಹೆಂಗಾಗುತ್ತೆ?
Lord, the already, my lord, articles of charge have been issued.
ಆಯ್ತು ಸಸ್ಪೆನ್ಷನ್. ಸಸ್ಪೆನ್ಷನ್ಗೂ ನೀವು ಎನ್ಕ್ವೈರಿ ಕನ್ಕ್ಲೂಡ್ ಮಾಡೋದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
They have revoked the suspension order.
ರಿವೋಕ್ ಅದನ್ನ ಹೇಳ್ಬೇಕು ತಾನೆ ಫಸ್ಟ್. What is called in question? The petitioner is before this court seeking the following prayer. What is called in question is an order of suspension. The learned counsel appearing for the respondent submits that the inquiry is concluded. The order of suspension has stood revoked. Since it is stood revoked, the petition is rendered infructuous. Yes.
166, R.K. Kulkarni, Shiv-Kumar Badwati.
My lord, the petitioner is the President CMC Nipani. And he has filed the petition for quashing the order passed by the Deputy Commissioner at Annexure N, because that order has been passed without conducting the proper inquiry. Because in the...
What is the order, sir?
The grievance of the petitioner is that in the course of the regular work, respondent number 2 and 3 have misbehaved, and they have also, a resolution has been passed to terminate their from services.
Misbehaved with whom?
By the CMC, the payment is being made.
Misbehaved with whom?
With all the members and others, including the officers. A serious action was proposed.
Complaint is registered?
Complaint might not be.
ಮಾಡ್ಲಿಲ್ವಾ? ಯಾಕೆ ಮಾಡ್ಬೇಕು? ಸೀರಿಯಸ್ ಒಫೆನ್ಸ್ ಮಾಡ್ಬೇಕಾಯ್ತಲ್ಲ.
Because
so no offense. ಆಮೇಲೆ next. ಅಷ್ಟೇ.
Inquiry has not been, so inquiry has not been properly conducted, and members were not inquired because there is a CD and other proofs to show that they have misbehaved.
Registered a crime, sir, immediately. ನೀವು ಹೇಳ್ತಿರೋದು ನೋಡಿ ತುಂಬಾ ಸೀರಿಯಸ್ ಒಫೆನ್ಸ್, ಮಿಸ್ಬಿಹೇವಿಯರ್, ಆಲ್ ದಟ್ ಇದ್ದಾರೆ.
ಅದೇ ಅನ್ಪಾರ್ಲಿಮೆಂಟರಿ ಯೂಸ್, ಈವನ್ ದೇ ಹ್ಯಾವ್
504 506 ಅಂತೂ ಬಂದೇ ಬರ್ತದೆ.
ದೇ ಹ್ಯಾವ್ ಇನ್ಸ್ಟಿಗೇಟೆಡ್ ಅದರ್ ಪರ್ಸನ್ಸ್ ಟು ಕಂಡಕ್ಟ್ ಧರಣಾ ಇಟ್ಸೆಲ್ಫ್. ಅದನ್ನೆಲ್ಲ ಮಾಡಿ ಈವನ್ ಎವ್ರಿಥಿಂಗ್ ಹ್ಯಾಸ್ ಅಪಿಯರ್ಡ್ ಇನ್ ದಿ ಪೇಪರ್ಸ್ ಆಲ್ಸೋ.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗಿಲ್ಲ.
Only commissioner was inquired, but the members in the meeting.
What is the impugned order, sir?
Impugned order is, my lord, at Annexure N.
ಏನದು?
ನೇರ ಪಾವತಿ ಅಡಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತ ಪೌರಕಾರ್ಮಿಕ ಶ್ರೀ ಸೂರ್ಯ ಸಂಭಾಜಿ ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕಿರುವ ಬಗ್ಗೆ ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ.
ಕೆಲಸದಿಂದ ತೆಗೆದಿದ್ದಾರ? ಯು ಆರ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ದಿ petitioner ಯಾರು?
President of
CMC. ಏನ್ ಕೆಲಸದಿಂದ ತೆಗೆದ?
As per the general body resolution, as everyone has expressed to terminate them, as they are the daily wages employees, they have been terminated.
ಯಾವುದು CMC?
Second and third respondents are the employees appointed on daily rated basis.
Daily rated.
ಅವರು ತೆಗೆದಿದ್ದಕ್ಕೆ ನಿಮಗೆ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್?
Because as they had not worked, they are paurakarmas. Their duty they have to conduct. When they have failed to perform their duties, they were asked to appear before the committee and explain why you are not working. So even the commissioner has issued the notices to them. Even then they have not properly replied and not conducted their routine work. And on the other hand, they have instigated others to file the.
You agreed of, sir? One ನಿಮಿಷ. Annexure N ಏನು?
Annexure N is the order passed by the Deputy Commissioner.
ಅದೇ, that is your agreed of that. What is that order?
ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ಕ್ರಮಕ್ಕೆ ಒಂದೆರಡು ಸಲ್ಲಿಸುವ
ಸಿಬ್ಬಂದಿಗಳ ಕೆಲಸ ತೆಗೆದು ಹಾಕುವಾಗ ನೈಸರ್ಗಿಕ ನ್ಯಾಯವನ್ನು ಸಲ್ಲಿಸಿದ. Anything else, sir?
No.
ಅಷ್ಟೇ. The petitioner is before this court seeking the following prayer. The petitioner is the president of the city municipal council Nippani. The drill of facts would go this way. On 17/9/2024, a general body is convened in CMC Nippani, wherein respondents 2 and 3, who are directly paid temporary Paurakarmikas, on an allegation of misbehaving and threatening the members and officers present in the meeting was sought to be removed from service. This removal is taken by those respondents 2 and 3 before the Deputy Commissioner. The Deputy Commissioner passes the following order, issues the following communication, Annexure M, page 39. The Deputy Commissioner on perusal at the records would pass an order, we would communicate that the removal of 2 Paura Karmikas by the members of the petitioner is contrary to principles of natural justice, as they were not afforded adequate opportunity to submit their defense. Therefore, the order is passed. The CMC is before the court calling in question the said order of the Deputy Commissioner on the score that that respondents 2 and 3 had indeed grossly misbehaved on the date on which the meeting was convened, which led to the passage of the resolution. If that be so, immediately the petitioner ought to have registered some kind of protest or crime against those petitioners. That having against respondents 2 and 3, that having the petitioner not having done so cannot now contend that there is gross misbehavior misbehavior and intimidation towards the members of the council on 17/9/2024. That on 17/9/24, the order of the Deputy Commissioner is only setting aside those orders and directing adequate opportunity being given to respondents 2 and 3 to defend their case. The order does not warrant any interference. The petition, as no prejudice is caused to the petitioner by the order passed by the Deputy Commissioner. Finding no merit in the petition stands rejected.
169, Sabil Ahmed.
My lordships, I appear for the petitioners in this matter, my lordships. The petitioner is calling in question the order of inquiry which is dated 31/7/2000, order of inquiry which is at annexure F, my lordships, which is dated 2017. And since then till today, no inquiry proceedings have been concluded. The inquiry officers have been changed 4 times at 4 instances, but till date, no inquiry has been concluded, my lordships. And further, my lordship, the inquiry has been initiated.
One minute. Who has to connect the inquiry?
Retired district judge was appointed as an inquiry officer, my lordships.
Sir,
inquiry,
please.
But inquiry officer was appointed. And my lord,
who has to conduct the inquiry, sir?
But it is for the government.
Government. Who is the inquiry officer? Date of charge sheet, date study. My
lordships, FIR is registered not against me, my lordship. First of all, it is arising out of a complaint by ACB. My lordships, FIR is not registered against me. Complaint is also not filed against me. Thereafter, my lordships, I am arraigned as a charge sheet witness in the charge sheet to prove the offence of Parmeshi. Thereafter, my lordship, surprisingly, a show cause notice on 1/6/2016 is issued at annexure D, my lordships, wherein along with me 5 other officers show cause notice was issued, to which I have also submitted my reply. My reply is not taken into consideration. All the other officers to whom show cause notice was issued are exonerated. I have been a disciplinary inquiry is ordered only against me on the ground that I have not submitted my reply. My reply is at annexure E, my lordship, 24/6/2016.
When were the others exonerated?
In the same impugned order, my lordship. Annexure F, page number 37 starts, page number 39, 5/2017, my lordships.
So last 8 years in the Madilva?
My lordship, the case is covered by my lordship, my humble self judgment, my lordships, in case of B.S. Rangaswamy versus State of Karnataka, wherein my lordships have taken note of the circulars issued by the government, wherein inquiry is to be concluded within 21 months as per the circular. Muda, my lordships, indeed.
2020.
And as per the circular of 1999, it was to be DE is to be concluded within 21 months.
21.
This is 21 judgment, my lordships.
Your Lordship, page number 43, two officers were appointed for the inquiry, Your Lordship. Subsequently, it is conducted from page number 44, Your Lordship, wherein already it is started, Your Lordship will verify and make submissions. What is the stage of inquiry, Your Lordship? Report, whether report is.
31/7 notice was ordered in the lordships. And it was listed for 5 days thereafter.
Don't worry, next date everything will be over.
Please, Your
The
Lordship.
petitioner is before this court alleging that since 5/3/2017, i.e. passage of 8 years, the enquiry officer has not completed the enquiry. The enquiry was initiated against 8 people. 6 are exonerated by the impugned order. 2 are sought to be proceeded. The sword of a departmental inquiry is hanging on the head of this petitioner for the last 8 years. Therefore, the learned HCGP, to secure instructions as to why it has taken 8 years for the inquiry officer to complete the proceedings or the disciplinary authority to pass necessary orders, in the event the inquiry proceedings have stood completed in the interregnum, failing which it would on the face of it become a gross abuse of power, which would gross abuse of power, which would result in imposition of exemplary costs upon the disciplinary authority or the inquiry officer for having sat over the inquiry for close to 8 years doing nothing. Therefore, list this matter on 19th in fresh matters list. Instructions be sought with regard to the inquiry by then. And if the inquiry is pending still, an affidavit of the inquiry officer or the disciplinary authority be filed before the court as to why there has been delay of 8 years. In the event no affidavit would come, the submissions of the counsel with the petitioner would, no affidavit would come. Affidavit would be filed. Yes.
Hello, President.
List the matter on 18th. Next.
170, K. Raghavendra Rao. PV Gunjan.
To restore full pension.
There are two issues here, my lord. First is the information was sought under the RTI Act. If at all the petitioner is not satisfied with the information given, he has to go in appeal before the appellate authority. That is one aspect.
Next issue.
That is second aspect is whether the petitioner is entitled to the pension as claimed by him. My lord, during the period, there was a direction from the Honorable Supreme Court which said that where an employee has retired before 2010 and had not opted for higher pension by contributing more towards it, he shall not be entitled to any benefit of contributing on the higher pension. That was taken into consideration and the pension was refixed. And the refixed pension has in fact been given to him with effect from March 2025 as per annexure R4, R3 produced by me with my statement of objections. Now, the contention of the petitioner was that his pension has not been restored to the original which he was entitled to. But the fact is that it has been restored after making a modification as directed by the Honorable Supreme Court. In fact, I've also produced annexure R4, which says that R3.
One minute. List tomorrow in fresh matters list. Next.
174, Ms. Harvey.
Regularization. Srinath. Where is it? Then challenge it. Amendment ಆಗ್ತೀರಾ fresh ಆಗ್ತೀರಾ? Already ಹಾಕಿದೆ. The petitioner's claim regularization. During the subsistence of the petition, it transpires that the claim of the petitioners are rejected. Therefore, the application seeking amendment of the petition, for the reasons indicated in the affidavit accompanying the application being satisfied with the same, the application seeking amendment of the petition stands allowed. The petitioner to file an amended petition in the next fortnight. List the matter on 28th. Yes, next.
175, Vijay Kumar.
Covered. When covered? Could compassionate. ಇದೆಲ್ಲ ಮೊನ್ನೆ ಮಾಡ್ದಂಗಿತ್ತು ನಾನು. Same issue. ಹಂಗೆ that this is that lady's case ತಾನೆ? ಅಲ್ಲ. What happened to this? Final ಆಗಿದೆಯಾ? Appeal ಏನಾಗಿಲ್ವಾ? What is the similarity? ಅದಲ್ಲ ನಿಮ್ದು ರೆಕಮೆಂಡ್ ಆಗಿತ್ತ ಇವ್ರ ತರ?
ಇಲ್ಲ.
ಮತ್ತೆ
ಇಲ್ಲ.
ಇಲ್ಲಿ ಕೇಸಸ್ were recommended for regularization.
Not appointed for the sanctioned post.
ಅದು ಇಲ್ಲೂ ಇರಲಿಲ್ಲ. ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೊಂದೇ ಡಿಫೆನ್ಸ್ ಗೌರ್ಮೆಂಟ್ ನಾಟ್ ಅಪಾಯಿಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಅಂತ 30 ವರ್ಷ ಕೆಲಸ ಮಾಡಿಸುತ್ತೆ. ಆ 39 ವರ್ಷ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ 39 ವರ್ಷ ಯಾಕೆ ಕೆಲಸ ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತು? ಎಕ್ಸ್ಪ್ಲಾಯಿಟೇಷನ್ ಆಫ್ ಹ್ಯೂಮನ್ ಲೇಬರ್. ಸೇಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಇಲ್ಲಿ ಕಂಪ್ಯಾಷನ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ನೋಡಿ ಮೇಡಮ್, ಇಫ್ ಇಟ್ ಇಸ್ ಕವರ್ಡ್ ಯು ಟೆಲ್ ಮೀ. ಇಲ್ಲ ಅಂದ್ರೆ ಡೋಂಟ್ ಫಾಲ್ ಇನ್ ಟು ಪ್ರೇ. ನಾಡಿ ಗುರುವಾರ ತಗೊಳ್ಳ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಥರ್ಸ್ಡೇ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
176, Sharada Baswa B, Shri Srinilokan.
For what? Associate professor. Associate professor's post. You applied. What happened to that? What has happened to the selection process? Cheers.
Please, now you have set the proposal because the state has cancelled the appointment of the petitioner on the ground of she is claiming under 371J. So government directed the university to cancel the appointment and to call for a fresh recruitment. And now again the proposal.
Was selected and appointed?
Illa. He was not.
Select list draw ಮಾಡಿದ್ರಾ? ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಡ್ರಾ ಮಾಡಿಲ್ಲ. ನೋ ಕಮ್ಯುನಿಕೇಶನ್ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಅರ್ಥ. ಹಾ ಹಾ ಮುಗಿಸ್ಲೇಬೇಕು ಅಂತೇನಿಲ್ಲ ಸರ್, ಯಾವ ಕಾನೂನು ಇಲ್ಲ. ಕೊಡಿ ಸರ್. They can abandon it at any time.
The notification itself provides serial number 14 condition, my lord. The right to fill up the right to fill or not to fill the
Right,
advertisement.
to say that recruitment process should be initiated, should be concluded, all that. Sir, Tej Prakash is on a different footing, whether it rules of the game can be changed after the commencement. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. It was referred to a larger bench because one who participates in the selection process can challenge later ಒಂದು. And once the game has commenced, whether you can change the rules of the game. The other issue went to the larger bench. Correct. Ends up ನಿಜ, ಅದ್ರಲ್ಲೇನು ಡೌಟೇ ಇಲ್ಲ. Nobody needs a judgment. ಆ ends up ಮಧ್ಯೆ ಅದೇ can end up. No right. ಅರೆ ಅಬ್ಸರ್ವೇಷನ್, ವಾಟ್ ಇಸ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಕ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. That you don't, that's too rudimentary even to consider it through a judgment. A recruitment process commences with issuance of a notification, ends with appointment. It's all right. But in the interregnum, you can't say employer has no right to terminate the shelve the very recruitment process. ಏನು ಮಾಡೋಂಗೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾರ? That has nothing to do. ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಏನ್ ಮಾಡಿದ್ರಿ ಕೊನೆಗೆ?
ಇಲ್ಲ, ನಮ್ದು on the order of the government we cancelled the process, my lord.
Recruitment, where is the order of the government?
Please. ಅವ್ರು ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ?
ಇದೆಯಾ?
Yes.
ಅದಾ?
Yes, I will file along with the memo.
Madam. 8/3/2019 ಅಲ್ಲೇ ಆಯ್ತಾ? ಸರ್ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. ಪಬ್ಲಿಷ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
ಪಬ್ಲಿಷ್ ಆಗಿದೆ, ನೋಟಿಫಿಕೇಶನ್
ಗೆಜೆಟ್ ಆಗಿದೆ. Anything else? The petitioner is before this court calling in question, is seeking a direction, seeking the following prayer. Heard so and so. Facts in brief germane are as follows. On 28/10/2017, the fourth respondent issues a notification calling for applications from eligible candidates for appointment to the teaching post in the regional local cadre, i.e. Hyderabad, Karnataka, in terms of Article 371J of the Constitution of India. The petitioner participates in the selection process, is said to have emerged successful. The contention of the petitioner is that he has emerged successful and his name finds in the select list. The selection after the name of the petitioner being drawn in the select list did not proceed further at all. The stalemate. ಮತ್ತೇನು ಮಾಡೋದು? ಸ್ಕೋರ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಬೇಡ, ಸ್ಕೋರ್ ಕಾರ್ಡ್. The contention of the petitioner is that the petitioner has scored the highest. In the light of the petitioner scoring the highest marks, the learned counsel for the petitioner submits that the petitioner was expecting the process of recruitment to be taken forward and an employment being granted to him. What happened? The petitioner, on this hope, 8 years passed by. There is no development with regard to the notification being taken to its logical conclusion. Therefore, the petitioner is before this court by filing the subject petition in the year 2025. The learned counsel Sriharsh, appearing for university, submits that since the recruitment itself was contrary to section 371J, the state government long ago, i.e. on 8/3/2019, has directed cancellation of the recruitment process and initiation of a fresh recruitment process. The communication reads as follows. In the light of the said communication, the petitioner cannot have any right crystallized in his favor that the recruitment process should be taken to its logical conclusion merely because he had scored the highest marks. It is straight law, TRIT. It is straight law that that a candidate's name found in the select list will not get an indefeasible right to seek a direction to the hands of the respondent to complete the selection process or render an order of appointment to him. A right that is not crystallized cannot be tested on the anvil of Article on the anvil of Article 14 of the Constitution of India for attainment of a petition under Article 226 of the Constitution of India. Therefore, leaving open to the remedies available to the petitioner in law, the petition stands disposed.
177. Anandar Kolli. B. Shivraj Hiramat.
Yaru illa 2 weeks.
My lord, in this case, even though Honorable Court directed me to take notice, serve a copy, but they have not served any copy.
Counsel for the petitioner to serve set of papers upon the counsel Shivraj Hiramat.
Please, my
Shivraj Hiramat forthwith lists the matter after 2 weeks.
Moreover,
In the event the copy is not served upon Shivraj Hiramat, the petition would be dismissed for its non-prosecution.
the date may be given because my lord,
Stay illa.
ಅಲ್ಲ ಇದರಲ್ಲಿ KT is having jurisdiction.
ಏನು ಯಾವ ಕೇಳ್ರ?
My lord, FDA.
ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್?
Suspension order, my lord.
ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್?
My lord, ಜಿಲ್ಲಾ ಪಂಚಾಯತ್. CUT ಯೋಜನೆಯಲ್ಲಿ they have been
ಜಿಲ್ಲಾ
appointed.
ಪಂಚಾಯತ್ KT ಬರಲ್ಲ. ಎನಿಥಿಂಗ್
ಅಲ್ಲ
ಎಲ್ಸ್?
FDA, my lord.
ಯಾವ ಕೇಳ್ರ ಆದ್ರೂ ಅಷ್ಟೇ.
Clerks.
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ won't go before the KT.
Clerks, FDA, first division assistant. Lien has been obtained from the government. Please.
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್. Yes.
Lien has been taken.
ಎಲ್ಲ. Is he on deputation?
Please.
ಎಲ್ಲಿಂದ?
From the primary school, government primary school.
Government primary school in there. The learned counsel, learned counsel Shivraj Hiramat submits that the petitioner is a deputationist. He belongs to the, he is a government servant working in the education department. He is on deputation to the Jilla Panchayat. Therefore, the petition is not entertainable before this court. The submission would merit acceptance as it is settled principle of law that the court of first instance to any government servant is the Karnataka Administrative Tribunal. In terms of the law laid down by the apex court in the case of 7-judge bench of the apex court in the case of L. Chandrakumar versus Union of India, AR 1997 SC 1125. The learned counsel submits it is also trite law that a deputationist from the government to any other department, it is also trite law that a service condition of a deputationist being tinkered with by the state, he will have to approach the Karnataka Administrative Tribunal itself, as a deputationist's right would accrue only from him being a government servant. There is no representation on behalf of the petitioner. List on Thursday in fresh matters list. ಕಳಿಸ್ಬೇಡ.
Tomorrow,
ಬರ್ಬೇಕಲ್ಲ. ಯಾರು ಪೆಟಿಷನರ್? ಯಾರು
petitioner?
ಆನಂದ್ ಕೊಳ್ಳಿ. ಅವರು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ.
Please.
Yes, list tomorrow in fresh matters list. We'll close it. ಏನ್ ಜಡ್ಮೆಂಟ್ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, this is the order passed by the authority by exercising jurisdiction under section rule 10 of KCCR rules. Suspension order.
That Jilla Panchayat has passed?
CEO, he is the chairman of that.
ಅದನ್ನು ಅಲ್ಲೇ ಕ್ವಶನ್ ಮಾಡ್ಬೋದು.
Please.
Yes. Because group C and D ಗೆ,
Please.
group C and D ಗೆ suspension
Please.
orders can be passed by the place where he is on deputation. A and
Please.
B ಗೆ ಮಾತ್ರ yes sent
House.
back. All right, yes.
180 Karbasappa Kurishekar, MM Kannur.
Writ of. Yes. ಆಮೇಲೆ.
It's calling in question the order of suspension pending inquiry. Suspension order was passed in the month of June 2025. I'll verify either it will be revoked or the inquiry itself will be. I'll just verify that tomorrow.
Filing of this petition, one long amount. We have issued Shoka notice to 6 members. 6 members. But suspension order is against this petition. Then bias, out of 7 members.
Bias.
Out of 7 members, 7 Shoka notice issued to 7 members. Suspension order issued to only one this petition. According to their version, they have suspicion on these all people. Then also the bias order is passed by the respondent. Only suspension order issued against this petition. Because this is a widow lady appointed.
ಅದಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
Widow lady, some hidden items I cannot tell before this honorable.
Hidden items.
He being a caretaker of her small kid, appointed compensation ground after death of her husband.
Compassionate appointments.
After death of her husband. Husband was doing job. Later on, that job is available to her. Lordship. This honorable court directed them to file objections, last chance on 9/9/2025. Then also they have not filed any objections.
So they have lost the chance.
That lady is suffering. That's why it's very urgent.
Urgent justice required.
That's why your lordship, that poor lady is suffering. This is out of.
What, Prashant? Urgent justice is required.
That's why I'm praying humble before the honorable court. Please finalize it.
Finalize it. We'll finalize it.
It's already 6 months, my lords, 5 months, my lords, have lapsed after passing of the suspension order. It seems, my lords, that
Heard the learned counsel appearing for the petitioner. The petitioner, along with 6 others, is said to have been issued show cause notices.
dates are different. This is in respect to the petitioner, it is in June. Others, my lords, it is in the month of August.
So 6 show cause notices are issued, which the learned counsel for the petitioner submits that only in the case of the petitioner there is suspension order passed and not against others. The learned counsel Prashant Husmani submits that he would secure instructions as to whether the order of suspension has been revoked or otherwise in the teeth of the fact that the suspension order was passed 6 months, close to 5 months ago. Even otherwise, selective suspension on the same set of facts is unknown to service jurisprudence. If suspension has, if all of them are involved in same misconduct or identical misconduct, one person cannot be picked out for suspension. It would become an act of selective suspension. Therefore, the respondent, if the order is not revoked, shall explain the aforesaid circumstance. List the matter on 18th in fresh matters list. There's a judgment. A.N. Reddy versus Union of India, 1990 AAR. AAR supplement, 1990 supplement 2 SCC. I think 510 or 520 selective suspension.
I'll go through it. Great.
181 Ravi Hegde, Srikanti Patil.
I appear for respondent number 4.
ಇಬ್ರು ನೋಡ್ತಾ ಇದ್ರೆ
Granting of pension, Lord, as per rule 217 of the KCSR is rejected by the state, my Lord. Annexure E is the endorsement, page number 36.
State by the state?
Yes.
State. You have to state something.
Appointment was cancelled, Your Lordship.
What cancelled?
Already, Your Lordship. Page number 37, Your Lordship. Endorsement wherein it was stated, Your Lordship, ಇವರ ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿರುವುದರಿಂದ ಕರ್ನಾಟಕ ನಾಗರಿಕ
ಈಗ
ಸೇವಾ
ಯಾರು ಸ್ಟೇಟ್ ತಾನೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು? ನೀವು ಈ ಕಡೆ ಬನ್ನಿ ಸರ್, ಅವರು ಕೊಡಿ. ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಮೈಕ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಬೇರೆಯವ್ರು ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಕೊಡಿ. ಈಗ ಹೇಳಿ ಮೇಡಮ್.
ಅವರು ಸಲ್ಲಿಸಿರುವ ಮನವಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಇವರು ಅನುದಾನಿತ ಹುದ್ದೆಗೆ ಆಯ್ಕೆಯಾಗಿ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಲಾಗಿತ್ತು. ನೇಮಕಾತಿ ಅನುಮೋದನೆಯನ್ನು ಪ್ರಶ್ನಿಸಿ ಶ್ರೀ ಶಿವಾಜಿ ಎಂಬುವರು ಅಪೀಲು ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ದಾವೆ ದಾಖಲಿಸಿದ್ದು, ಅಪೀಲಿನ ತೀರ್ಪಿನ ವಿರುದ್ಧ ಶ್ರೀ ಯರಗುಪ್ಪಿ ಇವರು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿ ದಾಖಲಿಸಿದ್ದರು ಸಹ ತೀರ್ಪಿನ ವಿರುದ್ಧ ಆಯ್ಕೆಯಾಗದ ಅಭ್ಯರ್ಥಿಯಾದ ಶ್ರೀ ಶಿವಾಜಿ ಇವರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಶ್ರೀ ಯರಗುಪ್ಪಿಯವರ ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿ ತೀರ್ಪು ನೀಡಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಅನುಸಾರ ನಿರ್ದೇಶನಾಲಯದ
Appointment set aside.
Set aside.
Your appointment.
Yes, my appointment and approval was set aside. It was reached up to the Honorable Apex Court.
What happened there?
There was confirmed.
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 Why is this now?
Now, my lord, kindly see page number 31. Earlier occasion, he approached this Honorable Court. Para 11, my lords. This Honorable Court has directed the government to consider the case of the petitioner on special consideration.
ಯಾವ ಸ್ಪೆಷಲ್ ಬರಲ್ಲ. ಸ್ಪೆಷಲ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
10 years he served, my lord.
Your appointment is set aside. Setting aside of the appointment is confirmed by Supreme Court. Special circumstance ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
99 in the 2010 he worked, my lord. 10 years he has served.
10 ವರ್ಷ.
Yes.
On what basis?
My lord, on 20
permanent employment?
Yes. After the Apex Court order, my lord, I was removed. Till such time, my lord, I discharged the duty.
Special circumstance ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ನೀವೇನು ನೋಡ್ತಾ ಇದ್ರಿಗೆ?
Page 32.
Because Your Lordship, his work is terminated, Your Lordship.
Special
then he is not.
circumstance.
Please, Your
10 ವರ್ಷ
Lordship.
ಕೆಲಸ
maybe
ಮಾಡಿದಾರೆ.
When his appointment itself is terminated, Your Lordship, 10 years, when the order has been passed,
Salary ಎಲ್ಲ
and he has
ಕೊಟ್ಟಿದಾರಲ್ವಾ
challenged,
ಟೈಮ್ಗೆ?
Your Lordship.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಷ್ಟ. This order can't sustain. ಸುಮ್ಮನೆ ನಾವು ಹಿಂಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಸ್ಪೆಷಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಿ? 210 ಕೊಡಿ, KCSR ಕೊಡಿ.
Yes.
Thank you.
217. 217.
Just ಓದಾಕತ್ತಿದ್ದೇನೆ.
Compassionate allowance. Compassionate allowance.
Allowance, pension not more than
The pro rata invalid pension.
yes 2250 as per 210.
Invalid regular employment ಅದು.
Regular employment that was set aside.
Why was it set aside?
But at the time of appointment, petitioner was age barred. That is the contention taken by the unsuccessful candidate.
But you were age barred.
Yes. On that ground alone, my lord, my appointment was set aside. I have not even suppressed any facts.
Age suppress
ಅಲ್ಲ,
ಮಾಡಕ್ಕಾಗತ್ತಾ sir?
ಇಲ್ಲ, age barred ಅಂತ ಹೇಳಿ it was set aside.
Yes madam.
Your Lordship,
Till
when,
1990
ಎಲ್ಲ ಓಕೆ, ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್.
Your Lordship, only on that ground, Your Lordship, it cannot be said, saying that.
No,
it
invalid pension you can give in certain circumstances.
Yes.
You can consider ಅಷ್ಟೇ.
Only consideration and will pass appropriate order.
Same order will pass. ಈಗೇನು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಈಗ?
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Your Lordship, it is already rejected.
ಕಷ್ಟ. ಇನ್ವ್ಯಾಲಿಡ್ ಪೆನ್ಷನ್ ವಾಟ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ನಾವು ಕಾಂಟ್ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್ ಆಸ್ಕ್. ಕಂಪಲ್ಷನ್ ಅಲೋವೆನ್ಸ್ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಬೇರೆ.
ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
See, an employee who is dismissed, removed from service on not on this employment kind of a thing, on other circumstances, he gets invalid pension or compassionate allowance.
Yes. From 1987 till 1999, my lord, I was discharged in the same institution as a temporary lecturer. In the year 1999, it was approved.
After passing order also, Your Lordship, he has worked.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಲ್ಲ. ಈಗ ಎಷ್ಟು ನಿಮ್ಗೆ ಏಜ್?
69 years.
ಎಲ್ಲ ಬಾರಾಗಿ ಹೋಗಿದೆ. ಎಸ್. But it is very difficult to give a direction. Let me see what can be done. Compassionate allowance is there.
Yes.
Even to dismissed employee, compassionate allowance is there. ಇವರು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. Not will pass some order. Wait.
Please, grateful.
List on 18th in preliminary here.
Grateful.
We'll try to give something, we'll see.
182, Lakshmi Narayan, MC Okkeri.
One 180? Two weeks.
183, Dundappa Malli.
Please, my lords. My lords, petitioner is petitioner is working as a branch manager in respondent number 4th society, my lords. Due to his health issues, my lords, she has given a resignation letter, my lords. Same was not considered, my lords. Hence, I approached this honorable court.
Resignation consider ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ sir.
Where
Page
is
number
respondent?
91 annexure.
Respondent ಯಾರು?
Society, my lords. Cooperative society. The chief executive officer.
Represented by whom? Whom ಯಾರ ಕೊಟ್ಟಿದ್ದೀರಾ?
To 4th respondent, my lords. Wide annexure H, my lords, page number 91.
Who appears? Serve ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir.
The 4th respondent, those served, remains unrepresented. As a last chance, list this matter day after tomorrow in fresh matters list. In the event the 3rd respondent would not be represented, orders would be passed on hearing the counsel for the petitioner. Yes, next.
Please.
185, 13%.
My lord, I'm the petitioner appearing person, my lord. My lord, on 7th of 30th 7/2024, Supreme Court passed a judgment in Gaurav Kumar, my lord, saying that state bar councils cannot collect any amount beyond 750 rupees, that is statutory
ಏನ್
amount,
ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮಿಂದ?
up to 10,000, my lords.
10,000
I,
extra
I,
collect
I
ಮಾಡಿದ್ದಾರೆ.
enrolled in October 2024, my lords, that is subsequent to the judgment of Supreme Court. And while my petition was pending before this honorable court, two more judgments have come. One is directly regarding the first respondent, that is KSBC, and second one is in general to the West Bengal Council, my lord. My lord, my prayers are mainly two prayers, my lord. Firstly, to stop this collection that has been done, that has been satisfied since the recent. Yes, my lord. So the second prayer is refund.
Please, in this case, my lord, we are ready to refund, my lord. Let the respondent make a representation along with his bank details.
If you have collected contrary to Supreme Court judgment, you should refund.
Yes, my lord, we are ready, my lord. But the thing is, my lord, subject to the welfare fund, which has the certificate which has been issued, it has to be returned along with the receipt, my lord, because for welfare fund, there is a separate provision under section 15 of the Karnataka welfare fund.
The welfare fund is dealt with under separate enactment.
Yes.
Correct,
Now,
my lord.
under other expenses, you have collected all this, that you will refund.
Yes, yes, my lord. We will do that, my lord.
My lord, the submission, my lord, before the
Those are
Supreme.
limitations.
Yes, my lord.
Gaurav Kumar ಆದ್ಮೇಲೆ connect
ಆದ್ಮೇಲೆ ಮತ್ತೆ ಕಂಟೆಂಪ್ಟ್ ಅಂತ ಹಾಕಿದ್ರು. They have produced it, my lord. So prior to that, it has been collected, my lord. Subsequently, we have stopped, my lord, after the contempt.
Subsequent to the judgment of the.
Let him produce his bank details, my lord. It will be refunded immediately.
That has been annexed, my lords. Annexure C and all. And it has been served to the respondents also.
No, right. There is no bank details in that.
We'll dispose it, madam.
Please, my lord.
Yes.
Lord, I appear for the respondent number 2, Bar Council, my lord.
Rajshekara.
Yes,
collect
my lord.
ಮಾಡಿರೋದು?
First respondent.
My lord, the state Bar Council has collected, my lord. Now, after the judgment of Honorable Apex Court, my lord, a circular has been issued to all the bar councils, my lord, indicating not to collect the excess fees, my lord, in pursuance.
ಆಯ್ತು, ಈಗ ಎಕ್ಸೆಸ್ ಫೀ ಕಲೆಕ್ಟ್ ಮಾಡಿರೋದನ್ನ ವಾಪಸ್ ಕೊಡಿ ಅಷ್ಟೇ. The
Yes.
petitioner appears in person, is said to have enrolled as an advocate. While enrollment, it is the case of the petitioner that beyond the prescribed statutory fee, 750 rupees is collected by the Karnataka State Bar Council under the caption additional another financial requirements. Huh?
Optional fees, my lords.
Optional fees.
Application fees, miscellaneous
Under,
fees.
ಏನೇನು?
First is optional fees of 6,800, my lord. Application fees of 300 rupees. Miscellaneous fees of 500 rupees. ID card fees of 130 rupees. I have made a list at page number.
ಏನು ಬೇಡವಾ ಹಾಗಾದ್ರೆ?
Yes, my lords.
ಏನು ಕಲೆಕ್ಟ್ ಮಾಡಬಾರದು?
It has been clarified in the Supreme Court judgment.
ಸರಿ, ಆಯ್ತು,
Paragraph.
yes,
That,
yes.
categorically, these heads have been named also.
Where have you listed them?
Yes, my lords.
Where have you listed them all?
Paragraph number 15, my lord.
Have collected the following fee, para 15, out of which it transpires that rupees 750 is the only fee that is legally sanctioned for such collection in terms of law. The issue whether the Bar Council could charge fees beyond what is stipulated under the statute need not today detain this court for long or delve deep into the matter. The apex court in Gaurav Kumar versus Union of India 2025 1 SEC page 641 considers this issue and holds as follows, para 72 to 88. The apex court holds that the charging of enrollment fee in excess of statutory stipulation is impermissible in law. The learned counsel Srimati Archana Magdum, appearing for the State Bar Council, submits that the fee was collected prior to the order passed by the apex court, and therefore if the account details of the petitioner is furnished, the fee that is in excess would be refunded, and the learned counsel would submit a representation to that effect be submitted to the Bar Council. Action would be taken in accordance with law as submitted herein above. In the light of the issue standing completely answered by the apex court in the case of Gaurav Kumar versus Union of India, quoted supra, the petitioner in person shall now submit a representation to the Bar Council within 2 weeks.
Yes, 1 week also.
Within 2 weeks from the date of receipt of the copy of the order. In the event the representation is submitted by the petitioner in 2 weeks, the Bar Council shall act upon the same, bearing in mind the observations made in the course of the order passed by the apex court in Gaurav Kumar Supra, and pass necessary orders granting refund of the same in accordance with the judgment within 2 weeks, madam?
3 weeks.
Within 3 weeks from the date of receipt of the representation of the petitioner, ordered accordingly.
My lords, may I seek cost of the petition, my lords?
Cost?
I have been making representation continuously since 1 year, my lords. None of them have been answered.
Cost of litigation?
Yes.
You are a budding advocate, sir. Why?
Obligation.
Though the learned counsel for the petitioner seeks costs, ಒಂದು ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಕೊಡ್ಬೋದಲ್ಲ?
I have paid the expenses, that is.
What you appear ಆಗಿದ್ರೆ ಏನು expenses?
My lords, my other time and all.
ನೀವು ಯಡ್ರಾಮಿ ಅವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ದಿದ್ರೆ ಅವಾಗ ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ಓ, ಅದಕ್ಕೆ because you'll have to get him from Bangalore or Delhi. ಅದಕ್ಕೆ ಬರಲಿ. Yes. Cost made easy.
Yes.
186, Ramchandra Vibhat.
When did you get enrolled?
October 2024, my lords.
October 25.
24.
24.
Yes. Judgment was passed in July, my lords.
Which one?
Gaurav Kumar.
Gaurav Kumar is 30th July.
Yes.
186. So she is right. It has been collected prior to the judgment of the Supreme Court. So no costs. Yes. Refund only. Yes.
Lords, appearing for petitioner, my lord.
The judgment was passed in July 2024, my lords. I got enrolled.
July 30th.
30th, 2024. I got enrolled in October. So that was subsequent.
After the judgment.
Yes, ma'am.
Yes, madam. Why? Archana madam.
No, no.
Bar Council ಗೊತ್ತಿರ್ಲಿಲ್ವಾ?
But subsequently, my lord, there is a writ petition, contempt petition has been filed before the Supreme Court, my lord. Subsequently, the optional fees anta ಏನಿದೆ ಮಾಡಿಲ್ಲ. Earlier it was others charges ಅಂತ, ಆಮೇಲೆ subsequently optional fees ಅಂತ ಇದನ್ ಮಾಡಿದ್ವಿ. ಆವಾಗ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿ there is no optional fees ಅಂತ ಮಾಡಬಾರ್ದು ಅಂತ ಆಯ್ತು ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ. That was passed on 4th August 2025, my lord.
All right. In the event the Bar Council would not refund the amount within the 3 weeks as directed here and above, the petitioner in person would become entitled to cost of litigation at rupees 25,000. Yes.
Lords, I am appearing for the petitioner, my lord. Lord, the petitioner is an auction purchaser. Lord, sales certificate has been issued by the competent civil court. Pursuant to that, my lord, I have paid the stamp duty. My lord, thereafter, my lord, I approve the copy of the sales certificate is also, my lord, sent to the registering authority in terms of section 89(2). Lord, I approve the revenue authorities, my lord, seeking entering my name in the revenue records. Revenue authorities, my lord, issues an endorsement stating that since it's a not compromised decree, my name cannot be entered and directs me to approach the sub-registrar. My lord, sir, the
Court sale.
Court auction sale.
Yes, sir. ಯಾವಾಗ ಮಾಡ್ತೀರಾ sir?
Covered by decision, my lord.
Annexure J.
ಸುಮ್ಮನೆ ಹಂಗಲ್ಲ.
Please.
Annexure J is the my lord, sir. Annexure J is the my
ಈಗ
lord.
10 days ಟೈಮ್ ಕೊಡ್ತೀನಿ.
Please.
ನೀವೇ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಓಕೆ. ಇಲ್ಲ ಅಂದ್ರೆ 50,000 ಕಾಸ್ಟ್. ಕಾನೂನು ಗೊತ್ತಿದ್ದು ಈ ತರ ಆಟ ಆಡ್ಸಿದ್ರೆ I am not going to spare
Annexure F may kindly.
whatever it is.
ಅಲ್ಲ ಇದು
Court sale ಅಲ್ಲಿ ತಗೊಂಡು ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕಾಗಿಲ್ಲ. Why should someone participate in the sale? What is the problem?
ಅದು ಆಗಿದೆ.
Compromise decree ಮಾತ್ರ ರಿಜಿಸ್ಟರ್ ಮಾಡೋದು ನೀವು.
My lords, may I make one submission, my lord. Registering authority, approach the registering authority. Registering authority, my lord, issues an endorsement, my lord, stating that the limitation under section 23 is expired. Section 23 is not at all applicable to my case. I governed by section 89 sub clause 2.
Please, I'll take instructions.
89 to I have myself rendered a judgment. Could you?
Lord, 89,
but
89 sub clause 2, my lord, I have annexed the copy of the, my lord, KM Shrikanta versus State of Karnataka.
The petitioner is before this court seeking a direction for registration of the sale of his property before the jurisdictional sub-registrar. It transpires that the jurisdictional registrar has refused to register it on the score that it attracts limitation under section 23 of the Registration Act. The learned counsel for the petitioner submits that the Registration Act is not even applicable to the case at hand, as the registration is sought on account of a auction sale put up by the court and the petitioner being the successful auction purchaser. Therefore, the state shall explain as to, therefore 10 days time is granted to the state to correct its action, failing which exemplary costs would ensue, as the state is deliberately making the citizen approach this court in plethora of cases of the kind that is now projected. List this matter on 27th in fresh matters list.
Please, my lord.
ಅಷ್ಟಲ್ಲಿ ಮಾಡ್ತಾರೆ.
Please, my lord.
ಇಲ್ಲಾಂದ್ರೆ ಸಬ್-ರಿಜಿಸ್ಟ್ರಾರ್ 50,000 ಪಾಕೆಟ್.
My lords, in fact, Apex Court has held that once the sales certificate forwarded to the registering authority, my lord, it completes the registration formalities.
Natural justice.
Please.
One option.
Please.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
Please.
from his pocket he will pay AGA.
Please.
Tell him. Yes.
Please. Oblige.
189, Torgad Manjunath.
Lords, GST appeal, my lords. GST appeal, yes, my lords. GST appeal has been rejected on. Rejected.
Respondent ga Sadiq.
188 adjournment ಆಯ್ತು ಸರ್.
ರೆಸ್ಪಾಂಡ್ ನೀವು ಇದ್ದೀರಾ ಅಂದ್ರೆ ಏನು ಮಾತಾಡ್ತಾನೆ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅದು 188 ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ರೆಸ್ಪಾಂಡೆಂಟ್ 188 ಅಲ್ಲಿ.
ನಿಮ್ಗೆ ಹೇಳಿಲ್ವಾ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ
ಏನ್ ಮ್ಯಾಟರ್ ಅದು?
ಅದು ತಾವು PDS ಕಂಟ್ರೋಲ್ ಆರ್ಡರ್ ಅದು
ಶ್ರೀನಾಥ್ ಪಚಾಪುರಿ ಅವರು
ತಗೊಂಡ್ಬಿಟ್ಟು.
Ultimately, what Mr. Sadiq had argued on that day, and he had said, "We'll see to that he will not get it." That is being witnessed in this writ petition. Whenever he says. No contempt file madi, then court ordered, secretary was summoned. And thereafter, my lords, the license was.
Your lordship has directed, my lord, to grant license if other quality, my lord, there are some other disqualifications. On that ground, this was challenged. In review petition, your lordship disposed of, directing to approve, to work out remedies in this writ petitions.
No, he is also sailing with me because he's responded now.
ಇದರ ಮೇಲೆ ದಾರಿಕೊಂಡೆ filed a review also.
ಹೌದು, ಅದ್ರಲ್ಲಿ
That
interim order
also.
ಕೊಟ್ಟಿದ್ರು, ಅದು
That
ಈ
is, I think 6 months ago, I dismissed the review
yes,
also.
disposed, saying that these writ petitions are pending, you work out your remedy in that writ petitions. These are the writ petitions.
Now he is respondent, my lords.
My lord, I have, my lord, directed that petitioner advocate to file this writ petition. To be
ಅದಕ್ಕೆ
fair to
ಇವರು
the court.
PDS ನೋಡಿದ ತಕ್ಷಣ ಇದು ಪಚಾಪ್ ಶ್ರೀನಾಥ್ ಇದ್ದಂಗೆ ಇದೆಯಾ?
Next week, any fresh matters, my lord, so that it can be disposed.
List the matter in the fresh matters list on 18th.
Please. And my lord,
ಇಲ್ಲ 18th ಹಾಕಿ.
government advocate were directed to submit modern medical report. It is in the cause list note.
Medical report ಯಾರ್ದು?
This court directed, we took up a contention that he has no, my lord, disability as, my lord, in the rules. This court said, you get the, my lord, get it checked up before medical board and submit the report of petitioner.
Reports are filed on 25/9/25.
ಏನ್ ಡಿಸಬಿಲಿಟಿ ಇದೆಯಾ?
Just given the file just now.
ಆಯ್ತು 18th in fresh matters. 189.
Lords. The petitioner challenged the GST appeal which was rejected on the ground of delay, my lords, in filing. The petitioner is aged about 71 years, my lords. Due to his old age diseases, he was unable to file appeal, my lords.
This tomorrow in fresh matters list will dispose.
Coordinate bench has
ಅಲ್ಲ ಬರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬೇಕಲ್ಲ ಯಾರು? ಇವರೇನಾ? ಸ್ಟೇಟಾ?
state, my lords.
ಕೊಡಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
Delay of my lords for.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list and answered by the coordinate bench in so and so, wherein the coordinate bench considers the very issue with regard to entertainment of an appeal beyond the period of limitation under section 107 of the GST Act on sufficient cause being shown with regard, cause being shown. The learned counsel for the petitioner in the case at hand also has shown sufficient cause with regard to the health, with regard to his health being the reason for non filing an appeal within stipulated time. In that light, petition deserves to succeed with the same order. Yes.
Please.
190, Ewe Patil.
302 lords, general, 302 lords, parallel lords. General parallel lords, 302 offense lords.
304.
302 lords.
302.
Already in 12 years, 2 months in the.
ಎಷ್ಟಿದೆ?
12 years, 2 months.
12 years, 2 months. Yes, AJ. The petitioner is before this court seeking the following. Who is the petitioner? Madara. The petitioner, mother of the convict, is before the court seeking release of his son on parole. The counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the subject parole is the second in line and has served second in line, and there is no adverse against him while he was granted parole at the first instance. The learned AGA would submit that there is nothing against him in the prison or outside the prison, or had not outside the prison. In the light of the said circumstance, 60 days. Order earlier order. Earlier order ಹಾಕಿಲ್ವಾ? Same order, parole.
Page number 14 lords.
Same
lords.
Same offense.
Please, same offense, 11 years lords.
11 years.
Please.
ಅದರಲ್ಲಿ
12 years.
12 years. ಇಬ್ರು ಜೊತೆಗೆ ಹೋಗಿದ್ರು ಅನ್ಕೊಂಡು. Yes. Offense is ಮಾತ್ರ change, 11 years, 2 months.
Admission matters 192, Anil Kale.
This matter was heard, and your lordships were pleased to allow the petition, passing the proceedings.
ಏನಿದು?
My lord, in this complainant, my lord,
ಅವಿನಾಶ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ನಲ್ಲ ಬೆಳಗ್ಗೆ. Promise to marry. We'll keep up the promise of disposal.
Lord, by order dated 10th August 2023, lordships were pleased to allow this petition and quash the proceedings. After quashing of the proceedings, the complainant, my lord, has filed application to implead himself. He was not
hearing the complainant ಮಾಡಿದ್ರು ಅಂತ.
I was not made the party in.
Now he is, my lord,
ಪಾರ್ಟಿನೇ ಮಾಡದೆ ಹೋದ್ರೆ ಹೇಗೆ ನೀವು?
now, my lord, he has been arraigned and similar order, my lord, same order.
Satisfied that you are heard. ಏನು offense ಹೇಳಿ sir?
Offense, sir, my lord.
384 and
383, 353, 384 and 109. 109 of
353 police ಮನ್ನ ನೀವು? ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್?
Government servant.
Government servant, yes, my lords.
ಓಹೋ, ನಿಮ್ಮನ್ನ ಕೇಳ್ಬೇಕಾಗಿತ್ತು ಅಂತ. ಏನು ತುಂಬಾ ಗಲಾಟೆ ಮಾಡಿದ್ರ ಬಂದು?
My senior will argue in this matter, my lord.
Senior will argue?
Yes, he is on his legs in court all 6 months.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ?
Tomorrow or day after tomorrow.
List day after tomorrow for admission.
193.
Where is Dhananjay? ಕಳೆ ಅವ್ರೆ, ಧನಂಜಯ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಿಮಗೆ ಕೇಳಿದ್ದು
Dhananjay judgment, my lord.
ಇದೆಯಾ? ಎಲ್ಲಿದೆ?
I'll furnish.
ವಾಟ್ ಇಸ್ 353 ಅಂತ ಅದರಲ್ಲಿ ಇದೆ?
Yes, ma'am. In
ಸ್ಟೇಟ್
this
ಆಫ್
also, my
ಕರ್ನಾಟಕ,
lord,
ಧನಂಜಯ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ.
please, I'll get it.
193, Pawan B. Doddapi.
CRP.
711 application is.
Special orders.
Oh, day before yesterday.
Please.
Yesterday, no? Friday.
Friday's get 30th.
Yes, sir.
Lords, the claim of the plaintiff is that, lords, he is a kosher. Please, suit for declaration and injunction, claiming right of preemption. The grounds that, lords, he is a co-sharer.
711 what ground?
Co-sharer. Lords, I have contended that there is no cause of action and the suit is barred by limitation.
A and D.
Please, A and D.
A and D ಗೆ ಏನು ಕಾರಣ?
Lords, he claims that he is a co-sharer. In fact, the pleadings show that he is a cousin brother of, lords, the present defendant number 1 and 2. So he would not be a co-sharer. He is not a blood relation.
All right.
And in respect of, he claims that he is an adjacent landowner. In this respect, lords, the law is already settled by the Honorable Supreme Court. It says that, lords.
What is the date?
Please.
Allah.
Date of sale.
Limitation ಗೆ what is the date? Cutoff
Lords,
date you are taking?
Lords, the first demand has to be made immediately, lords. That is 12/1/2022 is the sale deed. He says, lords, he after got knowledge about the sale deed, he has filed the suit. That is on 19/1. There is a delay of 7 days.
7 days.
Please, even 12 hours delay is considered to be a belated stage, wherein, lords, right of preemption
Days
cannot.
delay.
Please,
But
delay.
will it not amount to mixed question of law and fact?
Please,
That's the only thing.
lords, he happens.
The latest judgment, Justice Pardiwala ಅವರು ಕೊಡಿ.
Please, day of
Question of
tomorrow, lords.
Apart from that, my lord, if I may submit, subject to what my learned friend says, parties herein are Mohammedans. Under Mohammedan law, 3 categories of persons are having a right to seek law of preemption, the right of preemption. One is, my lord, the co-sharers. Third one category is, my lord, even the adjacent owner who is totally, my lord, stranger to the other property. Even he can seek. My lords may kindly refer to Mullah. In that, my lords.
In respect of that, lords, law is already settled.
Only 3
Supreme
classes
Court
of
has held that it
persons
is
may.
unconstitutional.
Adu vicinage, that was right of vicinage. Only 3 class of persons may claim exercise of right under preemption under Muslim law. A person who is a co-sharer, that is, my lord, Shafi'i Sharik in the property sold. The person who is participating in immunities and appendages in the property, such as a right of way or discharge of water, Shafi'i Khalid. 3 owners of adjoining immovable property, that is Shafi'i Jar. 2 and 3 I come because I am adjacent owner, even if, my lord, for a moment it is held that, my lord, I am not a co-sharer. Admittedly, property was divided from the common ancestor between 2 of us. That is my plain pleading, which has to be looked into for the purpose of, my lord, Order 7/11 application. Now there is a common passage, my lord, in between both of our lands. But I use that way to reach my other land. Plain hand sketch map may kindly be seen. But if that is concerned, what all the grounds are raised now are the matter of trial. That cannot be a matter of order 7 to 11 application.
So far as adjacent land, what my learned friend is submitting, lots, law is already settled. Adjacent land owner cannot claim.
You get those latest judgments the Supreme Court gets, sir.
Is settled, lots, insofar as adjacent landowner is concerned, he cannot claim on the ground that he is an adjacent landowner. It is already held unconstitutional.
We'll see. Let's day after tomorrow.
Please,
In
now,
fresh
lots,
matter.
it is a stage of evidence, lots.
Fresh matter. Let the court not proceed to
Please.
the next day.
Please.
Let's day after tomorrow. The concerned court shall defer its proceedings till the next day.
Please.
List in fresh matters.
Please.
194.
Please, my lord, for supplement respond number 2 in the matter. And the petitioner is guilty of this suppressed factor because he has not produced the entire charge sheet material. With the lordship's kind permission.
Yaudidu?
My lordship, this matter, there is a civil suit pending for a relief of declaration, possession and injunction. Subsequent to the filing of the civil suit, a private complaint is filed. Civil suit is in Annexure J, my lord, page 75.
Lord, the other day I submitted a judgment to your lordship's kind consideration. I take your lordships to they have forged the survey records, created a fake seal and fake signatures. May I take your lordships to page 218, my lord? Page 214. Signature is fake. Seals are fake. In respect to this property, my lord, 3 properties have created records. They had no title. So based on this, my lord, they submit the application to the municipal corporation to pay the tax. And they contend that they have paying the taxes regularly, and that's how they are the owners. And they said that is unsuccessful. In fact, my lord, this property was purchased by the complainant's family way back in 1939 in court auction. And they have built a huge complex, a lodging, which is around 75 cents. So these worker sheds have been trespassed by the complainants. And my lord, may I take your lordships to for a minute, my lord, the certificate of the DDLR.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet is filed, my lords.
500 and odd pages, my lord.
500 and odd?
The very same charge sheet with your lordship.
ಇದೆನಾ?
ಇದೆ.
Charge sheet from your lordship may kindly find it at page 8.
You are accused number?
1, 2, 3. All accused.
ಎಲ್ಲರೂ ಇದೆಯಾ?
All of them. Not only, my lord, they did not manipulate the records. They also sold the property by registered sale to somebody else. And I'm not, they are also witnesses to the incident. And they have repaid the amount that was received by them. And when the prima facie case exists, my lord, the latest law laid down by the Honorable Appellate Court.
Tomorrow, fresh matters.
Please, public.
Password. 230 more. Password. ಆಮೇಲೆ ಬಿಗಿಟ್ಕೋಣ.
more list.
Avinash.
Matters pertaining to KBGN, my lord. On the other day, your lordship has stayed matter.
Same tag AC. Tag same order.
But my
Soon
state 1 and 2. My lord, these matters are listed on 18, my lord.
ಅವತ್ತೆ ಎಲ್ಲ.
Lord, ಅಂದ್ರೆ ಕನೆಕ್ಟ್ ಮಾಡೋದು ಬೇಡ ಸರ್, ಯಾಕಂದ್ರೆ ಅವು ಸರ್ ಕೆಲವರು ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವು ಹಿಯರಿಂಗ್ ಆಗೋದಿಲ್ಲ.
ಟ್ಯಾಗ್ ಇಲ್ಲ ಅವತ್ ಮಾತ್ರ.
Please,
ಎಲ್ಲ ಬರ್ಲಿ.
Please. All matters.
Full list ನಿಮ್ದೇನಾ?
Same, all same matters.
ಸರಿ.
1 and 2.
ಎಲ್ಲ ಲರ್ನರ್ AGA 1 and 2. ಇನ್ಯಾರಿದ್ದಾರೆ ಅಷ್ಟೇ?
ಅಷ್ಟೇ.
ಎಲ್ಲ on
All are private parties.
all 18th.
Please.
List all on 18th.
Oblige.
Not tagging, but in seriatim.
Oblige.
Past tour matters.
ಇಲ್ಲಿ 200 ಬಂತ. ಇಲ್ಲ.
Cell number 67. Sunil Desai.
Yes, sir.
Lord,
only contention is, my lord, that the 90 days which has been expired. My lord, I take your lordship's, my lord, page number
Your lordship's judgment.
94, my lord.
ಸಿಕ್ತಾ?
Please.
Yes.
ಹುಡುಗಕ್ಕೆ ಏನಾಗಿತ್ತು?
ನಾನೇ ಕೊಟ್ಟೆ ಅವ್ರಿಗೆ.
Xerox ಆಗಿರ್ಲಿಲ್ಲ, my lord. I had only one copy. Yes. Now, my lord, for a minute.
ಆಗಿರ್ಲಿಲ್ಲ ಗೊತ್ತಾಯ್ತು. Xerox ಆಗಿರ್ಲಿಲ್ಲ, ಹೊಸ ಗ್ರೌಂಡ್ ಬಿಡಿ.
Page number
for a minute,
94. 2 ನಿಮಿಷ. Sir,
permission of my lord. 1 second.
That is for the petitioner.
Page number 94. Lord, the validity of the tender period is 90 days. The date of the opening, it starts from technical opening, my lord. That is on 1/4/2025. My lord, admittedly, the tender has been finalized on 16/7/2025 after 105 days. So, my lord, it is clearly, my lord, did by Rule 22. My lord, apart from your lordship judgment, my lord.
You have also participated.
Yes, yes, I have participated. No, I have not participated in the final lottery system. I have refused. No, I messaged them, my lord, it is already lapsed. You can't proceed with.
ಅದು ಮಾಡಿದಿಲ್ಲ?
Yes, yes.
All right. ಈಗ ಅದಿರ್ಲಿ. ಲ್ಯಾಬ್ಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದಕ್ಕೇನು?
Please, my lord, may I take your lordships to the timeline.
Bid validity ಎಲ್ಲಿದೆ? Bid validity in the tender.
90 days. That is what 94.
From what date?
From 1/4/2025.
The judgment here is 180 days.
Yes.
For a minute, my lord.
90 days correct?
90 days correct.
Bid validity.
Please, may I take your lord, page 32 of the petition. There is a note. The district stand committee have reserved the right to update, change or modify any of the above time period is the condition that was in the tender document. Now I take your lordships to Rule 22 of the KTPP Act. Time taken for evaluation and extension. The evaluation of tenders and award of contracts shall be completed as far as within the period for which the tenders are held valid. The tender accepting authority shall seek extension of the validity tenders from the tenderers for the completion of evaluation if it is not completed within the validity period of the tender. For these, my lord, may I take your lordships to the annexer E1, F, Z, H, my lord. And my lord, even original tenders have been, from time to time, it is the
ABCD, EFG and
annexers andre, ಅವರು by virtue of the particular tender clause, by virtue of Rule 22(3), the period has been extended from time to time to finalize the tender. And he did not participate in the final bid while picking up the lottery. And he has received his EMD amount also.
Tender period extend ಆಗಿರೋದು ಎಲ್ಲಿದೆ?
My lord, from 5th June onwards.
What is the period?
No, it is not extension. It is fixing of a date of lottery, not extension. They are not sought as clause 2 of subclause Rule 22. They are not for they are not sought for extension from the tenders. They themselves fixed it.
ಎಲ್ಲಿ ಎಡ್ರಾಮಿ ಸರ್ ಏನು ಓದಿರಲ್ಲ ಎಲ್ಲಿ?
Please.
ಓದಿದ್ರಲ್ಲ ಎಲ್ಲಿ ಅದು?
My lord,
96, page number 96.
Page number 96 onwards.
96.
Please, my lord.
ಬಿಡ್ ನಲ್ಲಿ ಆಯ್ಕೆಯಾದ ಎಲ್ವನ್ ಬಿಡ್ ದಾರಗಳ ಮರಳು ಬ್ಲಾಕ್ ಗಳನ್ನು ಒಬ್ಬ ಯಶಸ್ವಿ ಲಾಟರಿ ಮುಖಾಂತರ ಆಯ್ಕೆ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆ ಬಗ್ಗೆ ಸರ್ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ ಯಾವಾಗ? ನೀವು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಇನ್ನು ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಸ್ಟೇ
ನಮಗೆ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಪ್ರೊವಿಷನಲಿ.
ಅಲ್ಲ ಆಯ್ತು, ಸ್ಟೇ ಆಗಿದೆ ಯಾವತ್ತು?
So, my lord, on 11th June it is finalized.
23rd, 7th.
And the 7th July work order has been issued to us. Provisional work order is issued to 7th July.
7/7/2025.
By tender process finalized the 11th June. And I have invested around 1 crore. 75 ಲಕ್ಷ ಬ್ಯಾಂಕ್ ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ದುಡ್ಡು ತಗೊಂಡು ಬಂದು ಬಿಲ್ಡರ್ ಬ್ಲಾಕ್ ಸ್ಟೇ ತಗೊಂಡು
ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
The whole process will take its own time.
No, it has to.
ಆಮೇಲೆ one more submission lordship is sand being an essential community since July building construction ಸಿಕ್ಕಾಪಟ್ಟೆ ಹವಾಕಿದೆ ಸ್ಯಾಂಡ್ಸ್ ಈಗ.
ಅದಕ್ಕೆ ಅವ್ರು ಲಾಟ್ರಿ ನಲ್ಲಿ
ಅಲ್ಲಲ್ಲ.
ತಗೊಂಡಿದ್ದಾರೆ. ಹೆಂಗ್ ತಗೊಂಡಿದ್ದಾರೆ ಅದು ಬೇರೆ ಮಾತು. ಲಾಟ್ರಿ
How that guilty is, instead of seeking only their own tendered blocks, 2 ಬ್ಲಾಕ್ ಹಾಕಿದ್ರು. ಅದ್ರ ಬಿಟ್ಟು 12 ಬ್ಲಾಕಿಗೂ they have taken.
ಇಂಟೆಂಟ್
22 ಹೋದ್ರೆ ಎಲ್ಲ
ಎಲ್ಲ ಹೋಗುತ್ತೆ. ಇಂಟೆಂಟ್ ಆಫ್ ದ ಟೆಂಡರ್ ಇಂಟೆಂಟ್ ಒಂದೇ ಇದೆ,
ಈಗ
ಬ್ಲಾಕ್ಸ್ ಬೇರೆ ಇದೆ.
1/4/2025
1/4/2025
Last
ಓಪನಿಂಗ್
date.
ಲಾಸ್ಟ್ ಡೇಟ್ 105 ಡೇಸ್ ಆದ್ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಅದರಲ್ಲಿ ವರ್ಕ್ ಆರ್ಡರ್ ಅಂತೂ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ನಮಗೂ ಕೇಳಿದ್ದಾರೆ ಅಂತಾನು ಹೇಳಿಲ್ಲ. ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ದಟ್ ದೇ ಹ್ಯಾಡ್ ಅ ಡಿಸ್ಕ್ರಿಷನ್, ದೇ ಕ್ಯಾನ್ ಎಕ್ಸ್ಟೆಂಡ್ ಇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಯಾಕೆ ಸರ್ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ?
Mike.
I filed objection, my lords, on behalf of the state.
ಫೈಲ್ ಮಾಡಿಲ್ಲ,
ಮಾಡಿದೆ.
ಕಾಪಿ ಇಸ್ ನಾಟ್ ಗಿವನ್ ಟು ಎನಿಹೌ ಯು ಕ್ಯಾನ್
ಆಯ್ತು ಹೇಳಿ.
ಹೇಳಿ.
On the ground of jurisdiction itself, my lords.
Jurisdiction.
ಹೌದು. ಯಾಕಂದ್ರೆ since it is, my lords, issuance of license. My lords, so kindly see, I filed objections, my lords, kindly annexure R1 in.
ಏನ್ jurisdiction ಹೇಳಿ?
Please. As this is the, my lords, the memo which is issued by the.
ಏನ್
This are-
jurisdiction ಹೇಳಿ sir?
It is noticed that the matter pertaining to Green Bench are not being listed in accordance with the notification so and so. As the above referred notifications, all the writ petitions and writ appeals relating to grant of lease, license of mines and minerals.
ಇದ್ರದಾ? ಅಲ್ಲಿ ಇದು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್.
Principal bench.
ಗ್ರೀನ್ ಬೆಂಚ್.
Green bench.
ಆಯ್ತು, ಇಂಟ್ರಿಮ್ ಇಟ್ ಮೇ ಬಿ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ಎಕ್ಸ್ಟೆಂಡಿಂಗ್ ದ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
ಅಲ್ಲ, maybe
The
dispute
issue
with the liberty
will
to
be the
approach
same,
Green
Lord.
Bench.
Sand mining.
Sand mining. All minor and minerals, whether major or minor or major.
Let them withdraw the writ petition and approach.
Where is the question? It can be transferred.
Very easy. ಅದೆಲ್ಲ ಮಾಡಲ್ಲ ನಾವು. We will direct the matter to be placed before division bench confirming the interim order.
The interim order may kindly be modified at least to the extent.
No.
Rule 22 ಹೋಯ್ತು ಅಂದ್ರೆ ಹೋಯ್ತು sir.
It's not green bench and non-green.
This need not go there also. It is not stricto sensu, it is not a mining.
It will not, my lord, because it says it is the order of the court which, my lord, memo which has been referred. It grant of lease and license to the mining. It will not come, my lord. Otherwise, the office would have raised the objection saying that it is
The
not.
office is not so.
ಇಲ್ಲ ಮಾಡ್ತಾರೆ, ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಅದೆಲ್ಲ ಆಫೀಸಿಗೆ ಕೊಡಬೇಡಿ.
ಇಲ್ಲ ಮಾಡ್ತಾರೆ. ನಮ್ ಲಾಸ್ಟ್ ಪೀರಿಯಡ್
ಅವ್ರು ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು ಮಾಡಲ್ಲ.
ಹಂಗಿದೆ. ಬಟ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದ್ ಕರೆ ಸತ್ಯ. It will not, Lord, it will not.
ಯಾ ವಿನಯ್. ಕಷ್ಟ. ಇದು ಮೈನಿ ಅಲ್ಲಿ ಕಳ್ಸಲ್ಲ ಹನುಮಂತ ರೆಡ್ಡಿ ಅವರು.
Please.
ಹನುಮಾರೆಡ್ಡಿ ಅವರು.
Please.
ನಾನು ಅಲ್ಲಿ ಕಳ್ಸಲ್ಲ. ಪೆಟಿಷನ್ ಕಷ್ಟ. Rule 22 straight violation. Bid validity period 180 days ಇದ್ರೆ it's a different thing. Bid validity period is 90 days, circular will become straight away.
Bid validity period ಹಾಕ್ಲಿಲ್ಲ ಅವರು ಇದರಲ್ಲಿ ಟೆಂಡರ್
ಡಾಕ್ಯುಮೆಂಟ್. ನಾನೇ ತೋರಿಸಿದ್ದೇನೆ. ಪೇಜ್ ನಂಬರ್ 94 ಡಾಕ್ಯುಮೆಂಟ್, ಟೆಂಡರ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ annexure D, it start from 94 ದಲ್ಲಿ ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ವ್ಯಾಲಿಡಿಟಿ ಪೀರಿಯಡ್ 90 days. ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ 90 days ಲಾಸ್ಟ್ ಡೇಟ್ ಟೆಂಡರ್.
ಅದು ಬಿಡ್ ವ್ಯಾಲಿಡಿಟಿ ಅಲ್ವಾ?
ಇಲ್ಲ, my lord, this was not noticed by.
Not noticed.
But one, my lord, my submission, my lord, the whole process was completed by 11 June. Work order process issue ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗ್ಬೇಕು ಫಾರ್ ದ ಪರ್ಟಿಕ್ಯುಲರ್ 5 years period ಗೆ.
ಈಗ ನನ್ನ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಚಾರ್ಟ್ ಹಾಕಿದ್ದೀನಿ.
ಹೌದು, ಅದನ್ನ ನಾನು
ಆ ಚಾರ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ ನೋಡಿ.
ಆ ಸರ್ಕ್ಯುಲರ್
Issuance of work order, purchase order on or before the 91st day.
ಅದನ್ನ annexure ಎಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಆ ಸರ್ಕ್ಯುಲರ್ ನ annexure ಎಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಪೇಜ್ ನಂಬರ್.
On or before the 91st day. Not even the next day.
ಇದರಲ್ಲಿ ವರ್ಕ್ ಲಾಟ್ರಿ ಮಾಡಿರೋದೇ 16/7 ಗೆ. ಸೊ ವೆರ್ ಇಸ್ ಅ ಕ್ವಶನ್ ಆಫ್ 11/7 ಗೆ ಅವ್ರಿಗೆ ಫೈನಲೈಸ್ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. 16/7 ಗೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿರೋದು.
Fresh tender. The petitioner is before this court seeking the following prayer. Heard the learned counsel Sunil Desai appearing for the petitioner, learned senior counsel S.S. Edrami representing the
Impleading respondent number 5.
ಓ, ನೀವಿನ್ನೂ ಒಳಗೆ ಬಂದಿಲ್ವಾ?
Implead ಆಗಿದೆ,
ಆಗಿದೆ,
ಅವ್ರ
ಆಗಿದೆ,
ಅಮೆಂಡ್
amendment ಆಗಿದೆ.
ಮತ್ತೆ impleading ಅಂತ ಯಾಕೆ?
ಅಲ್ಲ ಇಂಪ್ಲೀಡ್ ಆಗಿದೀವಿ ಬಟ್ ಅವ್ರ ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಕಾಸ್ಟ್ ಟೈಟಲ್.
ಇಲ್ಲ, ಹಾಕಿದ್ದೀನಿ,
Impleading
amended
application
petition
ಅಲ್ಲ
ಆಗಿದೆ.
ಆದ್ಮೇಲೆ impleading applicant ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀರಾ? The petition, SS Yedrami representing the, ಯಾವ respondent? Fifth respondent.
Fifth respondent.
5 is made.
Respondent number 5. ಎಲ್ಲಿ amendment?
ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿದ್ದೀನಿ, ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿದ್ದೀನಿ,
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
Amended cost schedule ನೋಡ್ಕೊಳ್ಳಿ. The facts in brief germane are as follows. The third and fourth respondent issue an e-tender notification seeking applications from eligible tenderers for quarrying, for leasing out sand blocks. The petitioner and the fifth respondent, both finding themselves eligible, submit their tender documents pursuant to the tender. This is not in dispute. The issue in the list is with regard to the tender process being taken to its logical conclusion contrary to Rule 22 or the circular issued thereon. The this court, owing to the submission of the learned counsel for the petitioner, had granted an interim order of stay of further process of the tender. The said interim order is subsisting even today. The learned counsel Sunil Desai takes this court through the documents appended to the petition to prima facie demonstrate that the validity period in the tender is 90 days. The validity thus would expire on 1/4/2025, and the process of taking the tender to its logical conclusion is taken up only in the month of July 2025, which is long after the expiry of 90 days from the date of issuance of the tender, and 90 days. Therefore, it is contrary to the circular or the law laid down by this court interpreting the circular, by this court or by the coordinate benches of this court interpreting the circular. Per contra, the learned senior counsel SS Yedrami, appearing for the fifth respondent, would vehemently refute the submission, contending, ಏನು ಹೇಳಿದ್ರಿ?
Condition, my lord. Timeline.
ನಾನು ಹೇಳ್ತೀನಿ. Contending that there is no hard and fast rule that the tender should be taken to its logical.
Only direct train, not mandatory.
Hard and fast ಅಂದ್ರೆ ಅದೇನೆ ಸರ್. Hard and fast rule that the tender should be taken to its logical conclusion within a period of 90 days. Certain play in the joints of the state government should be permitted, as sometimes due to administrative delays, the tender would not get concluded within 90 days. He would further submit that on the strength of a work order admittedly issued in the month of June 2025, the respondent has now invested 1 ಕೋಟಿ.
ಹೌದು.
Invested.
ಅಂದ್ರೆ 25 lakhs so towards EMD, 75 lakhs towards bank guarantee. All of them.
ಬರುತ್ತೆ ಬಿಡಿ.
Not only me, all the 12 successful bidders.
ಎಲ್ಲ ವಾಪಸ್ ಬರುತ್ತೆ.
Along with interest from July. ನೀವು ಅಲ್ಲ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕಟ್ಟಬೇಕು ಅಂತಂದ್ರೆ
you are wanting to perform your marriage in Hishamiyana.
ಅವ್ರಿಗೆ ಬಂದಿಗೆ ಕುಂತ್ಕೊಂಡ್ರೆ they are following the whole.
ಏನ್ ಹೇಳಿದಮ್ಮ?
And extendable by Rule 22, Sub Rule 2 and the timeline.
The learned counsel would further submit that the rule is the rigor of Rule 22 is controlled by Sub Rule 2 of Rule 22 as it is extendable. He would further submit that the petition be dismissed as it is a matter of contract and this court should not interfere at every stage of the tender.
Page 32, last line.
ಏನದು?
The district sand committee has reserved the right to update, change or modify.
The learned senior counsel would also take this court through the observation in the tender document that it is permissible for the district
sand committee.
District sand committee to extend the period of limitation as obtaining under Rule 22. The learned AGA would submit that the jurisdiction The learned AGA would toe the lines of the learned senior counsel in seeking dismissal of the petition. I have given my so and so actions. Therefore, narrated facts are not in dispute. The tender for the purpose for which it is issued is as follows. Page 17. The petitioner and the respondent participate in the tender. The validity in terms of the tender is clearly depicted to be 90 days. It reads as follows, page 94. The tender is notified on the date and time of opening of the technical bid is 1/4/2025. Therefore, 90 days, 1/4/2025. The rule or the circular which depicts a timeline for conclusion of the tender once the opening of the technical bid happens is considered by this court in so and so period petition wherein this court is held as follows. If the law as laid down by this court in the aforequoted judgment is pitted against the facts obtaining in the case at hand, the 90-day period would come to an end on June 25th, 2025. When the tender is not taken to its logical conclusion even till the date of the interim order is granted by this court on
On 11th June, the whole process was completed.
On 11th June.
23/7/2025. interim order. 3/7/2025.
3/7/2025.
For a minute, on 11th, the whole process was completed.
ಯಾವತ್ತು?
Lottery
11 July.
No, 16/7 ಗೆ ಡೇಟ್ ಆಫ್ ಲಾಟರಿ ಇರೋದು. ಹೆಂಗ್ 11/7 ಗೆ? ಡೇಟ್ ಆಫ್ ಲಾಟರಿ ಡೇಟ್ 16/7 ಗಿದೆ.
The documents appended to the petition would clearly depict that the date of lottery to award the contract is on
16/7/2025.
If the period had expired on 25th June 2025, it is ununderstandable as to how the state could fix the drawal of the lotteries long after the expiry of 90 days as stipulated in the circular. The circular is a reflection of Rule 22. Rule is a reflection of a validity period in the tender document. The tender document depicts 90-day period to be the 90-day period to be the validity period. If the validity period is now considered in terms of Rule 22, the circular and the law, the impugned tender would necessarily to be held to be invalid on the aforesaid score. Therefore, reserving liberty to the respondent state to re-notify the tender if they so desire, the subject tender proceedings would stand necessarily obliterated. The learned counsel for the respondent submits that all the tenderers have deposited 25 lakhs EMD
plus 75 lakhs bank guarantee.
75 lakhs bank guarantee. If the
Way back from July.
If the state is wanting to issue a fresh notification of tender, the aforesaid amount of all the tenderers could be used for the ensuing tender, failing which the tenderer should not be driven back to this court again seeking a mandamus for refund of the amount. The amount in deposit, either EMD or the bank guarantee, shall be refunded in accordance with law to those tenderers.
Within a time period.
To those tenderers. For the aforesaid reasons, the following order. Petition is allowed, tender so-and-so stands quashed with the aforesaid liberty as indicated in the course of the order.
Nice.
$111. Sadhana is this side.
So petitioner. At the outset, my apologies. My colleague mentioned Passover at 2:30 minutes. I'm very sorry.
No problem. Yes, madam.
Miss, what I'm seeking is a mandamus to consider my representation at Annexure J, page 104. My lords may kindly turn 2 minutes for a second. Page 104 minutes. What I've written is to the bank, minutes, responding bank, I, the undersigned so and so, managing partner so and so, request you to provide us a revised ledger extract of the above mentioned firm after reversing all the expenses charges as per the DRT Bengalore's order dated 30/10/2024 within 10 days from the receipt of this letter to enable us to know the final amount to settle the account. But this annexure has arisen by virtue of a DRT order at page. Let's page 90, my lords may kindly take 91, my lords.
90.
Page 91 is 91 minutes. The operative portion of the DRT order minutes. That's got it.
Oh, it is held in your favor.
Yes, minutes. I may be permitted to read out what the DRT has held minutes. First is, minutes, this tribunal declares that the measures taken by the defendant bank through its first defendant authorized officer under section 13 of the Act, including issuance of demand notice dated so and so under 13(2) of the Act, are invalid and thus set aside. The defendant bank through its first defendant authorized officer is directed to restore the possession of the secured assets to the applicants within 7 days from today. The defendant bank shall reverse all costs, charges and expenses incurred by it or any expenses incidental thereto in connection with the impugned actions taken against the applicants under section 13 of the Act and shall not claim them as legally recoverable debt by operation of law. The defendant bank is granted liberty to invoke the provisions under the Act for enforcement of security interest over the secured assets afresh in accordance with the provisions of the Act and the rules made thereunder meticulously. Now, what drives me to this honorable court is the operative portion at point number 3 and 4 minutes. Because of point number 3 minutes, I have sought the representation minutes to give me a revised outstanding amount, which now the bank is not entertaining minutes. Also minutes, the bank, since the tribunal under point number 4 has also given liberty to take all the steps available under law, I'm seeking an interim relief at point 1 minutes. I've sought interim relief in 2 minutes. The first interim relief what I'm seeking minutes is until the DRT order is followed, the bank should not initiate any steps under the Act. That is, they have to first provide me after reversing the charges, penalty, etc. They should first give me the outstanding. So before following the DRT order, let them not initiate any fresh steps under surfacing. This is my first interim relief.
They heard the learned.
One more submission.
One more you have?
Yes, I've sought for 2 interim reliefs. The second interim relief. May I please, The second interim relief, says, now petitioner is a partnership firm doing business in pharmaceutical, wholesale dealership of the pharmaceutical medicines. Now there were several partners. One partner has retired. His name is Sampgaon. One Mr. Sampgaon. Srishalappa Basparappa Sampgaon. Now he has offered one of his property as a security asset, which is a residential house where he is living with his family. He is 75 years old and he's suffering from some continued illness. Now he has already retired as a partner. Now I'm through this interim relief seeking, if I may be allowed to partially redeem just this property for this reason, Firstly, his health issue and that he's retired, although it's not very sustainable in law. The ground I'm canvassing for this is, now the bank had sanctioned me 3 crores rupees. It's a cash credit limit. Out of 3 crores, it has dispersed 2 crores 10 lakhs and unilaterally withheld 90 lakhs. So because it has withheld, it had a direct impact on my business and I had to close the business. Now, because it has withheld, it in stricto sensu, it amounts to novation of the contract unilaterally. And they cannot do it unilaterally Unless, my lords, the mortgage deed provides for it, even if the mortgage deed provided for it, they should explain the reason, valid reason why it is withheld. It has withheld 90 lakhs, my lords. So what I'm seeking is, if at all the bank may be directed to consider, my lords, entering into new terms and conditions to release this particular property is all that I'm seeking. Because, my lords, actually the bank is a breacher of the contract because it has withheld 90 lakhs, which it originally sanctioned for me. So a breacher cannot seek to enforce the contract in its original form as it stands. Now, my lords, another contention is, if my lord sees the demand notice at Annexure D, my lords, Annexure D, page number 50, there are 14 properties which were made as a collateral, my lords. Then it issues a possession notice at Annexure E, page 58, only listing out 3 properties. And in one of those 3 properties, this is also the property which I'm now seeking redemption. Now, it chooses to pick and choose out of the 14 properties, my lords. It may as well, my lords, choose to make some other collateral to enforce against it, my lords, and this property may be redeemed, is what I'm seeking, my lords. So this honorable court under 226, if it can
Second prayer, the second prayer is a little difficult. We will consider the first now, second later we will see.
Yes, at
Heard
least
the
can
learned-
may I please request this honorable court to frame a question for the respondent to answer that why, my lords, if it can
That we will-
enter into new terms and conditions.
that we-
Because, my lords,
that we will-
in surface there is no bar to, my lords, for mortgage deed to be amended with the consent of the parties.
The heard the learned counsel Srimati Sadhana S. Desai appearing for the petitioner. The petitioner is before the court seeking a direction by issuance of a writ in the nature of mandamus, directed to consider a communication dated 31/7/2025 from the hands of the petitioner to the respondent. A little backdrop to the said communication is the petitioner had approached this court in writ petition. Justice Magdum or order. Which page is that?
My lords, that is,
Justice Magdum or order ittala?
yes, my lords.
Had
That is
approached
at
this
page
court
100, my lords, Annexure H.
105748 of 2022. The said petition comes to be disposed by an order dated 11th April 2023 directing the petitioner to approach the DRT. The petitioner then approaches the DRT. The DRT, by the following order, allows the application, securitization application filed by the petitioner by the following order, page 91. A direction is issued at clauses 3 and 4 supra, holding that the action of the bank was contrary to law, and the bank contrary to law, and possession of the property should be restored to the hands of the borrower. The bank was granted liberty to invoke the provisions under the Act in accordance with the provisions of the Act and rules made thereunder. Pursuant to the same, the petitioner has represented to the bank. The representation has gone unheeded. Unheeded for the reason that the bank is now wanting to take steps under the SARFAESI Act, without at the outset complying with the direction of the DRT in SA 284 of 2024. Therefore, there shall be an interim order directing the bank not to precipitate the matter, the proceedings under the SARFAESI Act, without at the outset complying with the order passed by the DRT, quoted supra. The learned counsel further submits that the petitioner is a partner who has retired. He is a retiring partner. There is new induction after the petitioner. The mortgage, though one of the signatory to the mortgage was the petitioner, the learned counsel submits that under the SARFAESI Act there is no bar to amend the mortgage in the teeth of the aforesaid circumstance, or the circumstance of the like that is now projected. Therefore, the bank shall also consider the same. The bank shall also answer the same on the next date of hearing. However, no further steps quay the SRPC Act shall be taken by the bank till the next date of hearing. The yaar appear agidru madam Munche?
Let's see. DRT Bank, my lords, an advocate filed.
SP Muttalli, who had appeared earlier in writ petition 105748. Idar avರೇನು madam? ಇಲ್ಲ ಗೊತ್ತಿಲ್ವಾ? So the petitioner shall serve on any panel counsel representing the respondent Axis Bank. Reserve Bank ಯಾಕೆ? Why you need Reserve Bank?
Because it has indulged in unethical practices and it's because there are 2-3 situations where may not be becoming.
Panel counsel representing both the Axis Bank and the Reserve Bank list the matter on
Let's hand summons on the respondent.
the respondents be served. Apart from taking out steps, the petitioner respondent shall be served by way of hand summons as well. List the matter on 28th November. Yes.
Grateful.
Yes.
128. Shanti Skardevar.
For the petitioner.
My
lords, appear for the respondents. The
petitioner,
my lord.
Yes, sir.
Is appointed as my lord additional district government pleader to the my lord 11th
Allah,
district.
Vijay Kumar, sir. One day, how do you change?
My lords.
Let me make one submission. I had filed a caveat, my lords, on 31st.
New appointee, yeah?
Yes, new appointee.
Very influential.
Caveat is not listed. It's not put up. Now I am instructed to file wakalat. Set of papers, my
Granted,
lord.
my lord, let them. I seek my lord interim order. Already I have appeared in one matter.
So what? Don't think to the post, sir. Wait.
In fact, I have taken charge and appeared in matters, my lord, on 31st, my lords.
Kindly see notes.
Documents are here.
Comment. You are the root cause for all this problem. Why did you appoint him first? Yeah, ನೀವ್ರಿಗೊಂದು ದಿನ ಕೊಡೋದು ಅದೇ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇನ್ನೊಬ್ರು ಕೊಡೋದು ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ 24 hours ಅಲ್ಲಿ. How do you sustain this, sir? What is all this?
Lords, there are no malafides as such, my lords, as my lords are aware.
It is on the face of it malafide. What is it?
Finally, the client, my lords, decides who their lawyer is.
Malafide is a lower rung of arbitrariness. This is arbitrary. I have myself rendered so many orders.
Please. My lords, in this case, my
They
lords,
may have no right. See, the government advocates so appointed have no right saying that I should only be continued. But the action of the state should not be arbitrary.
Arbitrary, yes.
Adhike I had imposed 100 rupees cost.
I am bowed on, I'm aware.
Though the term was over, all that by the time writ petition could be taken up, term was over. But you can't act arbitrarily like this. Athini na?
Athini, lordship. Sitting at Athini. District court.
Tumba important.
Additional district.
This is the only lord district court newly established. Upon the application filed by the petitioner, lord, new post has been sanctioned.
Applied, is it?
New post has been sanctioned.
Both of you had applied.
So the district
No,
judge
he has not at all applied.
No, there is no application.
I have applied, and the entire process has been taken about my lord 1 year, about 10 months, and they have written a letter to the my lord district judge. Kindly see my lord page number 19 annexure B.
Lords can permission.
The district judge has given my lord approval saying that there is a requirement of one post of sanctioning to sanction the post, and accordingly my lord annexure C, my lord, that order came to be passed appointing the petitioner as ADGP. Very next day, my lord, after that, my lord, I have appeared in one.
My only request for today would be, my lord, my appearance may be taken note of. Let a petition copy be served. Tomorrow it may be taken. I'll see the petition grounds and my lord, because 31st, 30th next day I have taken charge and CTC is also given. 31st I have entered appearance in 2KC. The earlier my lord in charge ADGP. There was an in charge for this post.
When did you?
No, he did not take charge at all. He was appointed on 28th. No charge was given. 29th I was appointed, my lord. On 30th charge is given to me.
Annexure D.
ಮತ್ತೆ appear ಹೆಂಗಾದ್ರಿ court ಅಲ್ಲಿ?
Annexure D. Kindly.
Charge ತಗೊಂಡಿದ್ದೀರಾ?
I have appeared, and the district judge
Charge
has
ತಗೊಂಡಿದ್ದೀರಾ?
the very next day, my lord, my lord, it is
Charge
politically
ತಗೊಳ್ಳಿಲ್ಲ,
motivated
charge
one, my lord. They have not given charge. I have, my lord, with the permission of the court, I have appeared in one of the case, and very next day, my lord, this order came to be issued. And it is contrary to the rules.
No, it is not.
In fact, my lord's judgment, my lord, considering both line of judgments, ultimately the conclusion was that, my lord, if he has come from the back door, he has to go from the back door.
That's what I have written.
So that has been confirmed by the division bench
Covered
also.
by the judgment, lordship.
My lord's order has been confirmed by the division bench also.
It is
One who
covered by
comes from the back door should go from
Yes.
the back door.
my lords.
You are a backdoor entrant.
No.
Selection
No,
process.
he can't, my lord, seek
Illa,
that, my lord, as
there
a,
is no selection process
he
as
can't
such.
seek
my
that
lord.
as a vested right.
No.
Yes, Vijay Kumar, ಏನು?
Illa, there has been no selection process as such. There has been no issuance of notification calling for filling up vacancies. All that is, with great respect, not correct, my lords.
In fact, what transpired is, my lord, I was the first applicant. My name was front running, but he got appointed, my
Relevant
lord,
law.
bypassing me.
The Karnataka law officers rules. The
First
Karnataka-
backdoor entry.
Don't get too touchy, sir.
Illa, in fact, all of them are backdoor entrants only, my lords. It's a spoiled system, as my lords are aware.
Don't get so touchy.
ಅಲ್ಲ, ಇದೇನ್ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
Don't get into the shoes of the client.
I'm sorry, my lord, I am not getting.
ಹೇಳಿ. ಅಲ್ಲ ಬ್ಯಾಕ್ ಡೋರ್ ಅಂತಂದ್ರು ನೀವು ಸೀರಿಯಸ್ ಆಗ್ಬಿಟ್ರಲ್ಲ ಅದಕ್ಕೆ ಏನ್ ಬ್ಯಾಕ್ ಡೋರ್
ಇಲ್ಲ, ಅದೇನಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನಂಗೆ. They are coming from back door.
ನಾಳೆ ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Lord, assert, my lord.
Yes.
Lord, it is covered by decision.
Correct. ಕೊಡಿ ಅದು ಯಾವ ಕವರ್ಡ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ನಿಮ್ ಪ್ರಕಾರ. Because I have rendered a detailed order in one case.
No, this case, my lord, sir, please do.
I think that is.
My lord, list of authorities.
And Lord, there are
Considering
rules.
both line of judgments.
Yes.
Single hidkondu,
No,
my lord.
both I have considered.
Yes, and that has been confirmed by the division bench of the
Exactly.
Yes.
Jagdish.
Idralli, my lords ultimately adopted the second line of conclusion. That, my lord,
ಇದು ಯೂನಿವರ್ಸಿಟಿ ಇರಬೇಕು.
yes, but the provision is parametry.
ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಬರ್ದಿದ್ದೀನಿ ಒಂದು.
That's
But
also
it
there. That
covers-
is, my lord, I have one judgment of Justice Pradeep Singh Yarur. Government advocates are there.
Advocates I have myself written
Yes, yes.
considering everything.
Lord,
In this,
it
why
comes
I
under, my
have this
lord.
judgment is, my
So
lord.
this was taken to the division bench, is it?
Yes, my lord. Why I placed reliance is, but exhaustively, my lords have dealt with both line of judgments. Where, my lord, the Supreme Court said it can't be arbitrary anta single ಅಲ್ಲಿ ಹೇಳಿದ್ರು. But in the other judgment, for 1994 judgment, it said that, my lord, one who comes from the back door, it has to be exit has to
They
be from
can't
the
go
same
beyond
door.
rules, your lordship. The Karnataka law officers rules 1977. My lord, rule 5, my lord, it's specifically, my lord, it is in favor of the, my lord, petitioner.
ನಾಳೆ.
Please. Please.
Consider the whole hog tomorrow, don't worry. Yes.
Please.
My lords
List
came
tomorrow in
permission.
fresh. Yes, Vijay Kumar sir.
Please, my lords, I wish to place a list of authorities for my lord's consideration. It may be
ಇದೆ
taken on.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಯಾವ್ದು?
Please,
The same authorities which my lord has placed reliance upon on my lord's judgment, my lords. State of UP.
ಅಲ್ಲ legal remembrance ಅದೇ ಇರೋದು.
Please, my lords.
Johari Mal, I think. Johari Mal
Johari Mal is the latest 2004 judgment.
Johari Mal, Sri Lanka Vidyarthi.
And one more submission, lords.
Sri Lanka Vidyarthi.
Lord, the respondent number 3 is already, my lord, he is a panel advocate for KNNL. This is also government entity.
I have resigned.
ಹೌದು. ಅದು because of this already appointment.
I have resigned and submitted my resignation. That also I'll place on.
My lord, after passing this order, my lord, they have given resignation.
It is not an office of profit.
All right, list tomorrow in fresh matters.
Please.
Oblige.
My appearance for respondent number 3 may continue.
Learned Counsel Girish Advard accepts notice for the third respondent.
Please, I shall follow tomorrow.
1 and 2 government.
Paralla accepts notice.
David was
for
filed by the other
registry to
counsel.
print the name of Girish Advard as appearing for the third respondent. ಅದು ಬಂದಿಲ್ಲ ಅಂದ್ರೂ ಬನ್ನಿ.
Yes.
So list tomorrow in fresh matters list.
Please. 1 and 2 government. Please. 1 and 2 government.
1 and 2 state.
Please.
Yes.
Obliged.
Oblige, my lord.
Yes, sir.
41, Avinash Mangadi. 41.
ಅಮೋಲ್ ಆದ್ಮೇಲೆ ಯಾವ್ದು ಬಂದಂಗಿಲ್ಲ ಅಲ್ಲ? ಅಮೋಲ್ ಆದ್ಮೇಲೆ ಯಾವ್ದು ಬಂದಂಗಿಲ್ಲ. ಕೊಡಿ. I've already referred in this. The petitioner is before this court calling in question, ಎಷ್ಟು ವರ್ಷ relationship?
2.5 years.
Calling in question the proceedings in CC, special case ಅಲ್ಲ?
No.
FIR ಅಷ್ಟೇನಾ?
ಹೌದು.
Calling in
No,
question.
charge sheet is also filed.
SC.
Charge sheet is filed. SC.
Calling in question proceedings in SC 15 of 2024, registered for offences punishable under section 376(2)(n) and 506 of the IPC. Heard, the learned counsel appearing for the petitioner, the sole accused, and the learned AGA and appear ಆಗ್ತಾರೆ ಇದರಲ್ಲಿ. Criminal cases ಎಲ್ಲ ಇದೆ. ಯಾಕೆ ನಿಮಗೆ ಹೇಳಿದಾರ ಹಂಗೆ?
ಇಲ್ಲ. Usually we appear, my lord.
Always HCGP ಅಲ್ಲ.
Yes, our ಹೆಸರು.
So and so, ಅದು ಹೆಸರಲ್ಲ, this question is not this, that, generally, yes. So and so, learned AGA appearing for the respondent state. The learned, the de facto complainant, though served, remains unrepresented. Facts in brief, Germain, are as follows. The second respondent is the complainant. The complainant and the accused are said to have met on, where is the complaint?
Lord, page number 12.
Are said to have met ಇಷ್ಟೇನಾ?
Next page, 12, 13.
ಇಷ್ಟೇನಾ? ಎಲ್ ಮೀಟ್ ಮಾಡಿದ್ರೆ ನೀವು ಅಂತೇನಿಲ್ವಾ?
Same village, my lord.
2.5 years ಅಂತ ಹೇಳಿದೆ ಇಲ್ಲಿ.
My lord, ನಮ್ಮೂರಿನ ನಮ್ಮ ಸಮಾಜದ ಸುರೇಶ್ ಮಾರುತಿ ಅರ್ಬಾ ಇವನು ನನಗೆ 2 ವರ್ಷದ ಹಿಂದೆ ಪರಿಚಯವಾಗಿದ್ದು ನಂತರ ನಮ್ಮಿಬ್ಬರ ನಡುವೆ ಪ್ರೀತಿ ಬೆಳೆಯಿತು.
ಎಲ್ಲಿ
first 2 lines of the complaint, my lord.
Page 12, para 3.
Para 2.
ಪರಿಶೀಲನೆ ಪಡೆದು.
Page number 12 is complaint, my lord.
Page 12.
12.
ನಾನು 112 ನೋಡ್ತಾ ಇದ್ದೆ.
No, my lord. Page number 12.
That's. Yes, so and so. The second respondent is the complainant. The complainant and the petitioner are said to have become friends close to 3 years prior to the registration of the complaint. The friendship appears to have blossomed into relationship, and the relationship getting physical as well. The relationship, as observed here and above, travels for 2.5 years. On the pretext of promise of marriage is the allegation in the complaint. When the accused, when the complainant receives the information that the accused is wanting to marry someone else, registers the crime registers a complaint before the jurisdictional police on 8/9/2023. 8/9/2023, alleging that the petitioner has indulged in the ingredients of 376(2)(n) repeated rape of the complainant on the score of promise of marriage. The promise of marriage. The police conduct investigation upon the said complaint and file a charge sheet. After filing of the charge sheet, the matter is committed to the Court of Session and now presently pending as SC 15 of 2023. The petitioner accused is before the court.
24.
24. The petitioner accused is before the court calling in question the entire proceedings before the concerned court. The learned counsel appearing for the petitioner Avinash Angadi would vehemently contend that the petitioner that the acts between the petitioner and the complainant for over 2.5 years were consensual but never on the promise of marriage. Was on promise of marriage, was though on promise of marriage, it was not false promise of marriage. ಯಾಕೆ ಒಪ್ಲಿಲ್ಲ?
Lord, she had another relationship with my lord, another boy.
ಹೌದಾ? How do you demonstrate that? ಸುಮ್ಮನೆ ನಿಮ್ಮ ಊಹಾಪೋಹಗಳೆಲ್ಲ ಹೇಳ್ಬೇಡಿ. ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್?
ಅದರಲ್ಲಿ ಇಲ್ಲ ಸರ್.
ಮತ್ತೆ?
They only say it was on the pretext.
Yes. The No, because we'll have to answer it whether it was false or not, then we'll have to correctly tell. Because there are two different things, promise of marriage and false promise of marriage.
Here it is only a promise of marriage.
How? Sir,
Allegations in the
promise of
complaint.
marriage ಯಾವಾಗ false ಆಗಲ್ಲ ಅಂದ್ರೆ efforts of marriage have taken place and failed. Then it becomes promise of marriage. Otherwise, promise of marriage becomes false ex facie. ಇಲ್ಲೇನು?
But in this case, my lord, she only alleges that on 8/9/2020.
She may allege, sir. You said there was promise of marriage.
My lord, here, my lord, as per the contents, my lord, we do admit that he was in relationship with that girl, my lord.
Relationship, all right. Whether it was on promise of marriage or not.
Promise was there.
Because Supreme Court says that if you wanted to quench your thirst of lust and have projected that you would marry the lady and then have not married, then it becomes a false promise of marriage. Adike, promise of marriage, see the line of judgments, Naim Ahmad, all those Supreme Court says that it is taken, marriage talks fail, then yes, it is not false promise of marriage. But 2.5 years is too long a period, that's a different thing. You should draw your line of argument like that.
But in this, my lord, there is no such allegations, my lord. She only says that she was repeatedly raped, my lord, in another context. On 8/9/2023, she says that, my lord, when she had gone outside, he has committed a rape.
Gone outside?
ಅಂದ್ರೆ ಹೊರಗಡೆ ರಾತ್ರಿ ಹೋದಾಗ ರೇಪ್ ಮಾಡಿದ್ರು ಅಂತ ಅಲಿಗೇಷನ್. Other than that, my lord, there is no such allegation.
Statement when the man goes outside, rape ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಅವರು
ಆಚೆ ಕಡೆ ಹೋದಾಗ ಅಂತ ಹೇಳಿ. Yes.
ಹೊರಗಡೆ ಹೋದಾಗ ಈ ತರ ಮಾಡಿದ್ರು ಅಂತ. Except that, my lord, there is nothing more.
Yes, sir. Madam, ಪೂರ್ತಿ ನೀವೇ ಬರ್ಕೊಂಡ್ರೆ ಹಂಗೆ. Sir. Yes. The ಎಲ್ಲಿದ್ದೆ? I would vehemently contend that the allegation of false promise of marriage is contrary to the facts. The marriage, though, did not take place at a later point in time, owing to several factors, one of which the learned counsel would contend that the complainant had an affair with someone else, inter alia. The marriage could not take place, but the consensual acts did go on for over 2.5 years. The learned counsel would further submit that the other offences alleged also would not merit any consideration on such consensual acts. The learned AGA would vehemently refute the submission in contending that the petitioner, in contending that the police after investigation have filed a charge sheet and therefore the petitioner should come out clean. Therefore, the petitioner should come out clean. He would further contend that the offence is of repeated rape and therefore this court should not entertain the petition and obliterate the proceedings on the say of the petitioner. I have given my source. The aforenarrated facts are a matter of record. Since the entire issue has now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 12 and 13. The complainant in the complaint narrates that she became friends with the present petitioner 2.5 years ago on the date of registration of the complaint, and the acts between the two went on for close to 2.5 years. When the petitioner wanted to get married to someone else, the offense has sprung that the petitioner has indulged in the ingredients of section 376(2)(n) for over 2.5 years. Therefore, the 2.5 years. It is thus the crime comes to be registered in crime number 272 of 2023. The police, after investigation, have filed a charge sheet. They filed a charge sheet. The matter is now pending after committal as in SC 15 of 2024. The charge sheet is filed for two offences. One 376(2)(n) and the other 506 of the IPC. Section 376(2)(n) and 506 of the IPC in such circumstances have borne consideration by the apex court in plethora of judgments. All of which and plethora of judgments, I deem it appropriate to quote a few. The apex 9.1 ಇಂದ ಕೊನೆವರೆಗೂ. In the light of the issue standing completely covered by the judgments rendered by the apex court till the judgment, till its latest judgment in 2025 SCC online SC page 1230 in the case of Amol Bhagwan versus State of Maharashtra, I deem it appropriate that the court deem it appropriate not to permit further proceedings to continue against the petitioner and obliterate the proceedings in SC 15 of 2024, failing which it would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, allowed cost.
Obliged.
Yes.
Obliged.
Number 150, Ravi Hegde.
My lord,
ನೀವು ರವಿ ಹೆಗ್ಡೆನಾ?
I am also filing wakalat. Ravi Hegde instead along with me on AR Patil.
Oh, sorry.
My lord,
150 na?
and 3 minor children, wife, mother, equal
Oh,
share
ಇದು apportionment.
apportionment. ಅದರಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ಕೊಡ್ಲಿಲ್ಲ. Kindly
But
we.
dispute is between my lords, the petitioner, the respondent.
ಅಲ್ಲ ಅವಳಿಗೆ 70 years ಆಗಿದೆ, ಇನ್ನೂ 3 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ ಅವ್ರಿಗೆ ನೋಡ್ಕೊಳಿಕ್ಕೆ. ಇವಳು ಪಾಪ ವೈಫಿಗೆ
ಅಲ್ಲ ಇವ್ರಿಗೆ ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ ಮಾಡ್ತಾರೆ. ಬಟ್ ಈಗ ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಕೊಟ್ಟಿದೆ ಸರ್?
ಅಲ್ಲ ತಾಯಿಗೆ ಮತ್ತು ಹೆಂಡತಿಗೆ ಈಕ್ವಲ್ ಕೊಟ್ಟಿದೆ, ಮಕ್ಕಳದ್ ಬಿಟ್ಟು ತಾವು ಮಾಡಲಿಲ್ಲ.
ಅಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದೆ?
50% ತಾಯಿಗೆ ಮತ್ತು ಹೆಂಡತಿಗೆ ಅಷ್ಟೇ ಮಾಡಿದೆ. ಮಕ್ಕಳಿಗೆ ಯಾರು
ಎಷ್ಟು ಕೊಟ್ಟಿದೆ?
50% ಕೊಟ್ಟು.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು?
ಅಲ್ಲ ಮಕ್ಕಳಿಗೆ ಇಲ್ಲ, ಅವ್ರ ಮಕ್ಕಳು ಇನ್ನೂ ಮೈನರ್ ಇದ್ದಾರೆ. ಹೆಂಡತಿಗೆ ಇನ್ನು 45 ವರ್ಷ.
ಏನ್ ಕೊಡ್ಬೇಕು?
ಅಲ್ಲ ಎಲ್ಲರಿಗೂ ಈಕ್ವಲ್ ಮಾಡಿಬಿಟ್ರೆ ಅನುಕೂಲ ಆಗ್ತದೆ.
ಮದರ್ಗೆ ಬೇಡವಾ?
ಮದರ್ಗೆ ಕೊಡುದು ನಾ ಬೇಡ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
ಮತ್ತೆ
ಈಕ್ವಲ್ ಮಾಡಿಬಿಟ್ರೆ 5 ಶೇರ್ ಮಾಡಿಬಿಟ್ರೆ 5 shares. ಈಗ ಅವಳಿಗೆ ಪಾಪ ಇನ್ನು 45 ವರ್ಷ, ಅವ್ರಿಗೆ 70 ವರ್ಷ, ಇನ್ನು ಅವಳಿಗೆ ಬೇರೆ ಮಕ್ಕಳಿದ್ದಾರೆ ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೆ. ಇವಳು ಹೆಂಡತಿಗೆ
No, of course, wife and children should get more, no doubt about it. Mother also should not.
She should also get my lords because
We'll make it 75% to the wife and children, 25% to the mother. But in the review petition.
Review petition.
My lord,
the written
limits of
labor court ನಲ್ಲಿ ಅದು ಚಾಲನೆ ಮಾಡಿದ್ದು at the time of the honorable court page number 9. ಆ KSRTC ಅವರು ಅಪೀಲ್ ಮಾಡಿದ್ರು. ಆ ಕೇಸಿನ ಲಾಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 13 ದಲ್ಲಿ ಒಂದು sentence is in future litigation workman including the mother would submit that no word of any unnecessary litigation in the future. ಆ ಒಂದು ವಿಷಯದಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಫ್ಯೂಚರ್ ಮೇಂಟೈನ್ ಆಗಬಾರ್ದು ಅಂತ ಒಂದು ಉದ್ದೇಶದ ಅಷ್ಟೇ ಅಲಾಟ್ಮೆಂಟ್.
ರಿವ್ಯೂ ಅಲ್ಲಿ ಕಷ್ಟ ಮಾಡೋದು. ಬಟ್ ಯಾವ ಮೂಡಿದೆ ಬೇರೆ ಮಾಡಕ್ಕೆ?
ಪ್ಲೀಸ್
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಒಳ್ಳೇದಲ್ಲ ರಿವ್ಯೂಗಿಂತ.
In the writ petition itself, my lords, they have to file some order.
Better.
But the other side should also agree for that.
ಅಲ್ಲ ಅಗ್ರಿ ಅಂತ ಪ್ರಶ್ನೆ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ಸ್
ಎಲ್ಲರೂ ಅಗ್ರಿ ಆದ್ರೆ ಮಾತ್ರ. ಅವ್ರು ಕೇಳ್ದೆ ಹೆಂಗ್ ಆರ್ಡರ್ ಮಾಡೋದು?
ಬಂದಿದ್ರು ಮುಂಜಾನೆ ಬಂದಿದ್ರು, ಬರ್ಲಿಲ್ಲ.
ಮುಂಜಾನೆ ಬಂದಿದ್ರ?
ಬಂದಿದ್ರು.
ನಾಳೆ ಮುಂಜಾನೆ ತಗೊಂಡ್ಬಿಡ್ರಿ.
ನಾಳೆ ಬೇಡ, 2 ದಿವಸ
ನಾಡಿದ್ದು ಬೇಡ, ನಾಡಿದ್ದು ತಗೊಳ್ಳು. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮುಂಜಾನೆಗೆ ಹಾಕಿ. Why is Shabad sir waiting?
Lords, 256, my lord, the lordships are directed to keep the officer present, secretary. Suspension order.
2:30 gitta?
But the petitioner is in the interregnum period.
Filing affidavit ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರೆ ಹಾಕಿದೀವಿ.
1 minute.
Suspension order was passed on 19/12/22.
1 minute.
I'm filing wakalat for respondent number 1 and 2, my lord.
The date of suspension is 19/12/2022.
His grievance is that we have not paid subsistence allowance and not continued.
Grievance ಬೇರೆ?
ಅಲ್ಲ, it's continued now, my lord.
What is continued?
Suspension order is continued.
Substance allowance ಕೊಟ್ಟಿಲ್ವಾ?
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ. ಕೊಟ್ಟಿದ್ದೀವಿ, and you lost me kindly take
Affidavit ಕೊಡಿ.
ಅವ್ರಿಗೆ ಕೊಟ್ರಿ. Up to date, my lord, suspension allowance is paid. Page number 9 is the document, my lord, statement showing the payment of suspension allowance. Lord, the matter pertains to, my lord, the illegal payment of 20 crore rupees while discussing, my lord, the compensation amount. CID has filed a charge sheet in this case. Lokayukta is also investigating, and we have also initiated, my lord, the DE against him. And, my lord, to the Shokas notice, so far he has not submitted any response at all. So, my lord, 20
Suspension
crores.
Suspension was in the, on 19/12/2022. We are in the year 2025, my lord. So even after lapse of 4 years, my lord, not even a single Shokas notice.
For what?
No, departmental inquiry. Departmental inquiry is not conducted. This is the exact reason why Ajay Kumar Chaudhary's case that is answered. After that, I am eligible for, my lord, revocation, deemed revocation under Rule 10, my lord, after 6 months.
Departmental inquiry ಯಾವಾಗ ಮಾಡಿದ್ರು?
ಇಲ್ಲ ಮಾಡೇ ಇಲ್ಲ ಇನ್ನು. There is no pending departmental inquiry.
Page number 16 of my affidavit, your lordship may kindly take. He has not responded to that.
Page number?
16, index page 16, my lord. This is the Shokas notice that was issued to him on 29/3/2025.
But this is with respect to different.
1 minute, 1 minute.
Yes.
ಯಾವ್ದು ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
Charge sheet, my lord, in fact.
9/3/25.
Yes, yes.
ಇದು ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ?
ಇಲ್ಲ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದೆ. ಎಲ್ಲ ಇವರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ.
ನಿಮ್ಮ ಮೇಲೆ ಎಷ್ಟು ಕೇಸ್ ಇದೆ?
Lord, I was after this, my lord, I was instructed that there is one more case pending. With respect to that, this Shokas notice is issued. And my lord, 2022 to 2025, nothing, my lord. Even this is not a charge sheet. This is a notice.
ಏನ್ ನೋಟಿಸ್? ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್.
ನೋಟಿಸ್.
ಸರ್, ಅನುಬಂಧ ಎಲ್ಲ ಇದೆ. ಸ್ಟೇಟ್
ಅನುಬಂಧ
ಗವರ್ಮೆಂಟ್
ಇದೆ,
ಕರೆಯೋದೇ ಹಂಗೆ. ಕಾರಣ ಕೇಳು ನೋಟಿಸ್ ಅಂತಾನೆ ಕರೆಯೋದು. ಅದಕ್ಕೆ ಅನುಬಂಧ ಇದ್ರೆ ಅದು ಚಾರ್ಜ್ ಶೀಟ್.
But this is not with respect to this. Lord, under Rule 10, my lord, there is a deemed revocation.
Deemed revocation.
My lord knows it. Exactly, this is what answered in
it is continued because of these serious charges, my lord.
ಆಯ್ತು, ಸೀರಿಯಸ್ ಚಾರ್ಜಸ್ ಡಿ ಮಾಡಬಾರದು ಅಂತಿದ್ಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಬಾರದು.
If he is, my lord, taken back, my lord, there will be so many, my lord, repercussions, because, my lord, in Dharwad Zonal Office, he was working from 2004 to 2022. When ಅಷ್ಟೊಂದು ವರ್ಷ ಇದ್ದಾರೆ, and in respect of, my lord, every, my lord, irregularity, his name, my lord, is at serial number 1 only. My lord, you lordship may kindly see the inspection report, which, my lord, discloses this. Kindly take, my lord, writ petition, page number 26, index page. ಎರಡನೇ ಬಾರಿ ಪರಿಹಾರ ಪಾವತಿ ಮಾಡಿದ ಸಿಬ್ಬಂದಿ ಅಧಿಕಾರಿ ಹಾಗೂ ಇತರೆ ಮಾಹಿತಿ. Serial number 1 ನಲ್ಲಿ 3 crores 53.
Lord, one more submission. Co-accused, my lord, had approached KAT against departmental inquiry. That is also cost.
He was a deputation employee, government service, state
Lord,
government.
co-accused annexure H, my lord, I have produced. Now they cannot come out of this Rule 10, my lord. That's what my submission is.
Let's see, anyway, affidavit has come. We'll pass some order. ಮತ್ತೆ ಯಾವಾಗ ಬರ್ತೀರಾ ನೀವು?
I'm filing wakalat for respondent number 1 and 2, my lord.
Land council so and so enters appearance for respondents 1 and 2, registered to print the name of so and so appearing for respondent 1 and 2.
Any date, your lordship.
We'll take it.
24th on matter.
We'll take it on 24th. List the matter on 24th.
House.
24th November.
Our affidavit may be taken on record.
The learned senior counsel Baswanath Sabrad appearing for the respondent files an affidavit of.
I'm not the joint director, my lord.
Of the joint director, the same is taken on record in compliance with the order passed by this court earlier. I would have passed an order, but for you being the most decorated officer.
If it can be taken in fresh matters, my
Fresh
lord.
matters, that will, fresh matters.
Please.
You would have allowed it today, or disposed it today rather. But for the allegations.
But whatever the allegations might be, but they cannot come out of Rule 10.
We'll see.
Yes.
Great.
Now that the charge sheet is issued, don't worry, I will come out of it. Yes.
257, Srinande Pachapuri.
257. Srinath, there's a meeting at 5:15. I have to leave with the Chief Justice. ಮತ್ತೆ ಬಿಟ್ಟಿದೆ ಈಗ. Otherwise B group is there. ಈ B group ಎಲ್ಲ ಇನ್ನೊಂದ್ ದಿನ ಹಾಕ್ತೀನಿ. About 40 matters ಇದೆ. ಯಾವತ್ತು ಹಾಕ್ಬೇಕು ಹಾಕ್ಬಿಡಿ. ಅದ್ರಲ್ಲಿ entry models ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ. ಏನು?
Serial number 230.
230 da?
Serial number 230.
Serial number 230 ಏನು?
It may be taken up in preliminary hearing, my lords. This is third time the inquiry is initiated against this petitioner.
B group ಅಲ್ಲಿ ಏನಿದೆ? Up to 2022 ಇದ್ರೆ ಅದು ಹಂಗೆ ಇರಲಿ. 22 ಮೇಲಿಂದ preliminary hearing ಹಾಕ್ಬಿಡಿ. All beyond 2022 matters, put them in preliminary hearing. ನಿಮ್ದು ಯಾವ ವರ್ಷ?
2022.
2022 and above, put them in preliminary hearing. Up to 2021, let it be in B group, we'll do it.
Great.
Yes.
Number 244, my lord, kindly.
Two ಅಷ್ಟೇ sir.
And ನಾಡಿದ್ದು urgency ಇದೆ. Out of 15 members of executive committee, 14 have withdrawn their confidence against the petitioner hearing, who acts to be the chairman of a particular society.
Appear for the petitioner in that matter. It may be taken Thursday, my lords.
Thursday ನಂಗಾಗಲ್ಲ. Wednesday ನಿಮ್ senior ಹೇಳಿದ್ರ? ಬುಧವಾರ.
You should first ask
yes
whether he is in Delhi or Bangalore. ಆಮೇಲೆ ಕೇಳಬೇಕು date.
Sir, Wednesday in fresh matter list.
Wednesday.
Please, my lord. In fresh matter list.
There is an interim order, my lords.
Interim order will continue.
Great.
I will.
But 227. Until question they got 7th.
Huh?
227. 7th.
ಒಂದು ನಿಮಿಷ ಕೊಡಿ. 227 7th. Why urgency ಏನು?
The petitioner was serving in the respondent number 1 bank, my lord. He was terminated without having a strong evidence, my lord. So I kindly request.
Terminated. We'll see. We'll post it another day, not on 7th. Termination urgency illa, next week ಹಾಕೋಣ.
My lord, serial number 241, my lords. 2 weeks time may be granted to file objection.
Lords, in that I am petitioner, my lords. From appointment till 2009, my lords, till today I am paying only consolidated salary, my lords. Actual pay scale has been
Objection ಹಾಕ್ಲಿ.
Monday, my lords.
ಅಷ್ಟರಲ್ಲಿ ಹಾಕ್ತಾರಾ? ನೀವೇ ಈ ಕಡೆ ಇದ್ರೆ ಹಾಕ್ತಾ ಇದ್ರ ಅಷ್ಟರಲ್ಲಿ? ಇಲ್ಲ ತಾನೆ? We'll fix a date commencing, week commencing from 24th November, all these matters. Yes, why?
Covered, my lords. It is regarding electro-homeopathy, my lords.
Oh, correct.
My lord's judgment.
ನಾಳೆ ಹಾಕಿ ನಾಳೆ ಆಗುತ್ತಾ ಮೇಡಮ್? Tomorrow.
Yes, ma'am.
Because covered.
Yes, my lords.
ಎಲೆಕ್ಟ್ರೋ ಹೋಮಿಯೋಪತಿ
Yes.
ಕೊಡಿ. ಅದು ಕೊಟ್ಟಿರಿ, ಆ ಫೈಲ್ಗೆ ಇಟ್ಬಿಡಿ.
Yes.
Yes.
242.
In fresh
242.
Fresh
Seriously, will come.
242, sir. Madam.
ನೀವು 14%.
Yes.
Petitioner.
Parting.
ಅದು ನಾಳೆಗೆ ಆಗುತ್ತಾ?
Yes.
ನಾಳೆ ಹಾಕಿ.
Aship, 234. I am for respondent number 1. Kindly allow this writ petition, my lord.
Tomorrow.
Please.
234. Tomorrow fresh matters ಲಾಕಿ.
234, yes. 234.
14% ವೈಭವಿ ಎಲ್ಲರದು ನಾಳೆ ಬೆಳಗ್ಗೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಾಕಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಡ.
In this case, my lords, they have imposed 1 lakh rupees of cost.
Which one, madam?
251, my lords. Additional one. Yes.
See tomorrow. ಕಮ್ಮಿ ಆಯ್ತಲ್ಲ? Monday starts.
ಇಲ್ಲೇ ಇರ್ತಿಲ್ಲ ಇವಾಗ ಡೇಟ್ ಹಾಕ್ಸ್ಬಿಡ 202 207 10ನೇ ತಾರೀಕು 41 52 10ನೇ ತಾರೀಕು ಸರ್ 41 ಅವ್ರ 2 ವೀಕ್ಸ್ ಅಂದಾರೆ 2 ವೀಕ್ಸ್ ಅಂದ್ರೆ ಒಂದು ಮಂಡೇನ ಇದೇನು
242